morning, everybody. It's really early today. But welcome back. Had a little chaotic end to things yesterday. Very sorry about that. Get off the stream and wonder, like, is the world blowing up or something? Did somebody bomb Google? I don't know. I guess I probably shouldn't say that in the first few minutes of the stream, but we did get those last few super chats from yesterday that we weren't able to get to. We got those saved, so we'll hit those when it's time today, folks. But boy, here we are. Here we are. Here we are. It's day 33, and we really are at the end of the road, aren't we? We're right at the end of the road. Nothing left to do but sum it all up and hand it over to the jury. I know many of you saw the very, very fast not guilty that Turtle Boy got yesterday in his case. Very fast not guilty. Now, granted, it's not the same thing. It's from a judge, not from a jury. But it sure does. It sure does shift my perspective, I guess, on the range of what's possible. I've been telling you, I've been very afraid to hope for a quick guilty verdict, or not guilty, a quick not guilty verdict. I'm afraid to hope for that. I'm too concerned about shenanigans. I think there's just been too much cause for concern about shenanigans and not enough basis to trust this court, trust this institution, trust its integrity. We already know the law enforcement, no trust. The prosecution, no trust. The court is pretty clearly chosen her side. So why am I going to have trust if you're going to side with the untrustworthy? So I'm very afraid to hope for a fast verdict. But seeing that yesterday with Turtle Boy does remind me sometimes, sometimes things really are obvious. And just because it seems like it to you, it's not necessarily because you're biased. It's just, in fact, because it is really obvious. Part of the challenge here is because I left the jury instructions conference yesterday, that absolute waste of time of a hearing that we had. And I'm still very unclear on the status of lesser included offenses. If any are being requested, and if so, which ones? It's clear to me the Commonwealth isn't requesting them, but it seems like maybe the defense is. Very confusing, but I'll tell you what, it did cross my mind. Certainly a viable defense strategy I think they could pursue here is, go ahead and ask for the lesser included on operating under the influence. Because then you can just tell the jury, look, no one's disputing she did that. Go ahead, find her guilty of that. But all the rest of this stuff, there's no collision. There's no collision. It's a really good way to invite the jury to do the compromise. Pretty good compromise for Karen Reed, DUI. It's not a bad position to walk out of the courtroom. But it lets them do something. It lets them feel like, even if she did do something wrong, it's a minor thing. She's not walking away scot-free. She's not trying to evade responsibility. She'll step up and take responsibility for what she actually did. But the problem here is there's no collision. So trying to find her guilty of the graders wouldn't necessarily make a lot of sense. I was thinking about that as a proposed compromise. And I'll tell you, it's not a bad one. It's really not a bad one. And it does, I think, put them in the position where it could that could make for a real easy resolution, couldn't it? You just cut through and avoid all of that conflict and concern over, well, but she's not perfect. She did something. She's just gonna walk away scot-free. A lot of drunk driving that night. No, I don't know that it would necessarily be fair that Karen be singled out as, the only person who would walk away with any kind of consequence for that, and, only because she's been the subject of a frame job. But, it's just not a bad position. It's a really, really good offer for the jury. Look, just give her the DUI and go home. Have yourselves a weekend. Have yourselves a summer. I could see that. I could see that as a defense strategy. So I'm waiting patiently to see if we get clarification on whether there are any lessers, what they are. If so, that'll I think give us a little bit more insight into what they're thinking about. But I could see that did make sense as I kind of sat and thought that through. Like, why would the defense be requesting lessers anyway? It seems like a pretty obvious all or nothing case. Otherwise, if there's no collision, there's no crime. But they do have that little OUI. We want to offer them something to say, yeah, she did that. She just didn't do all this other stuff. It's been a lot of days, guys. I went through and got at least kind of the breakdown of who the witnesses were and what day they were on and so forth, just so I've got at least like a visual picture of this trial. Because, guys, it's been so long. It's hard to remember that this trial had already started when we were doing like the Arc of Voir dire and stuff. You guys remember that? That was day 5. That was day 5. That was all the way back in April. Beginning of the trial, we had him in for that voir dire. And we saw how Hank treated them. And we're like, oh, there's no way he'd do that in front of the jury. And Hank's like, hold my beer. It turns out he is perfectly willing. Perfectly. What naive children we were back on day 5. Thinking, oh, no way would an attorney behave like that in front of a jury. All that time later, we saw that, nope, in fact, God, it was back in April. It was the trial had already started when we have that finding of the repeated willful discovery violations. Like, really? Really? When was that? When did that happen? Because I remember Hank freaking out about candor to the tribunal, but repeated willful discovery violations with ARCA, very, very questionable. Part of the reason why I did it is because I was trying to. We had that question yesterday in the super chats about the defense witnesses, because we'd gone through and done kind of a summary of all of the Commonwealth's witnesses when they rested. Someone wanted to know, can I do that with the defense witnesses? I'm like, I can't really, because I'm so behind in getting my notes up to speed. And but we had the little outline that we got from Mr. Yanetti making his argument on the motion for the not guilty finding. And I realized, because Mr. Yanetti didn't mention it, but we also forgot one, didn't we? We forgot about Kelly Dever. We forgot about Kelly Dever. She wasn't the most important, influential witness, anything like that. But she sure did make an impression. Holy cow. She sure did make an impression. Couldn't have made it clearer. Her testimony, her job depends on her testimony and what she saw in that Sally Port and so forth. So got at least a little bit of an outline now to have me reminded who we saw the days we saw him. Made me forget. God, all the long. We had 3 days of Jen McCabe. We had 3 days of Yuri Buchanan. We had 3 days of Judd Welcher, guys. Look back on it, and it's like some of it's just been blocked a little bit. Didn't necessarily need to remember that. But here we are. We're at the end of the road. And now it's just all taking what we've learned and painting the picture and comparing the picture that we have today to the picture we had on day one before we knew anything at all and just the introduction from the attorneys. We'll see how that's going to play. How that's going to play. How did your opening statement commitments? How did they end up? You know, I remembered going back and taking a little look back at that opening statement that we got. That Mr. Brennan, he is a good storyteller. He tells a good story. I'm just not sure he told the right story. When he started his opening, he told the story of Timothy Nuttall. Remember that? Arriving at the scene, and then the doors open, and it's chaos, and the swirling snow, and the screaming women. He can paint quite a picture, but just not clear that he was painting the right picture, because at the end of the day, turns out the trial wasn't about Timothy Nuttall. And at the end of the day, not sure Timothy Nuttall really mattered all that much, but gave Brennan what was ultimately and probably will continue to be his most important fact here. I hit him. That's what he wanted to get in. And remember how he brings us up. He's telling the story. Not only he's coming out of the ambulance into the chaos, snow swirling. Defendant approaches him, and then what happens next? You'll hear her words. I hit him. She admitted what she did that night. She admitted it, guys. Now, Mr. Nuttall ignored it because it didn't mean anything to him, because it wasn't congruent with the injuries he saw. Remember that? Even all the way back in opening, we already know the injuries don't fit. Even all the way back in Hank Brennan's opening, we already knew the injuries didn't fit. He told us himself. Nuttall ignored what she said because it didn't matter, because he wasn't hit by a car. Imagine having this as the defense. Wouldn't it be funny if you could play the clips back from opening? Be like, how, ladies and gentlemen of the jury, how did that age? How did that age? This part aged very well, with the part where Timothy Nuttall ignored it because it didn't mean anything to him, because it wasn't congruent with the injuries. And here we are 33 days later, and we've had Dr. LaPosada and Dr. Rentschler tell you all this other stuff. It doesn't matter because there wasn't a collision. So we have actually ended up where we started, the very same place. And the prosecutor knew from the very beginning. Wouldn't that be fun if we could do that? Under John is grass. It's hard, frozen ground with his cell phone underneath him. And then we turn, though, to the facts, science, and data. We're here today because John O'Keefe was killed by the actions and conduct of Karen Reed, and the facts, science, and data are going to show. When they were out in front of 34 Fairview, John got out of the car. He stood by the side of the car after an argument with the defendant. The defendant drove away at least 35 feet, then stopped, then put the Lexus into neutral and waited, then put the Lexus in reverse, pushed the pedal to 75% acceleration, went backward at least 70 feet, clipped him. He fell and he hit his skull, and she left him on the ground on top of his cell phone. That was the story that he said the facts, science, and data were going to show. Said it was going to show a clip, and that was always going to be the problem. Always going to be the problem with his case. Timothy Nuttall ignored what she said because injuries didn't fit. But facts, science, and data are going to prove that she clipped him with the car. See how well that ages. Then we get the background. John, he was a local kid. This is like one of the very few occasions we even heard about John O'Keefe in this trial. Anybody notice that? For a trial about John O'Keefe, we almost never heard about John O'Keefe. It's been a long time. Long time since we heard anything about John. Had to hear, his background. Local kid, Boston police, took in his sister's kids. Enter Karen Reed. And then they got reacquainted around COVID, and they were pretty good in their relationship until the beginning of 2022, and then things began to unravel. There was tension, there were arguments, and a few days before the incident, he asked her to leave, and she didn't. And there will be messages, discord, the beginning of the end of the relationship. Not according to Karina Kolakithis, and really not according to Mike Camerano either. But we did see they were arguing that morning on the texts. The cell phone. Hank is going to continue to hang his hat on the cell phone because it's really all that they have. That's what he talked about next. It's an amazing piece of tech, and they studied it. There's remarkable data in it. The location data from Waze. It's like a breadcrumb. The strongest and most accurate location data that Waze. Then the health data that shows movement, except when you don't want it to. Except when you want steps to not be steps and flights to not be flights. Then it doesn't. But when it's just stops moving, that's John dead, not the phone just not moving because, maybe it got put down or something. And then the temperature of the cell phone battery is going to be critical to your analysis. Critical because Ian Whiffen put that phone in a freezer, and we learned that the phone battery gets cold if it's in a freezer. I am curious to see if that gets touched. If the cell phone is such an important part of the data and the battery temp, he's really fixated on that battery temp. You, the jury, has brought it up many times, brought it up with lots of different witnesses. But how's he gonna tie that in? I don't think he's concerned about that. It's almost like he could just say something happened to the battery, jury, and that proves that Karen hit him with the car, left him outside. I don't know that there's any way to really analyze that, tie that in with the evidence about what's it mean? What's this data mean? It was supposed to be Ian Whiffen's job to kind of be able to demonstrate for us the meaning of the cell phone battery temp changing, but we didn't get that. So I suspect it's just going to be more Ipsy Dixit. The battery got cold, therefore. We'll see. Then we shifted to the story of the evening. They decided to meet at McCarthy's. 8 vodka drinks she drank, 7 in 2 hours. Walked to the waterfall, at least 8 in 3 hours. Then there's info on the Lexus chips on the black box. And that, together with the cell phone data, will tell you everything you need to know. Don't pay attention to the injuries. That'll be a problem. But the phone and the Lexus chips, he's told us That's his focus. That's what they're going to focus on. It's going to tell us everything we need to know. We'll see if that holds up. I kind of suspect it will, but we'll see. So they leave the waterfall at 12:12. The car goes on to 34 Fairview. You can follow it. They can follow it on the location data. They get lost on the way to Fairview, and John calls Jen. And guess what, guys? It's near Bella's mom's house, and John had dated Bella's mom before. Important enough to mention that in opening. Bella's mom. So the acceleration triggered a black box in the Lexus during a 3-point turn. So remember we got a trigger event from doing an ordinary 3-point turn, the same trigger event that we later got according to the Commonwealth from, speeding up and running into John. Doesn't quite fit, does it? Same trigger event from doing what is by all indication a perfectly normal 3-point turn. Almost like maybe it had something to do with the conditions outside or something. Then we have the truck coming the other way that saw the lights on the car. There's a man and a woman inside. They followed. The Lexus slowly went to the corner, and they got there at 12:34:33, he says. That doesn't fit at all, does it? It doesn't fit at all. It did not take you 9 minutes to get from when we saw it on that video with Lucky Loughran on the stand. Cedar Crest is like right there. It did not take 9 minutes to get there. But here we are, 12:27. The text from Jen, parked behind me, 12:29. He's coming inside. Jen looks out the window and sees the Lexus. John's healthcare data shows he doesn't move until 12:31:56, a whole 20 seconds before he falls. He looks at his text at 12:32:09, moves for 7 more seconds before lying dormant. So that was the timeline that we got in Hank's opening. And the black box shows at that time the car leaves, then shoots in reverse with the tires spinning. And she told the firefighter she was sad because their last moments were fighting. But then later she said he didn't look mortally wounded. That was that clip that's taken so out of context. You found him the next morning. Clearly what you're talking about. But he's really hanging on his hat on that clip to try to argue she was saying that night she saw him and he didn't seem mortally wounded. By 12:37, at 12:37, the battery temp is 77 degrees, and then it drops to 72 after 5 minutes by 12:42. Almost like the difference between being out in a car with the heater blasting and going inside. Maybe kind of like that. Then by 12:45, the battery temp is down to 61. Colder, colder, colder. But by 12:53, it's only 60. So we reach that plateau. Karen's calling, 40 calls from her that night that he never answers. 12:59, she leaves a message, nobody knows where you are. And that's when, according to Hank, the Darvo prosecution, the cover-up began. That's when the cover-up began, guys. It's Karen doing a cover-up. No, you're doing a cover-up. Not me. It's you. 50 degrees battery temp by 1:14. Almost like by now the car is the phone has started to move outside, moved somewhere a little chillier. We still out in that cold garage. Karen's healthcare data then shows it stops because she fell asleep. But at 5 a.m., she wakes up frantic. She's unintelligible. She calls Jen. She asks Kaylee to call Jen. Jen wakes up. She hears, Jen, John's dead. She says, I left him at the waterfall. Jen says, we saw you out front. I don't recall that this happened in the phone call, but that's what Hank said in the opening. Karen calls Carrie Roberts, says she thinks John was hit by a plow. Carrie calls 911. She calls the hospital. She tells Karen, come to my house. I'll help you look. Karen says, I was so drunk last night. I don't remember anything. Carrie parks behind Karen's car at Jen's, sees the taillight broken. A lot of very heavy reliance on Carrie Roberts in the opening. In her version, she's in charge of everything that morning. They get close to the scene. There he is, Karen screams, but they don't see anything. They don't see anything at all. How did Karen know he was there? They didn't see anything. So then they find John. They start to move him, and the phone drops to 40 degrees, 37 degrees at 6:02, something like that. This is the theory. I wonder if Hank has worked on his timeline at all. Is he maybe going to refine his timeline a little bit for his closing? So they lift him, and then Carrie puts the phone in her pocket, and at that point it starts to warm. Police find some blood spots. They go and get some plastic containers. And then they worked to uncover the snow around his body, but they found very little. Indeed they did. In fact, they found the broken glass, and that was it. And the blood spots on top of the snow where they really don't belong. Then we shift to the hospital. Karen's there. Peggy O'Keefe is saying that she was screaming, is he dead? Is he dead? She says, Karen, what happened? And Karen doesn't say a word. Then CPD pulls in to check on the kids, and they see the taillight has a big missing piece. Well, of course they didn't. In fact, Ray testified he didn't even notice. He didn't even pay attention. It just happened to get caught on his dash cam, and apparently it wasn't significant to anybody until later. So then Karen and the father show up at One Meadows. They ask to go upstairs to John's room. They're up there for 15 minutes, and then they leave. And then they begin to learn, the family begins to learn, or police begin to learn she had hit him. That's it. That's the explanation of the investigation. They began to learn she had hit him. Stick with that. Stick with that in the closing, Hank. They began to learn she had hit him. So they decided to get a warrant for the Lexus. Well, that took a minute, didn't it? Because they had to go seize the Lexus first. They didn't have a warrant when they went and seized it. Took them a minute. So they spoke briefly to Karen. They brought the car back from Canton. Broken taillight was littered around John O'Keefe's body. The shoe was found on the berm next to the street. The hat was frozen to the ground. And then over 10 days, they found almost every piece of broken taillight in that area, as if that's not suspicious. As if that's not suspicious. Found almost every piece of broken taillight after 10 days. How many times did the plows go by? But somehow all the taillight ended up on the grass. It didn't end up in the street, except for the small little 1 foot square area where the CERT found stuff. And on the back of the Lexus around the taillight was John's DNA and one last piece of John's hair stuck to the side. It's a very dramatic story that Hank told. So John fell back and hit his head after being clipped by the car. He sustained a basal skull fracture that created a contrecoup injury because there was just a dusting of snow on the rock-hard ground at that time. But also Judd Welcher will explain how the black box data coincides with the cell phone data. Really? Because he didn't do that, did he? He didn't talk about any of those things because they have nothing to do with biomechanics or accident reconstruction. But that's what he said. Judd Welcher was going to tie those things together. And as it turns out, he didn't do anything like that. The closest we got was Ian Whiffen trying to tie the stuff together. So there's 3 charges, the murder 2, not trying to prove she intended to kill him or wanted him dead, but just she engaged in the intentional act of driving backwards. So from the very beginning, only proceeding on that 3rd prong of murder 2, not trying to say she wanted to kill him or intended to kill him, but just that she intentionally drove backward. And then the manslaughter, she recklessly hit him. Guys, the case will come down to science and data. It will come down to science and data. You better hope that's not the case. Karen Reed then began the campaign of public statements. Her words will confirm she admitted to extraordinary intoxication, driving the Lexus, being angry that night, said that she hit him, played that first clip from the Dateline interview. I don't think I hit him. Could I have hit him? He didn't look mortally wounded. Would have had to have been when he was dropped off at the party. And on January 29, 2022, very intoxicated Karen Reed was angry and arguing with John, brought the fight back to him. She clipped him and left him to die without any help. So that was the Commonwealth's opening. That's what they told us in opening. Very heavy reliance on that cell phone and car data. And so it's just fascinating that they buried that in the middle of the case, right? We got most of that. We got most of that all the way back from Ian Whiffen. Ian Whiffen started on day 5. Day 5, day 6, that's when we were hearing about the steps that were registering. Remember how Ian Whiffen went to the neighborhood to drive the route and see if the Apple phone would register a hill from holding your phone in your hand while you're driving. Remember that was his theory for why the steps aren't steps, why the hills aren't hills. They are when the Commonwealth wants them to be, but they aren't when the Commonwealth wants them not to be. Remember, he went and did his own test right there in the neighborhood when Helen Jackson wanted to find out the results of that test. Objection. Objection. We could not have that. That was all the way back on day 6. Do you wonder if the jury has gotten the idea? Was that maybe when they started to it would be a logical place to start to have a dawning realization that, you know what, it seems like maybe this prosecution doesn't really want us to know what's going on way back when. So it's interesting. It's just interesting to look back at this and the judgment calls that were made early on, how that lines up with the decisions that were made at trial, and then looking back, of course, with the hindsight, the 2020 hindsight we have now, how did all that play out? I gotta think Hank didn't anticipate that, so many pieces of the case, particularly the I hit him piece, was going to just be damaged so severely so early on, because that's what he front loaded the case with. Front loaded the case with I hit him from Timothy Nuttall, Kerry Roberts, first responders, got that out real early, and then we've already heard the problems with the recollections, heard the problems with the credibility. You went and lied to the grand jury? No. Oh, you didn't lie. You just made a terrible mistake. Misunderstood the question. Don't think he anticipated it was going to take so much damage so early. Because then he shifted from that to Ian Whiffen and the data. Ian Whiffen, the phone data, the health data. Had to play a lot of games with when is the data good and when is the data not good. Gotta wonder if, that was the intention. I see on the docket, there is a motion for transparency regarding alternate juror selection. We don't have a document yet, it doesn't look like. We do have a note that it's in the docket. We have court coming now.
Jurors on their way?
No, we need to be.
Jurors are on the way.
Okay, come over to sidebar, please. The jurors are on their way.
Unfortunately, we have to go over to sidebar. Why? Does it have to do with that motion that just got filed? Gotta wonder if it has to do with the motion for transparency regarding the alternate juror selection. Are we going to deal with that after we do the closings? Here we are. It's 8 minutes to 9 over there on the East Coast. And everyone was supposed to be here. We started early because the jury was going to get here early. Attorneys were going to be there early. But lo and behold, here we are barely early. And so I see a few folks have mentioned this. Nikki, the defense filed a motion regarding jury selection. Dee Dee posted the docket. So that is done. That is out there. Don't know. Okay, so now I'm seeing YSL Kells saying Bev denied the motion for transparency in the alternate juror drawing. She denied it. Is that already on the docket too? Have they been able to find on the docket? They get entered as not allowed or denied or something like that. Not sure. Not sure how we know. Imagine a trial, a courtroom, a case where we can't select the alternates in front of the courtroom. Like that's some kind of big ask. It's just going to invite it's just going to invite questions, isn't it? It's just going to invite suspicion. Transparency, if you refuse to grant transparency, it just makes people naturally wonder, what are you hiding? Why would you need to hide the alternate jury selection?
You are muted.
Guess they got us muted now in the courtroom. Well, at least she already looks like she's in a mood this morning. Get over to sidebar. We know she'd be in a mood because here we are. It's already 5 minutes to 9. This is like the earliest she's been anywhere for any of this. Now she's going off the bench. It's just going to raise questions, isn't it? You can't. Why can you not do the jury selection? You just did in the Turk trial. No problem whatsoever in this same courthouse. Handling that with transparency, openness, doing it right in public, right in front of everybody. I mean, we looked at the statute. We looked at the statute the other day. It's nuts. It says very specifically how it's going to be done. The clerk shall direct the clerk to place the names of all of the available jurors except the foreperson into a box or drum and to select at random the names of the appropriate number of jurors necessary to reduce the jury to the proper number of members required for deliberation in the particular case. Says specifically how they're supposed to do it. So why would we not just go ahead and do that out in the open, out in public? How is that not a part of the trial? Something to which Karen has a right to be present and we the public have a right to be present. Why would that be something that is or should be kept from the public eye? Of course it shouldn't. It's bizarre. It does state denied right on the docket. I guess that's how we know. Dee Dee, of course, our girl Dee Dee, fabulous Dee Dee, has a screenshot of the docket. Defendant's motion to ensure transparency in alternate juror selection process and affidavit of counsel in support of defendant's motion to ensure transparency in alternate juror selection process and certificate of service denied. Denied. It says right there. It says right there on the docket. She's already denied it. Apparently, without a hearing even. Don't even need to have an argument. So everybody's going to be watching, huh? Who are the alternates? Who are the alternates? Which ones? Have they been expressive? Have they been note takers? It's just going to invite questions. Not doing it out in public. And so, surprising no one. We're still not started at 9. Remember, 9 sharp. 9 sharp, we're going to get those arguments started. But that might be asking a lot. Oh, she's got a minute left. She's got a minute left to pull that off. Well, here's just something to be aware of. Commonwealth of Massachusetts. General Laws, Chapter 234A, Section 71. Whoever is guilty of fraud in the processing or selection of jurors or prospective jurors, either by causing any name to be inserted into any list wrongfully, or by causing any name to be deleted from any list wrongfully, including wrongful data entry or the altering of any data processing machine, or any set of instructions or programs which control data processing equipment for such wrongful person, shall have committed the crime of jury tampering. On conviction thereof, may be punished by a fine not more than $10,000 or imprisonment for not more than 2 years or both. Jury tampering for fraud in the creation of the lists. But we certainly wouldn't want to do it openly so that we have assurance there's no criminal fraud taking place in the selection of the alternates. Well, officially behind schedule. Here we are, officially. We got up way too early. It was totally unnecessary. But hey, we got a chance to revisit Mr. Brennan's opening. Looks like Sue is in the courtroom today. Sue is making some notes. Inside the courtroom, the majority of folks are wearing dark colors, dressed more formally. Buchanan is standing outside the courtroom. Defense attorney Elizabeth Little has asked court officers if he will be standing there as the jury comes in and says they would prefer if he didn't. Ha! Yeah, I bet they would. Definitely a more somber and stressful mood. Judge is on the bench, jurors on the way, sidebar. Judge asked to speak with a court officer at the sidebar. Counsel returns to the table. Attorney Little brings the judge a drive. Recess as the jury is coming over. Both counsels are conferring at their tables. So something is going on. Judge went off the bench. They were bringing the jury over, but not clear that they finished that. Not sure if the jury is actually in the room right now or not. Ted Daniel, I guess, is saying, I'm told Alan Jackson will close for the defense. So that was $1 million question we had. Who's going to do the closing? Alan Jackson will close for the defense. He says, I'm told to expect a lot of visuals in his presentation. Well, that answers that question. That's the drive. Their Commonwealth is making a stink about Alan Jackson's closing. So we're going to have to go back. She's going back in her chambers now to look at it so that she can criticize it, tell them they have to change it. You're not going to be allowed to do that. You got to take out this and that and that. Why? Well, who knows? Can't expect that we'll actually be given a reason for that. Jessica Machado is there. I don't think she is in the courtroom today. I think she's an alternate. I don't believe she made it back inside. I'm not 100% sure about that. She tells us Bill and Janet Reed arrive. They're walking through the large crowd of supporters, hugging and talking to each of them. Lally has just walked past the crowd and literally no one noticed. The crowd is quiet so as to not violate the buffer zone rules. Yeah, she's an alternate. She has been moved to the courtroom on the first floor. She can see the jurors in the front lobby getting checked in through security. Things outside the courthouse, she says, had a very somber feel this morning. The crowd was very quiet. The O'Keefe family went to the corner across the street from where the FK supporters were to wait for Peggy and her husband. No one in the crowd said anything at all that I could hear. It was silent. There is far more press here today than in the past. That's typical. Lots of cameras and photographers. Many of them don't even know who people are in this case. As one photography asked me who a person was, and I said Bill Reed. So typical. The press likes to show up for the attention grabbing events, and the rest of the time, not pay much attention at all. So closing, everybody knows closing is a big day. So here's the press now taking an interest in what's going on. Reed said she texted one of the women who organizes the supporters, asking her to share with everyone to please be quiet outside and make sure no one yelled anything out to her. So that explains the quiet outside. There we go. Knowing that Karen is encouraging compliance with the buffer zone. So last thing from Sue, both teams are watching videos on their laptops. A reasonable assumption is that one of the teams is planning on using video in the close and it is being reviewed. Sounds like, per Ted Daniels' report and Ms. Little providing a drive to the judge, that it's probably the defense. So at least now we know. At least now we know that's why we're late today. Foreseeable to everybody except apparently the court. Okay, Dee Dee did get a hold of the motion. So the motion has been filed. Looks pretty straightforward. It's just a handwritten denied B. Canoni down there at the bottom. Now comes the defendant, Karen Reed, by and through undersigned counsel, respectfully moves this honorable court to adopt a fair and transparent process for the designation of alternate jurors in this matter. To that end, Ms. Reed submits the following motion and a proposed procedure. In support, she states the right to a fair and impartial jury is protected by the 6th and 14th Amendments to the U.S. Constitution and Article 12 of the Massachusetts Declaration of Rights. The selection and seating of jurors, including alternates, is integral to safeguarding a defendant's constitutional right to due process and the right to trial by jury. Ambiguity in the alternate juror selection process could undermine the integrity of the entire trial. Well, I'd say that horse has left the barn, personally, but it is just yet one more issue. Accordingly, defendant respectfully requests that this court issue an order setting forth the method by which alternate jurors will be identified. Defendant further moves that this honorable court allow the defendant to have input prior to the selection of the foreperson. The proposed procedure would be, let's see. Oh boy, look at this. Number one, there's a footnote here, guys. There's a footnote to the proposed procedure. It says, Ms. Reed notes that the first 3 steps of this proposed procedure are largely consistent with the method used to select and announce alternate jurors in the trial of Commonwealth versus Turk, held on April 8th, 2025 in Norfolk Superior Court. The 4th step, requesting that she be permitted to draw the alternate juror balls herself, is a potential additional safeguard. They're pointing it out. You did this right out in the open in front of everybody 2 months ago. What's the problem with doing that here now? No reason given, of course. So here's the proposed procedure. 1, that each numbered ball be shown individually and then placed one by one into the wooden drum with the process visible to the court, counsel, and Ms. Reed. 2, that the drawing of alternates from the drum be conducted in open court on the record and in the presence of the court, counsel, and Ms. Reed. 3, that the number on each ball selected be clearly announced, shown to all parties, then placed on a designated stand or display area in full view of the court, counsel, and Ms. Reed. And 4, that optimally Ms. Reed herself be permitted to draw the alternate juror balls from the drum as a further safeguard of neutrality and to reinforce confidence in the fairness of the process. Gotta tell you, 1 through 3, nothing about that seems remotely remarkable at all. It doesn't seem remarkable at all. Very perfectly normal and exactly how you should do it. I started thinking about this. I started thinking about trials that I've had. Alternates get selected. You always just do it out in open court. I've never seen it any other way. I've never seen it happen secretly. I've never seen it happen behind closed doors. I've never seen it anything other than pretty much what's being described here Everybody's number goes into a cup, goes into a bingo roller kind of thing. Whatever system you have, you pull it out right in open court because there's no reason not to. This is such an ordinary and reasonable request. There's just really no rational reason why you wouldn't go ahead and do this. It's just bizarre. She's so not going to be told how to run her courtroom. She's going to do it her way, the way that she wants, no matter what, that she's happy. She's happy for there to be questions about the integrity of it. No reason I can think of. No reason I can think of why you wouldn't go ahead and do that. Just select it in open court. What on earth is the problem? Well, did we or did we not call at this early morning? We're going to do it in an abundance of caution anyway, but probably not necessary. Did we call that? Yeah, we did. Yeah, we did. We knew she wasn't actually going to get started even on time, let alone early. Lawner Junkie tagged me in the motion for transparency on X. Thank you for that, Lawner Junkie. I did see it. Just read through it. Seems like a really nominal ask to me. Nothing extraordinary whatsoever about that. But all we just have is that little denied. No reason. No good reason we can think of other than I'm not going to be told how to select the jury. So I'm looking to see if we've got any updates from any of the folks who were there. Not seeing any so far, but check back with Sue. Well, Sue says as Special Prosecutor Hank Brennan has visited with Mrs. O'Keefe and the family. So stuff is going in the courtroom. But
you are
visibly.
unmuted.
Truly. Who set this up? Thank you. Evidence you need to see the flash drive. Here, I need my mouse too. All right, so why don't I see counsel over here at Sidebar? I've got my computer up.
Why don't we see counsel over here at Sidebar? Because Mr. Jackson, you're going to have to delete this and this and this. And Mr. Jackson, I'm not going to allow this and this other. I'm not going to allow. Here's the thing. If they're admitted into evidence, you should be able to use them in your closing. That is a very, very straightforward idea. So Mr. Jackson is going to know this. I trust. This is quite fundamental to lawyering, to doing a trial. You get to use what's in evidence. You don't get to use what's not in evidence. So If his presentation is demonstrating what's in evidence to the jury, shouldn't be any issues with it. Voir Noir, just realizing today is Friday the 13th. Yes, it is. Yes, it is Friday the 13th. Normally, I'd be superstitious, but today I choose to believe the bad luck will befall the Commonwealth. Free Karen Reed. Yeah. Yeah, that's the thing, right? One person's bad luck is another person's good luck. So it really just depends on where you stand, doesn't it? Dr. Laposada's clapbacks, good vibes and energy for Team Karen. Free Karen Reed. Good vibes and energy. Let's see a good closing. Let's see a good, powerful closing. Looks like Dee Dee's now posting that there had also been an opposition filed. That's now in the docket. Commonwealth's opposition to defendant's motion concerning selection of alternate jurors with exhibits attached. Don't see the document itself yet, but of course, that's all it takes to deny a defense motion is just have the Commonwealth oppose it. Of course, curious to see what their potential reasoning is. Now that's what I want to see. I want to see the opposition. What possible reason do you have for opposing transparency in the alternate selection? Here's a note from Turtle Boy. Like we just said, the media decides to get interested only at certain points that they think is most TV friendly. So Turtle Boy saying the Globe, the AP, and News National showed up. News Nation, I think he means News Nation. Not shocking there at all. Showed up for the first time today and took 3 of the media slots that are usually open. Grant and Law and Crime are on the list, but not here. That leaves 2 alternate spots for ABC and Jess Machado, which means I will not make it into the courtroom as a standby for closing arguments. So that, of course, is par for the course. Don't show up until the very last day, then show up, and the people who have been there since day one lose their seats. Kind of like when they show up and cut the line. Cut the line. Remember those line cutters over there at Delphi? I sure haven't forgotten the line cutters over there in Delphi. Nope, sure haven't, Dateline, and I'll keep mentioning that. That's the actual respect they have for their audience over there. Just go ahead and go cut the line. Disregard the public entirely. Oh man, I would love to know what the jury is thinking right now. Had to show up early for this bullshit. Guys, they had to get here almost an hour ago. Specially called to be here almost an hour ago. Here they are waiting, waiting, waiting. Why? Because Judge Cannoni's got to tell them how to modify their closing presentation. It'll be some ridiculous nitpicky stuff. If he's just showing the jury what's already in evidence, that's perfectly legit. Well, guys, while we're waiting, Miriam says good morning, y'all. Good morning, Miriam. Welcome. Welcome. We'll just keep waiting. We can be patient. Melissa Garcia, I feel like Russell got the worst Hank both times. She did get a pretty bad Hank, didn't she? She got a pretty bad Hank. I'd say it's pretty close with bringing up Dr. Wolf's wife. Bringing up the wife is pretty low. Pretty low. L'enfant, can someone help me find a membership button, please? I don't know why my membership and sub were off. I watch and like daily. Well, thank you for being here. It depends on what device you're on. If you're on iPhone, it gets really, really tricky to join. I don't know why that is. That's just how they've made it. If you are on a desktop or if you are on an Android phone, there should be a little join button next to the channel description, the video description. Hopefully you will be able to find that. Appreciate your being here and being a member. Summertime, if we had any photos of the men that were in the houses that night to see if they had any injuries at all. But no, maybe they didn't come out that morning because they didn't want to be seen. Possible. Possible. Now, Higgins didn't mind. Of course, we have seen Higgins that morning, at least, the shadowy apparition of Higgins over there at the Canton Police Department on the surveillance video. Didn't see anything obvious there. But the others, nope. No idea what condition they were in or if there was any reason why they wouldn't have wanted to be seen that morning. Oops. Jason McClellan had a reserved decision. HH dealt with scenarios that could motivate a jury to turn on side or another. HH noticed that juries can punish one side for wasting their time. Could they convict Karen Reed for wasting their time? Juries have the power to do almost anything. Juries have the power to do whatever they want. The question is, what can they do overtly and what can they do without getting caught? And the reality is that if everybody is on board with doing something and everybody stays quiet about it, they can do literally anything because there's no inquiry into their process. We don't get to ask them, what were you doing back there in deliberations? You have to have some kind of information about misconduct. You can ask them about misconduct, but you're only going to find out about that if somebody tells you it happened. And if everybody's on the same page back in that jury room about what we're going to do, nobody tells you, you're never going to know. So technically, this would be misconduct. You can't convict Karen Reed for wasting the time. The instructions are very clear. It has to be based on the evidence. So if you're basing a verdict on anything other than the evidence and the law, you are committing misconduct. You're not allowed to do it. The question here is really, is there a way that you could know if that happened? And is there a check on it if it did? And that just really depends on what the buy-in of the jurors are. Now, I have a very hard time thinking the jury is going to conclude that Karen Reed was a time waster here. I mean, the Commonwealth told us in day one in their opening statement, the injuries don't fit with I hit him, I hit him, I hit him. So they've known from day one about this problem. Thanks to Dr. Rentschler and the ARCA witnesses, they also know that before the last trial, the Commonwealth knew that this independent crash reconstructionist had determined that none of this is consistent. The damage to the taillight isn't consistent, and the injuries to John aren't consistent. They already knew. They went to trial anyway. Now they come back and they've hired a new crash reconstructionist who came and threw up his hands and said, we just can't know anything. And they came to trial a second time with that. I find it so hard to believe the jury could think that it's Karen who's wasting the time. But you just never know. You really just don't know. Haven, your note-taking skills are amazing. Could you show us a page or two of what they look like? How do you write so fast? Cursive? Thank you for all you do. Well, thank you. I just write a lot. I've had to do this for many years, try to get as many details as possible. So I have my system. Let me hide this for a second just so I can show you. I mean, I don't do shorthand. I don't, stuff like that. This is full on. I just, it's not really cursive. It's not really, printing. It's kind of in between. And I'll do things like, I make little stars in the margins where there's something that stands out, something that catches my attention. Yeah, I don't know. I just write fast. Just write fast, but thank you. I'm still learning how is the best way to do this trial coverage and talk about what's going on. What's the best information? Clearly did this in Delphi. It was necessary because in Delphi we didn't have the trial stream, and so the recap was all we had. So very critical to get as much detail as possible in the notes. Not as important in this case because we're all watching it together. So don't necessarily need the detail. Might be better maybe to just keep track of that 10,000 foot stuff. That's maybe just the big takeaways. But my comfort zone is the long detailed notes. It just makes it a lot easier to find stuff. If I want to go back and find the clip where something happened, I can find in my notes, what did they say around that period of time? And then if I can find that in the transcript, it makes it easy to find it in the video. So I'm not quite sure necessarily doing it the best way possible, but it's just what I'm used to. So and now she's going back off the bench. Oh my Lord, what a mess. What a mess. So anyway, Haven, that's kind of the story of the notes there and what I do. Still figuring out what I'm going to do with Koberger. I definitely plan to be there for at least the early part of the case, the jury selection. But I don't know if I'm going to try to be there like in the courtroom for the whole trial, if I'll stream some of the trial. I got to make some of those decisions, but I don't know. Interested in what you guys think about that too. If any of you are interested in coming back to follow the Koberger trial with me. What seems more interesting to you? Would you rather have the live watch of the stream like we're doing it here? Or would you like more of the inside the court view? See, part of what I'm thinking, there's a couple things going on. Obviously, the inside the court, important for you want to see the jury and look at the jury and how they react. Only way you do that is by getting in the courtroom. But the other piece of it too, guys, is that, there's going to be a lot of evidence they aren't going to show us on TV. There's a lot of evidence they aren't going to show us on TV. It might matter. We don't know. But things like, the knife sheath is one that it just seems very important to me because it's the most important piece of evidence in the case. And so it's one where details may matter. Exactly where was it found and what condition was it found and so forth. And it seems pretty unlikely that's going to be presented in a way that we can see it on TV because of the circumstances. So a lot of that evidence and a lot of those details, you're going to have to be in the courtroom to be able to get that information. But if I'm in the courtroom getting the information, we're not watching the live stream. So these are just some of the things I struggle with a little bit, making my decision. Add on the fact, going to Boise for me is not really that big of a deal. I've got family over there. But we are talking about, it's about a 5-hour drive from here. So it's not like I'd go home every weekend or anything like that. It's a long time away from home. So just trying to make some decisions about all of that. And I don't know. Not maybe I'll put a poll out on the community at some point. Let's first find out if the trial is actually going to go forward starting on July the 30th. It's not clear to me that that is a given at this point. I would love to have a verdict in Karen Reed this afternoon, and then we can just come in on Monday and watch the Koberger hearing on the motion to continue. We can just move right on. That would be nice. Not have juggling verdict watch with other cases and so forth. So anyway, I did just want to give you guys a heads up that definitely there's going to be Koberger coverage here, but just exactly what it looks like, haven't quite made that decision yet. So we will see. Mickey P, 4 elite experts laughing on the stand about the idea of a collision versus clown pursuing non-existent BS 17 years, and another who didn't see x-rays. Would take a very arrogant juror to contradict La Posada and Russell. I loved how they, Hank's cross of Rentschler is like to emphasize how they were laughing at you. They're laughing at you. Was there lots of laughing while you were eating your ham sandwich after you had that great dig about physics or physics? What a thing to highlight in your cross. I don't know, the thing about the experts is it's just not that uncommon for the jury to not pay that much attention to them. To assume, yeah, experts on either side are hired guns. That's what they're there for. Of course, they're going to come in and say what benefits their client. It's a lot of times over their head, so they don't have the ability to meaningfully question it, challenge it, second guess it, test it. It's either take it for granted or not. It's hard to know what the jury will do with the experts in the case. If you throw out the experts, then you just default to the, eyewitnesses, and we don't have that in this case. We don't have that. Even to interpret the card data and the phone data and stuff, we need experts for that. So it's hard to imagine they could just throw out the experts entirely, but it's not unheard of. The distinction between, the defense experts, the prosecution's experts. Nobody on the defense team got their academic fraud handed to them, did they? Just a problem. Anna Long, corrupt judge and a mob lawyer. The jury could easily be tampered, so easily. A hung jury is so likely. It's sickening. Bev wouldn't say a word. I hate that we can't take it off the table. I really do. It's the most frustrating thing about watching this trial is how we can't just rely on the law to be enforced and for normal norms to be out there and for transparency and for openness. We can't rely on any of that. We got to constantly be second guessing. What's going to happen? What are we going to see? How's it going to go? What's the decision going to be? Why are these decisions being made? We don't even get to know why the decisions are being made. Such a frustrating part of watching this jury, this case. Yeah, it could be easily tampered with. Oh, L'Enfant, you found the button. I'm so glad. L'Enfant is now a YouTube member. I'm glad you were able to find that. And Susan C is gifted membership. Susan C, thank you so much for turning the chat green for us. It's always a beautiful thing to see. Aaron White, what are the odds of the defense has to raise an objection during Brennan's summation? Brennan can't help himself. I'm going to say hi. We've talked before about closing is one of the most common places for prosecutorial misconduct to take place. It's like they just can't help themselves. They just can't help themselves. They go off script. They misstate the law. They misstate the evidence. They shift the burden of proof. They argue that the defense has some duty to do something. They ask the jury to draw inferences from impermissible things. It's just so common, and you have to object during closing if you're going to preserve that. So the answer to this question, or what are the odds that Brennan gives a perfectly clean, unobjectionable closing with no misconduct, no misstatements, no misrepresentations? What are the odds of that? I think that's extremely low, like astronomically low. Of course he's going to fight cheap. He's already given up. What else is there to lose? Of course he's going to fight cheap. So I feel like it's almost a certainty that there's going to be something in this closing that needs objecting to. Bev excluding Colin from third party equals Colin did it. I don't know, guys. I'm not we'll never know. That's the whole point. The only people who are gonna know what happened to John are the people that were there. Maybe someday somebody will tell us, but we don't have any way of knowing. We really don't. It's unfortunate. It's sad, but I don't know that Colin had to do it for Colin to be getting protected. Colin just needed to be there. Colin needed to have some guilty knowledge. They're fine with doing their own cover up, but bringing the kids into it, making the kids, all he needs is to know something that he's not supposed to know. That's why they want to keep him out. They don't want him in the position of having to lie to the grand jury, lie to the feds, etc. I don't know that it means he's the one that did it. We'll never know, because that was the whole point. They didn't go and interview Colin even for a year and a half, left him out of the initial police reports. We'll never know. They did that on purpose. Bino, looking forward to closings. Yeah, maybe today we'll get started. Maybe at some point today we'll have closings. That'll be nice. Jury is back there twiddling their thumbs, wondering why exactly are we here? She rage knits. I would drop way too many stitches rage knitting. I'm not a particularly good knitter anyway, but I really can't imagine doing it in rage. Since dropping lesser included, can the Commonwealth charge those again, or are they under double jeopardy? Thanks in advance. Lesser includeds are typically incorporated in double jeopardy, but not. I guess it just depends if it's something that the jury necessarily had to reject in order to find her not guilty. We looked at this the other day, and the answer on it was a little bit ambiguous, because what double jeopardy prevents is from you retrying somebody for the same crime, or charging somebody with multiple counts of the same crime for a single act. So there's a lot of different legal issues that get implicated in this. You have, what is the unit of prosecution? This is the idea that, say you have a fight, somebody's charged with assault. How many counts of assault do you get to charge for one fight? Do you charge one assault for one fight, or do you charge one assault for each punch? That depends on what the unit of prosecution is. Is it the punch, or is it the overall conflict? So that's one piece of the puzzle with what they get to do. But the other is, what is the crime and how is it defined? Double jeopardy is a doctrine that has been it's just been defanged. It has no teeth. Boy, now I just spaced. It's been an early morning, guys. Pointlessly, apparently. could have slept in for another hour and a half, but all I can think is Brandenburg, and it's not Brandenburg. There's a U.S. Supreme Court case where they basically said double jeopardy only applies to it's a legislative decision about how they choose to define crimes. And so as long as they choose to establish different elements, you can charge multiple crimes for the same act as long as they have different elements. So that means the legislature could define, one vehicular homicide that's got elements, an intentional homicide that's got elements. They're different. They're based on the same act, but they're different crimes for double jeopardy purposes. So it doesn't necessarily rule out being convicted for both and sentenced for both. So as far as what she can be tried with again, she can't be tried again for anything that they necessarily had to prove and have the jury reject if they, if they acquitted her, or necessarily would have been proven in a lesser included that gets dropped. But the issue here is more one of joinder. Are they required to file all of the same charges, present them all in the same proceeding? Or can they take additional charges that maybe are related, maybe could have been charged but weren't, and use those as a backup and charge them later? It's not clear. It wasn't clear when we looked at the joinder rules in Massachusetts. In Washington, we have mandatory joinder, where basically if it's all arising out of the same incident or the same police report, you have to charge them all in the same case or you're done. Massachusetts doesn't seem to have that, at least not explicitly in their rules. So when we looked at it, I think we were left with the conclusion of maybe it's possible. Couldn't rule it out that they would be allowed to do that.
Hey. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and before the country before. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors. So I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning, so I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you
Put away your notebooks. There we know.
But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is you folks are the fact finders. So it's what you find.
She already
from
knows.
The testimony, your memory of the testimony.
Hank's going to misstate the
trial,
facts.
but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. Right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. Mr. Jackson?
Not a first then last, first then defense then rebuttal. I guess I forgot about that. She did,
There was
didn't
no
she?
collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent. and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night, and John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, was a Canton board selectman. He was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away.
Wow.
Well, he got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look.
Through the side-by-side I like.
Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house, about 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You coming here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car, out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this.
Oh, God.
This is what a
We're not
body
going
looks
to
like
get
after being struck by a
the
car
Welcher
at
slide.
25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. Mm-hmm. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question.
Oof.
That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation, this is science, and it's irrefutable. It tells us that he was not laying outside in the cold, he was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scorti-Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes, Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously, to get this done. His friend then asks what Proctor's probably thinking at the time, quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass bitch. She's got a leaky balloon knot, leaks poo, zero chance she skates. She's fucked. And up to this point, Michael Proctor had done zero investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed. because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper?
Sprinkled!
Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door. And her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, and Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabe's. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Celebrite at 2:27 a.m. A Google search that read, Haas Long to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
Yeah.
Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video, multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered, he's bleeding, his eyelid is cut, his nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that?
Yep.
Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember,
What was he doing?
He's an ATF agent. He's a cop, a member of the
What was
Blue
he
Wall,
doing there?
and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be at that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever.
Do the right thing.
What else was said in that meeting?
Do the right thing.
What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. Mm-hmm. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as
his arm in.
Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them,
3, call them
sitting
all
right
out.
there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Read not guilty, not guilty, not guilty. Thank you.
Powerful. Very powerful. No breaks, straight to Hank.
John O'Keefe was 46 years old. 46 years old.
46.
He spent his life helping people.
All right, we're done.
He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in.
Mm-hmm.
John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Read in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking at McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card,
From
we know
the guy who's adding
exactly
to the
step
clock.
by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of his cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
According to La Posada.
She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described to you one time to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read if you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, After this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So he drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed was not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please? At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit.
That's 7:30 or 8:30.
Now, it's been intimated, not come out and said that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence.
Object.
And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they reported at McCarthy's, which is where I consumed most of the alcohol, was the weakest black tonic. It tasted just like old soda water with lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet, the roads were very quiet, you can see on the videos. And I was going, when I've had a few drinks and I drive, I always drove extra slow. And go my alerts aren't as sharp as they should be. But I shouldn't be driving.
Thank you. Do you think she drank when she got home? When they leave the waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering
Burgess
events.
did.
And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said this in the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical.
That's what it doesn't.
It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Slide 4, please.
That is their whole theory. This is like the most misogynistic theory of the case.
The outbursts. In fact, when Jen was navigating John to the outbursts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship,
The
fueled by
duress?
intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that a little, please. And it shows you with the healthcare data, it registers as flights climbed, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you can move down, please, Ms. Gilman. And then the bottom left, that's 34 Fairview. You can see second by second the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. Disorder comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and make criticisms like a Monday morning quarterback. But even he looking at the data says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there, they're together. The data matches up perfectly. Perfectly.
What?
And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for two reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They follow behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. And they didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves to 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly where John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves to 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing, it could be a straight line, it could be shaking the phone. We don't know.
Could be shaking the
We don't
phone.
know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds, he's moving. And in that 20-second window, when he moves, he has his phone and he looks down 12/32/09, he sees a text message from his friend, Jen McCabe. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over.
Wait, he was walking,
Whatever
Hank. Where's
argument
he
is
walking?
over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then
Westerly
she
off
makes
the
a
road.
decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Ms. Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case for second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and if that conduct will create a clear and plain likelihood of death, then she's guilty of that crime.
She's not. You missed
Whatever
the
label
causation
is,
part.
she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge and they see cars going by and they have a boulder and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car brake, the thrill. And when they throw that boulder off the bridge and it comes down and lands on the car and there's somebody, passenger, child, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. but that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34th Fairview Road where we left.
Why?
We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorgo wants, he stops moving. John O'Keefe stops moving forever. Forever. Next slide 6, please. You'll get to see this more closely, and you can't probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night.
That wasn't data.
Anger,
it was Welcher
although not
math.
necessary in any of these charges, anger can be inferred. For somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash tests on me. You know what else they do? Tech stream data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Ms. Reed hits John O'Keefe, collides with John O'Keefe, we don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back, and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you would need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard.
But you know
It's
what
no
happened?
She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12/31/56. 12/32/04 to 12/32/12 is the data which is adjusted when you reconcile the clocks with Alexis. 12/32/09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. Mr. Disorganized says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change.
Yeah, he's still walking after the end.
So we could have slide 10, please. Can you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving scene, knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells
Oh God, here's the clip.
that she knew. Could we have slide 8, please?
He didn't seem mortally wounded.
Could I have hit him? Did I hit him?
How could that have been?
I don't know what that could have been. It was howling wind. I had YouTube acting on the stereo. And I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come out and maybe trip or bend over to pick up his cell phone and I bent over his foot and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
Could I have clipped him? Damning stuff there, Hank.
When she left Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn,
Didn't even play the
but
right
she took
clip.
evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a
Almost
hospital.
like she didn't know anything about what was going
Not
on with
one
John.
to anybody but him. 53 calls. Slide 12, please. Can you play voicemail one, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whippen's taking a phone and putting it in a freezer.
Oh, that
Not
was
a same,
something.
same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61 at 12:53. 48 unanswered calls from the defendant. He's not in at a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There'd be
Why don't you put it
healthcare data.
down?
There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, then how would he get back outside? There would be more steps because this phone is working. The data is the data. There's nothing wrong with it. It's
Because he was
registering
buried,
everything.
thrown out there
Temperature,
like a slab
the
of meat.
movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you are, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in.
No, she went
So
to
then we
sleep,
see the
Hank.
healthcare data from Miss
Slept
Reed's
like a
phone. She
baby
doesn't
for
move
several hours.
after a little after 1 o'clock. And she could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up.
Sitting.
She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?" She doesn't call Brian Higgins. Has his number, has been texting with him. "Hey, was John at a party with you? Did you see John tonight?" She knows exactly where she is and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says she's panicked. She can't understand what she's saying. "Call Jen McCabe. Call Jen McCabe." Why is she calling Jen
No.
McCabe?
She did
She
call
calls
Jen
Jen McCabe. You know what she doesn't say when she calls Jen McCabe? "When did he leave the house? What happened last night?" No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See, now it's gone from panicked to self-preservation. "I left him at the waterfall." And Jen says, "Left him at the waterfall? We saw you in front of the house." Click. Hangs up.
Oh, yeah?
So then she calls someone that she doesn't know very well. She calls Kerry Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see, but someone's going to find him at some point. So she calls Carrie Roberts. It's no wonder she left him at the waterfall. She pivots. And she calls, Carrie. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce. And she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help.
Oh, man.
Because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts separately at that time answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are on. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35. 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Carrie Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going to go back to Meadows. You're going to follow me, leave the car, I'll drive. At this point, Jen and Carrie don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Carrie Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close,
Lose your
they
spot?
can see nothing.
Forget where you're going?
But the defendant screams, "Stop, let me out." And they look around and they say, what? Let me out, let me out. She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone, so you probably know this before, but John looked like a buffalo on the prairie. It was just a lawn in a heap that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe. A weird shaped lump, not like a bush, and that is John O'Keefe. She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him, you're gonna see, when you look at the records, that healthcare data starts to move. He's been there all night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass.
Why are we jumping all around?
That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert House. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her walker. He took the glass. She says it. So the Albert House, they don't need to get the glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field.
Straw on the street a week later.
Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a cell record is not the same as a call detail record.
What?
There's no evidence. It was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry
Long
Roberts
voicemail.
and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there. Not even a whisper of it because
Yeah, because why would Jen say that, Hank? Busy covering it up.
When they find their friend John, who's not 20 feet off the side of the road, like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have slide 14, please? You can see there's Kerry Roberts' vehicle And then on the left, you can see
Looks about 10 feet off the road, maybe a little
right
more.
off the road. That's not 20 feet. That is a clip, a stubble, and a fall. Remember when Yanetti fell, there wasn't snow. It was just the beginning of the dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? It causes this type of injury all the time. All the time.
The sidewalk did.
If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember
What
the straw? I
trail?
asked you to take a look at that.
You didn't
picture.
find the rest of the
waterfall,
glass.
12, the black straw in the drink on the street. Collision, glass, nose, straw, back hits his head. Can you play the clip on the left, please? 59.
Insane.
So when John got out of the car at Brian Albert's house, he took my full.
169, please.
Glitch.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it. And as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you've heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics, getting to work 2 hours early to know the blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody, but to him it's another human being. This is his passion. Katie McLaughlin, first responder, this is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him, she clipped him, she didn't think he was mortally wounded, she panicked, she can't come to terms with it, so she has to bring people with her to face it, and now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him, could I hit him, perhaps I hit him, that was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy.
Confabulator.
Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him, I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So I must have said was, did I know? I always said I know, but did I really say this many times as law enforcement is cleaning and said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises.
It
And it is not a
rises.
coincidence. There's no coincidence.
Oh my God.
That Mr. Nuttall, Ms. McLaughlin hear exactly that.
Seeping up in exactly the way John's blood did not seep
Jen
into the
McCabe.
ground.
When she's sitting next to or standing next to Ms. McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Ms. McLaughlin, the firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant from incriminating herself. The irony. Could we have slide 9, please? This is the battery temperature. You're gonna have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they're leaving the waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it's starting to go down 72, 12:45, 66, 12:53, 61, and you see it drop and steady off at 12 or at 1:36. Remember, cell phone battery under John O'Keefe, either struggling for life or he's passed, and the body's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the vote is passed, but the warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up her phone, you know what happens to the healthcare data, right? It starts to move. It's data.
Jillian's losing her mind here. Not healthcare data.
So, while they're going through this duress, the defendant asks Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in a cold. And there's Miss McCabe in her winter jacket, soccer mom trying to help. She has MS, her hands aren't working, she's trying to type in. But what's happening during that time? It's a frantic scene. She tells you that the defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what
She's
this
just a
woman
normal
did
mom.
that morning.
Mom.
Not only for a friend, for her.
Normal mom.
For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science.
I didn't even understand
There's
the dig on
basis to
Dr. Wolf
support it,
there.
But they stand here in front of you. Why? Because
When
every
did Dr.
time
Wolf
they
click
say
and
something
swipe?
like that, you look the other way.
You just
Don't
had
look
to
at
have
her.
something to swipe?
Look the other way. 2:27, look the other way. Don't look at what she did.
He
Former
stole
Cooper
Alan's
Proctor,
clothing
look
from
the
the
other
first
way.
trial.
Look
Look
at her.
the other way?
Every time they make those, oh, she got the glass from inside the Alberts. Maybe in the basement. Look the other way. Don't look the other way. Look at the
Totally
facts.
stole
Look at
that
the
from
data.
Alan.
And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Trying to evoke that primal reaction, disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's
Remember
effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't, but that does not change. It doesn't create a conspiracy. It doesn't invent a
That
dog.
right there.
It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted.
Really?
This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce three of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. when the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He's been near the car. And in the Dighton videos themselves, when you close, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please?
Just move a few things here and there. You know, the data doesn't lie. You just take some seconds off and you move it.
You want. If you look at this angle, it's gone. You go plant, it's already gone. You know where it is? 34 Fairview Road, on at the Refield. January 29, 2022, 823. Look at the right-hand side.
Where I don't know what he thinks he's showing us.
No, it's gone. It's gone. And the same thing when you do videos, it's a different angle, a little smaller, you can play that. And
But
watch
side by side was like
Let's
so
slow it down
weird.
and slow it down,
That's
you will see
worse.
it expands. It's gone. So when you have the Dighton officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case?
Oh, talk
A
about
lot of
accusing
attention on this
people of
case,
lying and
a lot of people
perjury.
watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims that the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? It's, of course, before the snow melts out in the salad board so that you can see it unexploded. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad board. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing when I was showing Kerry and Jen when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video.
Unfortunately.
There's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished.
Another perjurer?
I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here on her profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, and then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. La Posada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. Oh, is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way.
Like it came from a taillight then?
And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scordi-Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Ms. Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen, because she, in 90 days, saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car and have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test, that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there's no car accident.
What? I missed that about
Let me
ARCA.
talk a little bit about
Vanderbilt?
ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages?
And then
What expert,
objection.
what objective expert uses Signal
Oh my
an encrypted app,
God.
to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all. And because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Rexel came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge
Oh,
Welcher
really?
adjusted.
Was it?
Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's
Now
fine, he
we're at the
admitted it before he got to his
gaslighting
credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for the transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is of this fundamental fairness for all witnesses, not just some. And so what happens with Dr. Rexel, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just asking him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes. And then things change. So when you talk about objectivity,
Did
it would
things
they can
change
come
then?
in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation, could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judd Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. But when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can.
Oh yeah, the hanging dummy because Dawn was suspended from a
We
forklift.
don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die.
Going way too close to that car.
Thank
We
you.
got to be out of time so far, aren't we? 12:30. We
Ladies
should
and
be out of
gentlemen, there is
time.
no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You would say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
That's it.
Take that, thank you.
Take
All
that
right,
down, yeah.
jurors, the next up is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks? All right, so we'll give you a half an hour for lunch, and then we'll come back. I'll give you my instructions on the law, and then the jurors will go out to deliberate. I know there are 18 of you. We seat only 12 deliberating jurors, so 6 of you are going to be alternates. I can just tell you that, you know the odds, right? And I can tell you it's the Mr. McDermott's least favorite part of his job is smoking. So we'll do that this afternoon. Do not discuss this case to see the.
Why would he give a shit one way or the other? Seriously, why would Jim care at all about selecting alternates? Okay. We're gonna have to come back with the attorneys. The sound is still on.
Counsel, can I see you just a second?
Sidebar. Seriously, why would Jim care at all? It's part of the job, selecting alternates. What, you think they're crushed? Why would that be, Bev? Why would they be worried about not participating? So, well, hour and 15 minutes late, we got started this morning. After all of that effort to make sure everyone got here early, we called this jury in special. We started the live stream at 5:15, and then we waited for an extra hour and 15 minutes with nothing going on. She did, in fact, tell them to put away their notebooks because the closing arguments are not evidence. So only the memory of the evidence is what controls. She gave them that advisement, that little advisement. If anybody says something different than what you remember, it's your memory controls. Was she anticipating some misstatements of the evidence? Perhaps. Gotta say, think that went a little bit both ways, didn't it? I think AJ got some stuff in that we didn't technically hear. We didn't technically hear in this trial. So did Hank. Well, I gotta tell you, AJ killed it in many ways. Okay, number one, you're still on message from your opening. When you get through a 31-day trial, 31 days of evidence, and at the end, you get to tell the jury the same thing as you told them on day one. You had a good theory of the case, and you had a good opening, by the way. You had a good theme, because that's what this is. There was no collision. That's the theme of their case. It's all that matters. If you decide there was no collision, we're done. We're going home. So we had the theme that carried over so that he can open his closing the same way he opened his opening. There was no collision. Hank, on the other hand, Hank's opening. How did Hank open his closing? John O'Keefe was 46 years old. Huh, no shit. Guilty. I mean, compared to how he started his opening, guys, we had just looked at how Hank had started his opening. And he had started it with that great story. At 6:04 a.m. on January 29th, 2022, the alarm bell sounded at the fire department. Started with that story of Timothy Nuttall, and Timothy Nuttall getting to the scene and what he saw and what he experienced. And then we didn't even hear the words Timothy Nuttall in the closing. Because at the end of the day, that story, I guess it didn't matter. Let's take these through bit by bit since we got the time to look at it. Ellen, there was no collision. There was no collision. Starts by thanking the jury for their courage. Takes courage to stare at injustice and say, not here, not now, not on our watch. So he's got a call to action for the jury. You are the last line of defense against a system that tried to bury the truth. But this investigation from the inception has been corrupted by bias. They warned you what to watch for, to pay attention to the medical facts and the science, but also the integrity of the investigation. Because on full display, this jury saw the lengths that some police will go to protect their own at the expense of Karen Reed. Reasonable doubt is not a technicality. It is a fundamental legal principle to protect the innocent, and it means to a moral certainty. Karen Reed is cloaked with the presumption of innocence until the Commonwealth meets its burden squarely on the Commonwealth to prove beyond a reasonable doubt to a moral certainty. The camera's on Karen during this part of the closing, and she looks tired. Man, she looks tired. This is the hard part. You've gone through everything, and it seems so obvious and it seems so clear, but you're just not quite done yet. She looked tired to me. Like, this is just I mean, as I would expect, is something like this to weigh on you, but it's just showing. So maybe true, might be true, possibly true, probably true, more likely than not true. All of these equal not guilty. You have to find beyond a reasonable doubt and to a moral certainty, which is a certainty so strong and unshakable that you would go home, look your loved ones in the eye, and say, my belief is certain, my belief is unshakable. When you go home and talk to all the people who've been watching, and they're going to have the questions, think about what you're certain of and why. So that night, January 28th, 2022, was a Friday night. They had planned to go out and meet friends, go out for drinks. The relationship was loving. When they got to the waterfall, the Alberts were already there. They were a well-known family. They have quite the reputation. Don't know that we quite heard all of that, but we do know, yes, the brother is the selectman and so on and so forth. Everybody who's there, we go through and identify. And then also Brian Higgins, that guy who just happened to have the romantic design on Karen. So at the end of the night, everybody's invited back to the house for the after party, but the invitation to John, it appears to be for a different reason. And that's because Brian Higgins was agitated that John O'Keefe was with Karen and not him. We know this from the well text that he got no response to. Then the kiss on the forehead right in front of him. And then the play wrestling is shown. And then we see the exit from the waterfall. Really like this side by side, because we never saw that during the trial. We always had to watch Brian Higgins over here. We had to watch John over here. They're on separate screens, and you can't tell what exactly is the interaction between them, but you put them up side by side and you play them like that. Now you can see. Now you can see when he's waving him over and John's looking over, and who's he looking at? Who's he talking to? That I thought was very well done. Proctor had all this information and he did nothing with it, including Higgins's text to John, 12:20 a.m. You coming here? Question mark, question mark. They were not good friends. They barely acknowledged each other. So what happened in that house, in that basement, in that garage? What did Proctor ignore? He ignored the black eyes, the eyelid, the cut on the eyelid, the dog that was in the home that went missing, the obvious dog bites on the arm. Michael Proctor didn't listen. Karen Reed arrived back home at 12:36 when her car connected to the Wi-Fi. Guys, did that get into evidence this time? Now, it could be in one of the data pieces of data, one of the reports that's home, that's in evidence. I'm not real sure, but that was the first time my little radar went up. I'm not sure that was actually in evidence. But there it is, 12:36, her car connected to the Wi-Fi. She left a voicemail. He didn't respond, and she got more and more frustrated. That's what you're hearing in the voicemails, because he didn't come back out. and she didn't know what was happening. So about 5 a.m., she went looking and she found John beaten, battered, bloody, and left in the snow on Brian Albert's front lawn. At 6 a.m. outside, it was bedlam, the fire trucks, the police trucks, the lights, the flashing, the screaming, the first responders, just under Brian Albert's bedroom window. But he never came out, and lead investigator Michael Proctor never went in. And the Commonwealth has struggled to prove that John O'Keefe ended up there because he was struck by a vehicle. The reason why they struggled is because the science and the physics, they don't lie. But the investigator was corrupted from the start. There was no collision. The silent witness is the science. I like that expression. The silent witness was the science. It does not take sides. And if there was no collision, then what are we even doing here? For every one of the charges, a vehicle had to strike John. Even the Commonwealth's own medical examiner says a person by a car suffers from massive trauma, but there is none of that present on John O'Keefe, not a single bruise. His injuries are not from a vehicle impact. Not a single medical expert testified John O'Keefe was hit by a car. Not a single one testified that John was hit by the car. They saw no evidence of any impact site. That in and of itself is reasonable doubt. I tend to agree with that. What does it look like? Let's go ahead and show him Welcher's slide from his own PowerPoint presentation where he's showing him a guy that was knocked. Was that guy knocked out of his shoes? I don't remember. But they use that comparative accident where the guy suffered major broken ribs, collapsed lungs, all of the different broken pelvis, lacerated liver, all the injuries that he have. Showed him that photo. That's what it looks like when somebody's hit by a car, but John didn't even have a bruise. Dr. Scorti-Bello was presented the same case as you, and she flatly refused to agree with the Commonwealth's theory. She would not call this a homicide. Doctors Wolf and Rentschler, they were not hired by the defense. They were completely independent, hired by a separate agency, looked at the evidence from both sides. They looked at the damage to the SUV and they looked at the injuries to John, and they determined there is no collision here because that's what the science says. By the way, this is not some ridiculous blue paint kindergarten project. Oof. That was a burn. He did actual testing for physics and force calculations and so forth. And in every single test, the damage was inconsistent to the taillight and to the sweatshirt compared to what we saw from 34 Fairview. On Karen Reed's car, the taillight components, the internal components, the diffuser, it was completely shattered, but in the ARCA testing, it remained intact. Remember, if no diffuser was broken, there would be no light. It would be just black. That's also not in evidence. We were kind of waiting and hoping that would be in evidence. Hoping we might get a demo even. We didn't. I don't think that's technically in evidence. But at 5:07 a.m., the taillight is completely illuminated on the video, and at 4:12, putting it onto the flatbed, it's completely lit up. The only way you get that white chunk at 5:07 is by picking that exact second when the car is going from reverse into forward. The car is going out of the driveway. It is completely illuminated all the way across the back. And how would that be if those taillight pieces, those diffusers, were already on the lawn at 34 Fairview? We heard that John's arm would be destroyed if it was hit at that speed. And other than the dog bites he had, he didn't even have a bruise. So the Commonwealth, this was a gut shot. The Commonwealth spent nearly $400,000 of taxpayer money to hire somebody to dress up like John and paint his arm blue. Mic drop, sit down. Yeah, that's exactly what they did. $350,000, $400,000 they paid so that he would dress up like John O'Keefe and paint his arm blue and then pretend none of that had anything to do with the collision you're proposing took place outside of 34 Fairview? But the sleeve was never damaged in ARCA testing, not one single time. Ask yourself, John's arm had 36 abrasions. How did that happen through 9 puncture holes? Why are there no slices or cuts to the hoodie? Instead, they're just punctured like you might expect to see from a dog bite. And then the shards that they say cut gouges in John's arm. Why is there no blood? There's no skin. There is no tissue, nothing on a single shard of taillight. It doesn't make sense because it didn't happen. Sometimes the simplest explanation, the easiest explanation is the right one. If it doesn't make sense, it's because it's not supposed to. It didn't happen. So for $500,000, what they did is show that John O'Keefe was tall enough to touch the taillight with his elbow. But even that basic demonstration, he still had to lean in. And he himself told you, Dr. Welcher, his own words, there isn't enough evidence to determine what happened. So what do you do with that? You vote not guilty with that. They also tried to establish the time of collision. And now we get to Shannon Burgess. The cardinal sin in science is confirmation bias. And it was how brazen he was. Focus on that, how brazen he was trying to change the data. So the Commonwealth said in opening that they have it. They've had 3.5 years to get it right. And their own report says at 12/31/38, John O'Keefe was struck. He was rendered immediately unconscious and incapacitated. But somewhere in the middle of trial, someone realized that was wrong because John was interacting with the phone after 12/31. He was on the phone, he was reading text, he was looking at it, and he was taking steps. Their own data showed that. So enter Shannon Burgess. Ask first if you can believe him. He's got a brand new story in the middle of trial, but you don't actually have to look further than his CV to decide if you can believe Shannon Burgess. Oof. Knock after knock after knock. John O'Keefe was still alive and walking around after the impact in every scenario. John was alive and walking around after they said he was hit, no matter how they shift the clock around. You can look at the Ian Whiffin's data, and it shows he took the steps, 83 feet, westerly direction, just happens to be right towards the house. And we just happen to know it's 78 feet to the garage door. That is not a coincidence. And in fact, even Ian Whiffin conceded he had reasonable doubts about that location data. Remember that questioning by Mr. Alessi? Yes, we do. Yes, we do. So then John O'Keefe was inside, and the phone battery temp shows that. It shows he was not laying outside in the cold. Ian Whiffin put it in the freezer, and it dropped from 81 degrees to 21 degrees in 15 minutes. 60 degrees in 15 minutes, 4 degrees a minute. Now look at John O'Keefe's phone. It was directly on the frozen ground. It dropped 20 degrees in 1 hour. So quite a bit less than the 4 degrees a minute that Ian Whiffin got. And then it stayed steady at 50 degrees for the next 4.5 hours for the entire night underneath John's body while John is cooling. It's on the ground. He was not outside. He was in the basement, or he was in the garage somewhere else. He had no hypothermia. He had no frostbite. He wasn't outside. Every expert agreed John died from a rearward fall from a standing position. So the question is, what could cause that? Well, he's got a laceration to his eye consistent with a punch. He didn't fall into a lawn because Dr. La Posada said he hit a hard ridge surface like a concrete stair or a step, but Proctor never went in to find out. And then look at John's arm. They're dog bites. There is not a single witness who actually disputes that these are from the dog. Commonwealth had no medical expert to come in and dispute that. Dr. La Posada said explicitly he didn't get hit by a car. The speed didn't matter because he didn't get hit by a car, and the medical science proves it. Dr. Rentschler said it just as clearly. So the Commonwealth cannot meet their burden. There is not a single medical expert saying these injuries came from a car. There's no medical expert disagreeing that these wounds on the arm came from a dog. It is undisputed. There is no medical evidence that John O'Keefe was hit by a car. So how did Karen Reed end up sitting here? They don't want to tell you because the system has failed badly. It's the utter failure of police to investigate. Michael Proctor, he did nothing. He didn't secure the scene, didn't even treat the yard as a crime scene. What did Gallagher said? He said, well, it was really cold and windy, and I didn't know if a crime had even happened. But you have a police officer out on the front yard with black eyes, a bloody nose, bleeding from his face, a cut over his eye, no coat, no shoe. Where's his other shoe, by the way? There's a broken glass nearby. His phone tucked neatly under his shoulder. Nobody has got the ring camera footage from across the street, points directly at this area. Nobody even bothers to go look because this is Brian Albert's house, and that comes with privileges. And we know that because of that Michael Proctor text. Homeowners gonna get some shit. Nope, he's a Boston cop too. Written just hours after John O'Keefe's body was found. It's Exhibit 209. Go read the text. The one call out to a specific thing to go look at. Exhibit 209, Proctor's texts. Some of the highlights from the texts. Assume you guys are out there to make it cut and dry because it was a cop involved. Something stinks. Yeah, but there will be some serious charges brought on the girl. There has been zero investigation up to this point, except they talked to 3 people named Albert or McCabe. Remember the text about no nudes yet sent to his supervisor. And what did his supervisor do? He liked it with a thumbs up. So Michael Proctor went beyond just insulting Karen Reed. He dehumanized her, and he's ultimately fired because of this bias. So if the Massachusetts State Police can't trust Michael Proctor, how can you? Oof. He was never called to testify. Wouldn't you want to hear from him? Wouldn't you want to hear from him? But the Commonwealth didn't present their own lead investigator. He's got the bias, the sharing personal info in the text, and remember, all of the evidence in this case went through his hands. So the Commonwealth has pinned its hope on microscopic pieces of nearly microscopic pieces of plastic. But who had access to the shirt and to the fragments? That was Michael Proctor for months. Why not just give it to Hartnett when she's at the Canton Police Department? That was a good question. I hadn't thought about that. She went out to do that collection. Why wait until March to book everything into evidence? Once again, no blood, no skin, no tissue, no DNA on a single shard that they say cut into John O'Keefe's arm. Because they weren't there. And then he whispers, because it was a dog. Because it was a dog. Like every medical doctor who testified about it agreed in this trial. The only DNA was found on a smooth outer part of the housing, not the part that hit John O'Keefe. And the problem, there is 2 other unidentified men on it. So you got to question the significance of that. Show me some blood, then we'll talk. Then they have the magic hair on the SUV. It survived the 60-mile drive in 47-mile-an-hour winds, and yet managed to be moved between the photos that were taken of it in the Sallyport. The Commonwealth is embarrassingly grasping at straws. But then it gets worse because of Hanley. Hanley, quiet, little unassuming, very shy Christina Hanley, the criminalist, who testified that the glass they found on Karen's bumper didn't match the cocktail glass. What it matched was the piece of glass Michael Proctor claims to have found out there at 34 Fairview while he was alone on February the 11th. But there was no glass in the taillight. Nothing else had shattered. So the glass had to be placed there. How indeed, Ellen? How did it get sprinkled on the back of the bumper? Who left the bumper sprinkles? Then we get to the Ford Edge and Lucky. He saw it parked out there at 3:30 in the morning. It had been moved there sometime after 2:30. The only person connected with an Edge here is Brian Albert. It's in the exact position where John O'Keefe was later found, and yet nobody asked any questions. They completely ignored it. Michael Proctor didn't even want to talk to Lucky. Why falsely claim nobody plowed 34 Fairview? I'm not sure that made it into evidence either. We do know that from the first trial, but I'm not sure that technically came in this trial. But why falsely claim nobody plowed 34 Fairview? Nobody plowed that road. Why wait years to interview Heather Maxson and Ryan Nagel? Lucky would have said there was no body on the lawn, and he had a perfect view. There was only enough snow to track a cat. Maxson and Nagel, they saw Karen Reed in the driver's side. The passenger seat was empty, dome light on. Where is John? He's not in the yard. He's not in the car. Obvious conclusion, he is in the house. But Michael Proctor didn't want those answers. There is not a shred of evidence as to when Karen Reed had her last drink that night. Every witness said she wasn't drunk, she wasn't slurring. In the words of Karina Kolakithis, she was completely normal. But instead, they tried to get Yuri in to count sips, which he admittedly got wrong. Ian Whiffin's data shows Karen was driving safely, slowly, stopping at stop signs. She's going quite a bit below the speed limit. Ryan Nagel corroborated that. So they failed to prove even that she drove under the influence. But what happened when she got home and was upset with John? It's certainly possible. A little extra at that point in time. But nobody searched the house. Nobody searched 34 Fairview. Jen McCabe, she seemed, why we're on the ceiling fan. Sorry about that, guys. Jen McCabe, she seemed surprised about the garage door when she was asked about it. When she was asked about the garage door of her sister's house, where she has been since she was 5 years old, she seemed surprised to be asked about the garage door. Now, just consider if this house had belonged to somebody other than Brian Albert, it would have been torn apart. This is pure favoritism. So these are failures of duty. Every single one is a reason why you can't convict. They did not investigate every reasonable alternative, and how dare they ask you to do their job for them to find to a moral certainty what happened at 34 Fairview. They are in a position to take people's liberty. You can't just try to get it right. It has to be beyond a reasonable doubt, and they haven't met that burden. Brian Albert not being outside doesn't mean he wasn't awake. Jen McCabe claimed that they slept through everything that was happening outside, but she spoke with them at 5:07 a.m. and then lied about the call. It was there in her phone records. And that just happened to be the precise time that Karen went to look for John when she left One Meadows Ave. But Michael Proctor, he wasn't interested in their phones. He never asked. There also happens to be a dog with history at this home, a dog that is known to not be good with strangers. Not sure the not good with strangers is in this trial either. Forget where that came from. We knew that from last trial. Totally sure it's in here. But then Chloe just disappeared after that. Nobody saw the dog in the house that morning, and then ultimately is completely gotten rid of. She's Cora now, living a different life somewhere else. She's in witness protection. Buchanan had to go hunt her down. Then we look at the group chat where they're getting the story straight. Matt McCabe, who was never called to testify, tell them to say the guy never came in the house. And Brian Albert saying exactly explanation point. Guys, when you're telling the truth, you don't need to get your story straight. It's just the truth. Then the Google search. Jen McCabe admitted making the Google search. It was time-stamped at 2:27, undisputed that it is marked deleted. Now, if somebody asked you Google hypothermia, why wouldn't you just Google hypothermia? Indeed. She tried to get Carrie Roberts to cover the story about Karen screaming at the scene, but Carrie Roberts admitted she perjured herself to back up Jen McCabe's story. She actually didn't admit that. She said that she misunderstood the question, but she did admit wasn't part of it, didn't hear it. Different thing than she told the grand jury. Separating witnesses when they were interviewed. Michael Proctor didn't do that. Jen McCabe's messages about Carrie Roberts. She was bragging about influencing Carrie's statements. She's telling them everything, all the stuff. That's referring to the timeline that they put together. But Jen McCabe, in her very first statement to law enforcement, even she admits all she told police was that Karen was asking, did I hit him? Could I have hit him? Is he dead? We can answer the question, could I have hit him? No, the physics answer that question. Yuri reports that the first responders said, could I have hit him? So she was expressing confusion. Dr. Russell explained that she was suffering from an extreme grief reaction. Even her medical records confirm that diagnosis. Don't know if that's in evidence either, but we haven't seen all of Karen's medical records. Russell said that it is common for somebody in that situation to ask that kind of thing. Not a single police officer was called to support the claim. She said, I hit him. She didn't say it. There's video. There's no sound of it. Nothing. Not one officer coming in to corroborate that. So then Jen McCabe, who is confronted out of the blue with John O'Keefe's broken, frozen body, Carrie and Karen are screaming. She calls her sister at 6:07. There's no answer. She calls at 6:08. There's no answer, but she never goes inside to check on her sister, even though there are no signs of life inside. Anybody would sprint inside the house to do that, to make sure everybody was okay, but she already knew what happened, so she didn't have to do that. They didn't ask any questions about Brian Higgins. Yuri Buchanan refused to even characterize the text as flirtatious or romantic. So we read them all because they establish that Brian Higgins had a motive. Buchanan, they ignored his Brian Higgins' late night visit to the Canton Police Department while drunk, skulking through the halls, moving bags between cars, making that mysterious late night phone call. The Commonwealth didn't call him as a witness. He was there at the Canton Police Department the next day, but they didn't interview him. And then he was there in the Sally Port with Chief Berkowitz for a wildly long time, such a wildly long time that Ms. Dever thought it was weird he could have access to that critical evidence, the SUV, according to what she told separate investigators. And it just happens to be at that exact minute he would be out there. There's 42 minutes of Sally Port video that is just poof, gone, missing, not there. And Dighton, the taillight was cracked and not completely broken. So let's compare. Let's compare in your minds. Let's compare Devers and Barrows, Nicholas Barrows. Yeah, compare them in your mind. Barrows said the taillight was absolutely not in the condition that it was later photographed in the Sally Port. So how did it end up like that? Well, there's a video at Meadows, the Commonwealth's own expert, confirms. And there was no taillight found in any initial search. It was only after Michael Proctor had access to or control of the taillight that any pieces started to show up. And you will see how far a police officer will go because of this corruption. Talk about Kelly Devers again. She's interviewed by a different law enforcement agency. She told them what she saw. It was detailed. It was clear. It had emotion associated with it. She remembered how it made it feel. She remembered how long they spent. She had these incredible details. But as soon as she's subpoenaed by the defense, oh boy. Then she's called up to the commissioner's office. Didn't remember being told, do the right thing. I thought she did. I thought she did say she was told to do the right thing. And suddenly her statement, the whole statement, it became a false memory. And she told you explicitly, my entire career depends on what I say here on the stand. And ladies and gentlemen, that's how it works. And that's how we got here. So you have to ask, can you trust the Commonwealth's case, their witnesses, and their evidence? You have the inverted video presented in a previous trial. You have the test where he has to shoot his arm and lean into the car. The test that the Commonwealth themselves admitted was meaningless. Doesn't mean anything. If it doesn't mean anything, then why play dress up as John while you're holding this glass? They only abandoned that theory 2 days ago when their witness proved it's physically impossible. They deceived you about there being no x-rays. The Commonwealth has had those x-rays for 3 years. And then the sweatshirt that Mr. Brennan held up to the witness and to you and asked about the holes in the back. He interrupted Mr. Wolf to point out, here's a hole, here's a hole, here's a hole, clearly suggesting they were from January the 29th. And that is false. The Commonwealth created those holes. It is not road rash. It is cuttings from their own crime lab. And yet, even with 3 prosecutors sitting in the room, I'm really glad he called out the other folks responsible for that happening. It had to be on the defense to correct the record with the truth about the sweatshirt. That is dangerous. He's going to guess Hank Brennan doesn't talk about the fraud he perpetrated on the jury. Guess what? That bet paid off, didn't it? It's shameful. It's shameful. The jury is entitled to truth and they should demand the truth. But it's the product of desperation because they know there was no collision. So there are dozens of facts here that are reasonable doubt. Every one is a massive hole in the Commonwealth's case. If you hold even one of these facts on a card, you are holding reasonable doubt. That is not guilty. The burden of proof beyond a reasonable doubt is a wall. The Commonwealth has to get over every single one, but they don't even have a theory about how John was hit. They haven't even shown you that it's possible. Not even one simulation, not even one. You don't even have to say this is how it is. Not just show it's possible. Not even one. Exactly right, AJ. Because it's not. You can't do that because it's not. They have to prove their case and their theory, but they don't even have a theory. As soon as their theory gets pushed back, they just abandon it and say, that's not our theory at all. They failed to prove the essence of the case. They failed to prove any intent on the part of Karen Reed. They failed to investigate suspects. They justify perjured testimony, officer lying about false memories, present an unbiased investigation, or even present you with the truth. It's because the investigation was conflicted and corrupted from the start. How can they ask you for moral certainty? Your oath is clear. You must acquit. Justice demands it. Don't let the Commonwealth get away with this. If you convict Karen Reed of anything, science loses and Michael Proctor wins. Remember his text. Michael Proctor wins if you convict. Could you ever say this is justice? A car did not kill John O'Keefe. Let the community feel through your verdict that justice cannot be buried. Find Karen Reed not guilty, not guilty, not guilty. So it's, as a closing goes, A lot of material in it. A lot of material in it. And the hardest thing about constructing a closing when you have a lot of material is just how do you present it in a way that's cohesive and coherent and makes sense, that the jury can follow. Very easy to start to ramble and get a field and go off track, as we'll see when we get to Hanks. So I thought overall this was extremely well done insofar as it walked us through 34 Fairview, what we know, what we don't know, why we're suspicious about it, and then got us into the investigation and why we don't know more than we do. By kind of taking that structure of separating those two things out, it helped him get in a lot of those facts in a way that, you know, followed that storyline, followed that pattern. So very, very dense with information in this closing. So then we get to Hank Brennan. Hank Brennan, John O'Keefe was 46 years old. All right, sit down and go home then, I guess. He was 46. He'd spent his life helping others. He was kind. He was thoughtful. He was good. He took in his niece and nephew. And on January 29, 2022, he needed help from somebody. I hope this registers, you know. If there was no collision, yeah, he did need help from somebody. Just one person. Just one person he needed help from. He had just been hit. He would lay on the ground dying. Just one person to reach out the hand, knock on the door, call 911. The only person could help was Karen Reed, this defendant right here. She made a choice with her taillight all over the yard. She didn't call 911. She didn't run to anybody's aid. She didn't knock on the door. She made a decision about herself, and in her Lexus, she drove away. She was drunk. She hit him, and she left him to die. So drinking that night, we know she had her blood taken. It was 2 to 3 times the legal limit. Well, the next morning it was, but not at the time. The timeline is beyond dispute. The data is the data. It's from the black box. We know that she hits him because he never moves again. You got that, guys? You put down your phone, you lose it, you never find it again. You actually have been hit by a car. Because how do you know? Because your phone never moves again. He keeps calling it the healthcare data from the phone. I know Jillian is over here losing her mind. I don't know if she's in the chat today, but Jillian's been losing her mind with that one. It's not healthcare data, it's health data, but he keeps calling it healthcare data. There's healthcare data that shows no movement. The tail light's there. The DNA is there. The hair is there. He's got a skull fracture with a contrecoup injury. This is like spitting out information because you got to get all these facts in, but you don't have a story about them. You're just spitting them out, but you haven't explained any of this. We have trauma centers, level 1 trauma centers, because people can survive if they get help. So Karen Reed was drunk, and the night was a recipe for disaster. The fate was sealed well before that night because they were in a toxic relationship. I think we can all agree on that. I think that was pretty clear. I think the significance of that is probably in dispute. It was crumbling. Niece Kaylee, once again, we're using the name now. The order is apparently disregarded for the judge and for the Commonwealth, that we're not supposed to refer to the child witnesses by name. Here it is again. Niece Kaylee told us about Aruba and the discord and the arguments. And then Karen is reaching out to Brian Higgins to text. So the relationship is crumbling. Kaylee said John would walk away from an argument, but Karen would pound on the door. She has to get the last word. And it kind of mirrors what happened on January the 29th. We have no idea if it did or not. So behind closed doors, things go up and down. It wasn't so lovey-dovey behind closed doors. There were tensions simmering. She thinks he's already halfway out of the relationship. So they go out, they drink a lot. We've seen the videos. We can see 6, 7, 8 drinks. You can see the shots and count them ourselves. Indeed, we can, and we did. Indeed, we can, and we did, Hank. And just a few hours, then she has another shot and mixed drink at the waterfall. As far as discord between Brian Higgins and John O'Keefe, it's not honorable. Brian talking to Karen Reed isn't honorable, but they were in a celebratory mood. It's a bunch of friends. Are we really saying they were practicing moves to murder John O'Keefe? I don't personally find the play wrestling all that, particularly compelling. Other than just this is how these guys interact. And probably the more drunk you get, the more handsy you get with your bros. Just kind of tends to make it more likely they might have this kind of play fighting with John. Oopsie, somebody falls and cracks their skull. But there was no animus between John O'Keefe and Brian Higgins. Wasn't he earlier trying to suggest that John knew about the texts? Or was he suggesting contrary? It's so hard to lose track when your theory shifts around so much. The next morning, Karen had her blood taken. She was far beyond the legal limit 2 to 3 times. They did the retrograde extrapolation. It's been intimated maybe she went home and drank, but there's no evidence, mind you. I have a big star. That's where I'm standing up and objecting right now. As soon as the words no evidence come out of a prosecutor's mouth in closing, you're standing up, you're objecting, burden shifting, no burden of proof. Strike that. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't. Really? Because you're going to do that multiple times. We'll just look at Karen Reed's own statements. So we start playing the clips, which we knew would be a key feature of his closing argument, those clips, because that ultimately is what the case is all about. So they left the waterfall at 12:12. John O'Keefe is holding a glass. He says you can see it in that photo. The photo's in evidence. It will speak for itself. And we know exactly where he went because the car has a black box and Judd Welcher took it and downloaded it. And then comes in Shannon Burgess. Don't attack the data, attack the man. Well, if the man is going to put the weight of his credibility on trying to tell us what the data means, then the man kind of is important. But he found a key piece of evidence that everybody had overlooked. Everybody had missed it, the SD card. And so because of that, we have the time, we have the date, we have the location. I have a million questions still about that SD card that was missed and what they got on it. So on the way to 34 Fairview, Karen Reed is driving drunk and they get lost. And so John O'Keefe has his phone and he puts on Waze. And now we get the best location data that there is. We get the speed, we get the movement. The healthcare data shows his movement, and that's critical also because it shows when it doesn't move, when he doesn't move, and that's data. Except when it's not, right? Except when it's not steps and it's not flights climbed. Other than that, it's data. But when it shows him not moving, it's data. You guys are going to have to make sense out of this for me. Alcohol fuels tension, and then there's a trigger because Jen McCabe tells them they're near Ashley's house. And that's it. Being near Ashley's house is enough, apparently. Why? How does this trigger fighting, rage? Nobody knows. Just this misogynistic theory that the very idea that your boyfriend who, recently cheated on you on New Year's to your face while you're babysitting the kids, dated somebody before. That's it, right? That's the theory. Women are going to be jealous. She's going to be so jealous that John had an ex-girlfriend that she's going to murder him. There's the elevation, I guess, on the map. The battery temperature at 77 degrees. It shows a difference between being in the bar and being in the car. Then you have the 3-point turn at Cedar Crest that triggers the event. Yeah, like the one that you're saying, the same trigger event that you're saying is a normal 3-point turn is the same trigger event that you're saying is then her doing this collision. But because of that 3-point turn, you can match up the cell phone clock with the Lexus clock, the range of 21 to 29 seconds. DeSogra is just Monday morning quarterbacking, but even he says 2 or 3 seconds. But it's all there. The data matches up perfectly. Well, it doesn't. And they're going to have DeSogra's entire report and evidence thanks to you. They drove straight to the flagpole, according to the data. Heather Maxon and Ryan Nagel, they follow right behind in their truck. John O'Keefe has about 8 more minutes to live, and he's in the car for most of that. Why? Because nobody sees him getting out, and the healthcare data shows he isn't moving. It did show steps. You've just had to turn those into being on a hill. So they sat there for minutes after arriving at 12:24:32. They're still there for after 12:30. Maxon and Nagel, they leave after 5 minutes. And so then there's 2 minutes left. They're arguing. We know that because she told Becker she was sad because the last words were an argument. We don't know if she meant the voicemail or if it had something to do with the car. But he says that proves they were arguing in the car. And then John gets out, and we know because the dome light goes on. The dome light was on when Maxon and Nagel went by. So did they just happen to catch that exactly at the time? He had already gotten out, but he's not out, but you didn't see him get out, but you see the dome light on. No explanation for this. The dome light went on. And then John O'Keefe begins to move at 12:31:56, and it's the last time that he moves for 20 seconds. And then the location data shifts to low frequency data. Nobody claims that you can tell exactly where John O'Keefe was all night, but it's consistent with him never leaving the flagpole. The data doesn't say he walks to the house. The investigator measured from the driveway, not the flagpole. I'm starting to get lost even in my own notes about where we are and what story we're telling, because we've lost the story in here. We are now just spitting out information that we hope the jury is going to rely on, but we're not tying it to anything. It's just kind of random and very difficult to follow. So we don't know every detail, but we don't have to. That's not reasonable. That's not a reasonable doubt if you don't know every detail. Well, it's a pretty important detail whether there was a collision at all. So John looks down. He sees a text from Jen McCabe. He looks at it. He closes it. And then it happens. In the uncontroverted black box data, Karen Reed drives about 30 feet away. Then she makes the decision. She could have just driven home, but she took that 6,000-pound Lexus, steps on the gas after banging it into reverse. Now we got to stop and talk about the charges in the case. What? Wait a sec. Before we get to that, let's talk about the charges in the case. This was not a good cliffhanger. Don't understand this transition. Second-degree murder, it's a serious charge. Said from the beginning, they're not suggesting that Karen Reed intended to kill John or even that she intended to hit him. Just that she intended to put the car in reverse, hit the gas pedal. By doing that, created a plain and strong likelihood of death. Because it was dark, it was late, there was snow out, she was under the influence of alcohol. She accelerated to 24 miles an hour. That created a plain and strong likelihood of death. So if she did that, she's guilty. If she did that, she's guilty. Now there's an analogy. If you're on a bridge with a boulder and you throw it off, you're not trying to hurt anybody. You just want a thrill. But when it lands on somebody in the car and it kills them, you're not intending to kill them. It's just the risk that's created by your conduct. Same sort of thing. Talked about now with recklessness, the transition, not real clear to me. But for voluntary manslaughter, the leaving the scene, we'll get back to that. But now back to 34 Fairview. So we got to jump around between the facts, between the law, between the other law. Now back to 34 Fairview. The window, whatever DeSogra wants the window to be, he stops moving forever. Yeah, 4 seconds after, according to you, She hit him, even under the most generous clock skew calculation. He stops moving forever. 75% acceleration, 24 miles an hour over a distance. Her anger can be inferred. Nothing about the text stream data is uncertain. Karen Reed hits John. We don't know how he moved. We know there's a collision because there's tail light all over the yard. That's the case for there being a collision, because there's tail light all over the yard where it doesn't belong from the crash testing that we saw. Belongs in the street. You can't replicate the hit, but you know what happened. You know what happened. Can't show you. Can't present even one possibility. Can't replicate it, but you know what happened. She goes home and she's still mad. And we know that because of the voicemails. John O'Keefe sadly lays on the ground abandoned. And so we have to ask, did Karen Reed know if she hit him? We don't have to prove that for the first 2 counts, but for the last one, we do. But an eyewitness tells us she knew, and that eyewitness is Karen Reed. We start playing the clips. Could I have clipped him? I think that was the wrong clip. He wanted the mortally wounded clip, but he didn't play that one. We have to finish the recap of the instructions.
So who wanted to see me? I'll see you at Sidebar for just a minute.
Oh, never mind. Sidebar for just a minute. So she made 53 calls that night. Now, Ian Whiffen putting the phone in the freezer doesn't mean John O'Keefe went in the house. What kind of whiplash are we on now? If he was in the house in a fight, he'd be moving. But how'd he get back? There would be steps, but the phone never moves again. Nobody knows where you are in the message. She knows that she's hit him, so she's getting nervous and she's getting anxious. She doesn't move for a while. She freaking falls asleep, dude. I guess that's all we get for our sidebar. I don't know. Very confusing. She doesn't call Jen McCabe or Brian Higgins, ask where he is. She didn't ask Jen McCabe, when did he leave? She says, I left him at the waterfall, because she's gone from panic to self-preservation. We get the story about the phone calls. Then she pivots to Carrie Roberts. That John got hit by a plow. Why choose that? Because she knew. She knew he was hit by something, had to change it to a car. And Jen and Carrie, these are both normal moms. Normal moms. They got out to help because that's what good... We see the nudge, but the taillight's already broken. And there's not a single piece that you can see on that video at John's house. But the exact same piece is missing in that video because it's back at 34 Fairview. Then at 5:35, she's at Jen McCabe's house. It took 28 minutes. Where did she go? We don't have the data, but we know she's panicked and screaming. Where did she go is a defense question. So they go back to 34 Fairview, and this is remarkable because they can't see anything, but Karen screams, let him out. Let me out. It's like a buffalo on the prairie clip, the weird shaped lump in the snow. We're not discounting the trauma of the scene here, of course, but when the cool air hits John's battery, the temp drops.
You okay?
And then the healthcare data starts to move because he's been there all night. There's a piece of glass stuck in his nose. She plucks it out. It spurts. We'll get back to that. Why we got to jump around on that, I don't know. There's a shoe, a hat, and a straw. We don't know about them right now. Why we're talking about them remains to be seen. Jen calls her sister, but a call record isn't the same as a call detail record. I don't think they've even heard of call detail records. So there's no evidence there was a conversation other than the phone call lasting 38 minutes.
All right, jurors. going to give you the instructions now in the law. But
Instructions
first, I
now.
want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any
Got
other
that? Listen
instruction.
carefully
To
for the
make
next
sure
90
that I
minutes.
give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence, and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and credibility and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you are to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes
Criminal
charged here,
character from
or to
Aruba.
conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder.
Intentional
now,
murder.
I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely, by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI. The lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay.
It just said
Thank
Supreme Judicial Court says you have to read these verbatim,
All
which
right.
is a lie.
As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right. So I skipped the line. And when you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous an unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case. I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at Sidebar, but I'm required to see counsel at Sidebar.
Well, that was torture, wasn't it? Who thinks the jury probably didn't catch most of that? Anybody? I don't know. I've listened to a lot of jury instructions, and it's still awfully hard for me not to zone out listening to all of that. Guys, I have been checking the research extensively, because if she's going to tell the jury that the Supreme Judicial Court has mandated that I give you these instructions verbatim, I'm going to check the accuracy of that myself. And as it so happens, the model rules themselves say in its own introduction, these model jury instructions are intended to be just that, models. Judges have broad discretion and inherent authority to decide how to instruct a jury, whether it is by adapting these models, creating their own instructions, or starting with some other model.
May I?
Yes.
All right.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate?
Bye-bye, 6.
Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? Juror 8, could you step down and take your place as an alternate?
All right.
And the court officers?
Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God? Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
Go now.
Make sure to take your notebooks with you, please.
And now we wait. The notes on the foreperson, number 5, who was selected. He's sitting in seat number 1. Just like last time, the juror sitting in seat number 1 was the foreperson. A middle-aged black man who took no notes throughout the entire trial. But he has been observant.
I'm going to see counsel one more time.
One more time, huh? I guess we'll see about that. So juror number 6, Turtle Boy, posted a list of who his, he went down his juror preferences in order. Juror number 6 was at the very bottom. He's described juror number 6 as sort of having facial reactions, and he thought maybe she didn't like Ellen Jackson, but then apparently she's also making the same face at Brennan. So I think the conclusion was that she just maybe had a little bit of RBF. But 6 was the very, very last one on his list, lowest preference. 17, who is an alternate, was low on the list. 7 is an alternate, was low on the list. 8 is square in the middle. 2 is a little bit above 8. And then 13 was 4th from the top. So a pretty good mix if we just kind of collectively look at Turtle Boy's preferences and where we landed with the jury that we got. Foreperson number 5, he has 3rd from the top, his third favorite of the jurors. His favorites, 11 and 10, they are deliberating. So see if there is any additional record that they make before they hand it over to the jury. And then we wait. Then we'll wait. When I left off recapping Hank Brennan's closing, we were at the part where he was talking about her calling Carrie Roberts. And why did she change her story? She pivots to the story because she's shifted from panic to self-preservation. But these two normal moms, just normal moms doing normal mom things, went out to help because that's what good people do. So, where was Karen for the 28 minutes it took to get to Jen McCabe's house? We don't know, and apparently neither do you, Hank. It was remarkable. They couldn't see anything. John was like a buffalo in the snow. We heard that clip. So a cell record is not the same as a call detail record. Well, we know that. The jury knows nothing at all about call detail records. They haven't heard anything about that at all. There's no evidence that there was a conversation beyond the length of the call itself on the record. That's true. There's not. But then also the lying about it. All right.
It's the first thing is council this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory is not perfect, but I believe that we were going to have this redacted, subject to the same redactions in the last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time, so if defense
Okay.
wants to make that redaction, you can go into evidence.
Great.
I'll see if I have a Sharpie and maybe I can just take care of it.
I think we probably have one here you can have.
I definitely have one somewhere.
All right.
That's number one. And number two is, can council look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
We're going to do
You'll see
that
it's
now
not what
on the
you provided me
fly.
yesterday, Mr. Yanetti.
We're going to talk about that too, for sure. Because there were lots of lesser includeds, and I have all kinds of questions about that. As fabulous Emily might say, I have questions. I have questions. Cross long to find not guilty. Countdown begins.
Oh, thanks. Oh, Jesus. You sworn in first. Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, and that you not suffer any person to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse and then charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
All right, guys, I've added a poll. I'm afraid to be optimistic, so I am not betting on a verdict today, but I want to see what you guys think.
Is the Commonwealth content with the verdict slip?
Almost content.
So
They're still going over the verdict
Your Honor,
form.
I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yanetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury.
So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. We really ran into the same issue last time. I think what complicates it is the fact that there are two theories for two of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yanetti? I have not found any. I've looked.
I'm sure you looked real hard.
Case law out there, this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean,
So that's fine. So your rights are reserved. Does that help you?
right, well, all we can do is object, Judge, and you make,
Okay.
you make the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
We'll do.
Okay.
The last couple of things, Judge, is that we were provided with a clean
Laptop?
laptop, thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right, so
That's
we'll
going
send
back?
that in with the exhibits. I need to go
Ooh.
edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
So, thank
All
you.
right, thank you.
All rise for the court, please.
Well. A laptop is, in fact, going back with the jury. That's unusual. That's unusual. Doesn't normally happen that way. Guys, we got a pretty strong leaning in favor of no. No verdict today so far. Let us know what you think. I tend to be on the side of no verdict today. I would love to have a verdict today, don't get me wrong, but just can't think it's lightly. Well, I keep flipping around where I'm at in my pages. Forget where we are doing that recap. We were at the call detail record. So it's just remarkable because they see their best friend, John, there, lying lifeless right by the side of the road. It's a clip, it's a stumble, it's a fall. It was cold, hard ground. Dr. Wolf said that the cold, hard ground causes this kind of injury all the time. They found matching glass in the street. It broke at the time of the collision, but he kept the glass with him. The straw, how'd the straw end up? How'd the straw end up there? And I think more interestingly, stay there for all this time. Then the 911 calls happen, and the first responders, the heroes, the people that were born to help, they show up. And now Karen Reed has switched to I hit him. Now it's set in. She's realizing what she did. Now it's I hit him. Anybody who says anything adverse to Karen is a liar or a perjurer. Is that what we are supposed to believe? But their theory, all the evidence, the I hit him, I guess, doesn't reconcile with the boogeyman Proctor. But you have independent people who heard it. She tells you herself that she hit him. The truth has a way of seeping up. I couldn't help but notice when he said that. It has a way of seeping up, like in exactly the way that the blood here did not seep down, in exactly that way. Jen was just trying to help Karen, to tell her to shut up. The irony that the villain of this story is trying to keep her from incriminating herself. Then there's the battery temp. We look at the slide again. It shows it's 50 degrees at 1:36 in the morning, and it stays there until 6:06. It's suddenly down to 43. So it lost 7 degrees like instantly. And then by 6:14, it's down to 37. So it only lost another. Remember, it was losing 4 degrees a minute in the freezer with Ian Whiffen. But out here in the blizzard, 8 minutes, it lost another 6 degrees. Math doesn't math, guys. But Carrie picked up the phone. Karen was asking, look up hypothermia, and Jen McCabe is trying to type it in, but it's cold, and she's got her MS, and she's last night looking up the Hakamat Sports at 2:27, and she used that tab, and that's what the tab says, and it took Ian Whiffen just a 5-minute demo to show, not a click and a swipe like Dr. Wolf, who likes to do it. I got lost at this point. Absolutely no idea what he's talking about. I don't know. But now suddenly we're on to Look the Other Way, which was AJ's closing from the first trial. Alan Jackson's theme from his closing in the first trial, Look the Other Way. Hank is cribbing that, and it's really not clear why. I don't understand how Look the Other Way fits in with his theory here. It leads to one person, Karen Reed, not just the data, not just the facts, but her herself, which is, of course, what this case has always been about. The defense opening, they called Proctor a cancer. That's a really tough word, but he was responsible, and he should have been, because we're not here trying to justify those text messages, but it doesn't change the facts or the physical evidence. Guys, remember, Yuri Buchanan, he said the investigation was done with honor and integrity, but he wouldn't say, when it was asked about Proctor, he only said integrity. He wouldn't say honorable. And this honorable veteran there, Buchanan, that we got to see with ourselves, the honor with which he conducts himself, he wouldn't say Proctor was honorable. But it has nothing to do with justice in this case anyway. So there's not one piece we can look at and say this taillight was planted. We didn't need Proctor to prove the case. He didn't introduce the stuff until the defense made him. Like guys, my notes don't even make sense here because the argument made such little sense. I caught him saying, I didn't put this stuff in until the defense made me. Defense brought it up. Then I put it in. I did not understand what that was all about. Then there's talk of planting taillight, but we know that they didn't because nobody went to Dighton until later in the day. And we know that the taillight was already missing at 5:07 from the video and the welfare check, the photo of the taillight. Those can't be planted. And look at it. Look at this angle. It's gone. It's gone. So you have to ask, okay, 10 minutes ago, he's like, anybody that remembered I hit him is a liar. But now Nicholas Barrows, we have to ask what his interest is in this. Why would he say that? After driving out to the defense's hotel to get the subpoena. And he said he'd never said it before. He said he had, but it's in the transcript. Unfortunately, there's no Ring video from that morning. Yeah, unfortunately. Such a shame. There's no Ring camera video from that morning. But now they want to find a dog bite, so enter Dr. Russell. Oh, we got the second liar now. We got another liar. Barrows, now Russell. She volunteers for the job. She wants to be here, but she can't even tell us her methodology. She can just tell you altogether these things are dog bites, but if you look at it individually, she can't. And she says there aren't punctures, but then La Posada says there's punctures everywhere, that this is an animal attack. There's obviously no science to look at an abrasion and tell you where it came from. Then why are you trying to tell us it came from a taillight, Hank? There's no collision, they said over and over again. Scorty Bellow said they're not consistent injuries with the motor vehicle collision, but she only looked at the case for 90 days. She knows nothing about the data, the black box, the DNA, the shards in the clothes. That's not actually in evidence. And what was in evidence was that at any point they can go back and amend it if they get new information. That was brought out on cross. She didn't see any lower body injuries, but Arca showed you can have a collision without any lower body injuries. Thank you, Arca. So then he shows us the suspended dummy. He just can't make this up. The suspended dummy who's not actually standing on his feet. Look how he twists around. The expert's job is to assist you so that it's clear. I'm glad that he pointed that out. because I know who was clear and who wasn't. I still think back on Jessica Hyde and that just like rapid fire text speak that meant absolutely nothing. And I wonder what the jury made of that. And Welcher with the test that apparently nobody knows what it means, why he did it at all. How's that for wanting to clarify? But Dr. Wolf, my goodness, what expert has an order to turn over text messages and then deletes them? Okay, that I'm objecting to as well, because that's not the order. It's not the order, and you know it's not the order. You know perfectly well that's not the order. You've deliberately misstated that. He deleted them long before he got the order. Then, what expert uses Signal? The horror. Who uses Signal? He used a lower weight arm, and that's a basic issue, and he fought me on it. And then he admitted that they adjusted it, and that was all I asked for, was to find out whether he was adjusting it for like an hour. No, that is definitely not what you were asking, because he explained that to you multiple times, and you kept saying, but let's get to my question. Let's go back to my question. Dr. Rentschler knew when he came right in. There's a sequestration order, but he knew right when he came in to talk about the 50th percentile dummy. And then there was Dr. Russell on the ride over, where they ask, if he asked you questions, ask for a transcript. Rentschler, he said he was standing there in the corner with his ham sandwich until he was told he was on video, and then it changed. I don't know what you think changed. He laughed at you some more. And of course, Dr. Welcher never suggested his paint test was how it happened. He was just looking at if it's possible. He never did that. How bad faith to assume that the test that he relied on to support a proposition meant that he was testing that proposition. But inevitably, the timeline never moves. The date never changes. The physical evidence that can't be put there without a collision. There's proof with no doubt that Karen Reed drank, went to an after party. They were fighting. He had a brief window of life left. She couldn't let it go. She left him to die. We don't know exactly how it happened, but we have a good idea. And there's no doubt what happened or who did it. You just said we don't know what happened, but there's no doubt what happened. It's a very difficult task ahead of you. There's 3 charges. One that creates a plain and strong likelihood of death. Just have to show you'd expect somebody would die. You don't even have to show that she knew she hit him to get the manslaughter, but she left him there to die. We finish with John's photo. He's not an it. He's not a body. He's not a buffalo on a prairie. He's a person. He was murdered by Karen Reed. That was the conclusion. This was freaking chaos. Okay. This was so all over the place. Absolute mess. I mean, jumping here, jumping there. We were going to get back to the leaving the scene, but I don't think you ever did. I lost track of where we were going to jump to something else and then come back to it, because we didn't come back. We were just jumping all over the place. This has got me with a little vertigo in this closing. So very, very confusing, hard to follow, obviously very emotionally loaded. And so it just strikes me as this is for the choir. Okay. This is not to persuade anybody that's undecided, or to persuade anybody that's on the fence, because you haven't provided any way for people to connect the dots to get to A, B, or C. This is just an appeal to feels. It's an appeal to feels. And so if your feels are already in line with, I don't like Karen. Karen did it. I'm suspicious of her. She probably did something wrong. She sucks. Whatever. This was for you. That's all this was. Anybody who is not going to decide the case based on I like Karen or I don't like Karen, including hopefully this jury, really did not give them much at all to explain how any of this adds up to proof beyond a reasonable doubt. He didn't even respond to the key issue that's raised by the defense. How do you even prove there's a collision? He doesn't. because there's tail light all over the yard. That's basically his reasoning. There's a collision because there's tail light all over the yard. But we have actually no evidence of tail light in the yard at all. We have Proctor and Buchanan said so. They said they found some stuff on the yard. Actually, no, I guess we did have some photos. We had some photos of those little pieces right next to where the snow was melting. I guess we did have some evidence of taillight pieces in the yard. But then that was it. The overwhelming vast majority of it is not documented. We have no idea where it was. And sometimes it's in the general vicinity, and that's okay when it's Buchanan. But sometimes it's in the general vicinity, and that's like an unforgivable failing when it's Rentschler. So chaotic, absolutely chaotic. So we took the short lunch, had the jury instructions. Remember that whole thing about, listen real carefully because you're going to get a written copy. But if what I say verbally is different than what's written down, you got to go with what I say verbally. This is just, if this is the law in Massachusetts, what a ridiculous law and what a ridiculous standard. This is right up there with, if I tell you it's stricken, then it's not evidence and you're not to consider it. But then I'm not going to tell you what actually stricken is. I'm just going to be like that. Strike that. What the fuck is that? It's literally setting them up to not be able to follow this. I just couldn't help but notice that with the instructions. Guys, I have to fess that like everybody else, I found it hard to keep my eyes open through all of this. The only ones that I kind of made special note of, the elements. You think the jury is going to hear that first one. It's drawn straight from the indictment that she charged that she did assault and beat John O'Keefe with intent to kill him. That's what the indictment said. But now the case that Mr. Brennan is arguing that he wants him to buy, nothing to do with intent, nothing to do with assault and beat John with intent to kill him. She tells them the Supreme Judicial Court has promulgated instructions on homicide. I have to read them verbatim. No, you don't. I literally just read the model jury instructions themselves. This is like the cover, the introduction, the cover page. The model jury instructions are intended to be just that, models. There's also this statement that the Supreme Judicial Court issued in April of 2018 when they modified the model jury instructions on homicide. They updated them after the first one was issued in 2013. And they say in this statement, we recommend that the judge use the language of these instructions unless a different instruction would more accurately reflect new developments in law or would better describe the law in light of the particular facts of the case. Like, I don't know if nobody's disputing certain prongs, facts of the case. Go ahead and modify it. It says right there in their statement. So I spent, while she's reading the instructions, I spent some time over there in the case law trying to look for any indication at all that there's like ever been a case in Massachusetts where they say you have to, it's mandatory to give these model instructions on homicide. No, there's nothing. So if you're wondering why Bev maybe isn't so gravely concerned about Hank's lies to the jury, she literally just did it herself. It's a lie. She does not have to read them verbatim. And it's ironic that she even says that because then in the course of reading, she doesn't read them verbatim. She goes ahead and takes stuff out. She's like, oh, you've already heard these elements, so I'm just going to focus on this one. Well, then you're not reading the instructions verbatim, are you? The judge selects the foreperson in Massachusetts. She picked the first chair, same as she did in the first trial. That happens to be juror number 5. The middle-aged Black man was very attentive throughout the trial, but he took no notes at all. Then the alternates were pulled from the little barrel thing right in front of us. They didn't show us the number, but we did at least see that being done in open court. The jurors 13, 7, 6, 17, 2, and 8 are the alternate. Then we want counsel to review the verdict slip and state their objections on the fly. Okay, on the fly. Apparently couldn't have been provided to them last night or earlier or whatever. Last minute jury instruction here. And the defense is naturally concerned because on count 2, with all of the lessers, there are 7 options for guilty, 7 ways to put guilty on the page, only 1 for not guilty, arguing it's too confusing. It's the same issue as last time. It's complicated by the fact that there's multiple theories for the 2 lessers. And what does Canoni say? Well, do you have case law? Where's your case law, Judge? Where's your case law? Because I got the introduction to the model instructions right here, and I've got the statement from April of 2018 of the Supreme Judicial Court saying if it'd be more accurately reflected the law in light of the particular facts of a case, go ahead and give a different instruction. I got that. What do you got? What do you got? Just got nothing. But your rights are saved. This instruction hasn't been challenged or criticized or whatever. Not yet. I loved that answer. Not yet. Not yet. It hasn't. That's right. It's all fine until they say it isn't. But if you find some case law, let me know. They have a clean laptop that is going back into the jury room with the jury. That means they will be able to watch all of those digital exhibits, the videos, all of those things. They'll be able to do that themselves back there in the jury room. It's different. Certainly happens some places, but most of the time you're getting called back out in the courtroom, and then they're monitoring and they're watching very carefully. I'll pay it back. I'll play it back for you 1 time, but I'll play it back for you 2 times, but not more than that, because we don't want you to focus on that unduly. Well, they're going to be able to look at it as much as they want and do whatever they want with it back there. And so now we wait. Now we wait. What is it? It's 3:11 over there. She asked them to stay until 5 or 5:30. So they got about a little over 2 hours. A little over 2 hours. That would be pretty fast, guys, to get done today. That would be awfully fast. Still a really strong preference in the poll for no verdict today. I do tend to agree with that, but we will see. We'll see. So, guys, we got a lot of stuff in the queue. We got a lot of things to talk about to go ahead and keep us busy while we wait for this jury. Jeff went out and took care of the trees for me, so we should be in good shape. During that instructions reading is intolerable. My eyes are drooping just like everybody else's. I did get up and walk a minute, took a few steps, so all a little bit better. L'enfant, I was listening to Andrea at work on loud Wi-Fi speaker when she made those infamous comment at HK's. I don't know about thrust. Well, I hope your entire work site enjoyed that little your mom joke. Surely they would, right? I mean, if you're at the kind of job where you get to listen to stuff on a loud Wi-Fi speaker, then surely you're at a place where they'll appreciate a good your mom quip. Dino Tink, John O'Keefe's BAC has never really been talked about. It would affect balance, bleeding, body cooling, thoughts. It hasn't been a focus for sure. It's come up, but really just as kind of an afterthought. what was it, 0.28, something like that. I mean, it was high. It was high. You know, no retrograde extrapolation on John. But it was quite high. And yeah, it would affect balance. It would affect reaction time. It would affect perception. Bleeding, I guess it would. Yeah, for the same reason it would affect the cooling, because it's a vasodilator, so your blood vessels relax. I guess if your blood vessels relax, maybe you bleed easier, maybe. Not sure, but you know, my thoughts about it are really, it's just one of those things where if you're not going to focus on it, then I don't know why we even brought it up. You know, why is it even in evidence? If it's not a piece that we need to know that's going to be tied together to something, then why is it even in evidence? Just for curiosity? I'm not sure. It just kind of speaks a little bit to you know, how you put a case together. If this were a more tailored, more tight case, we wouldn't have heard anything about John's BAC, because at the end of the day, sitting here having listened to closings, apparently it didn't matter. Doesn't matter. So why is it even in evidence? Not clear. Those are the kinds of things I worry about with the trial, because those are the kinds of things that you have no idea if the jury is going to put massive significance on that or not. You have no idea. And you haven't directed them what to do with it. So whether it will mean anything at all, who knows? L'enfant. But the funniest and favest of the day was her "This isn't your fantasy" about shoes and book face laps. Oh my God, it's starting by. The high heel, little fan. Like, where does that even come from? He was this, I mean, my impression, sometimes you're dealing with stuff on the fly. This surely was not an example he thought of ahead of time, because he would have thought of a better example. Wouldn't he have thought of a better example ahead of time? A book versus a high heel. So where did he get the idea of the high heel? Is he over there staring at Karen's feet the whole time? Ooh, that. Ugh. Don't even want to think about it. Rabbit Heart. Is her interference in the jury process a reason for appeal or judicial misconduct? Not that I can tell. I mean, she's doing it. She's doing it with, you know, within the discretion that the law gives her. The law, it's Massachusetts law that says she gets to pick the foreperson. It's wild to me. Seems like there's some room for bias to enter the whole calculation there. It's just unseemly to be involved in that, to be handing out, delegating that kind of authority in the jury room. But the law gives her that authority. So otherwise, I mean, she hasn't really messed with the jury. We haven't had any jurors dismissed this time, which is really amazing. You know, 33 days and we still have all 18. Nobody got sick. Nobody had a kid get sick. Nobody had an emergency come up. Kind of astonishing, really. So she didn't mess with that, but you know, everything that she's done so far really has been within the lines, within what the rules allow her to do. Z, is transparency denial appellant issue strong? Probably not, because once again, it always comes down to harmless error. If you don't have a structural error, something that's fundamentally wrong with the process of the trial, then you typically got to show it's harmful. And so what's the effect? We don't know, because we don't know the counterfactual situation. If it had been done where the numbers were turned around and shown to us in public, would that have affected the outcome? We don't know, because they didn't do that. It's a real catch-22, those types of issues. Very similar with like ineffective assistance. They don't do something, don't call a witness, don't investigate, don't ask a question. It's your burden as the appellant to go and show, well, what would the effect have been if they had? And you'll never know because they didn't do it. So no, probably not a strong appellate issue. I was thinking about it at the top from the standpoint of the public right to a trial. But I have no idea if this would be considered, part of the history and tradition of the trial that the public normally gets to attend. I'd be inclined to think so. Jury selection in general is. I don't know why alternates wouldn't be. But I think the counter argument would be, well, you got to sit there in the courtroom and watch him do it, so it's fine. So no, probably not an appellate issue there. Sabina D, is there any argument not to do it in public? I don't know, security reasons or something? Does she have the smallest argument for it? I really can't think of one. The only one I can think of is just, you're not going to tell me what to do. That's it. What possible reason is there to not do all of this out in public? I can understand, okay, you don't want Karen to draw him out. It's too theatrical or something. Maybe you envision there's some security issue with that. She's got fake ones up her sleeve, whatever. I can see leave that out, but the rest of it? The rest of it doesn't seem to be a problem. I appreciate that they did the whole, barrel rolling thing in open court. All it would have taken is just turn the number, just verify that's the number. I don't know why we can't do that. I really think it's just she won't be told what to do. She won't be told. She's the boss in there. Don't you know about her authority? But if I order you. Alleged Drake. Did any of the experts talk about the Lexus data rear safety systems? The LX is equipped with rear cross pedestrian traffic. It would beep and brake if the system was active. TechStream data would show this. So all that we got about this was from testing, from vehicle testing, where we were told there was no autonomous braking. That's all the information we were given. We weren't told about any kind of like backup systems, warning systems. Nothing like that. Just no autonomous braking. So if there's more that would help either side, it got left on the table. I've heard so much. I had and now I'm trying to remember. It's been so much information over the last several weeks. I have, people send me messages. I get tagged in stuff on Twitter and stuff like that. It's hard sometimes to keep track of where I see different people saying different things. But I do remember a comment I got or I heard or something from somebody who was a Lexus owned a Lexus dealership. Had a lot of similar things to say about the Lexus and the features on the Lexus and so forth. So it does make me wonder, but we didn't hear it. We didn't hear it at the trial. 45 state PE. Andrea, do you sell any of your bonsai trees? I have a koi pond lacking that. I haven't sold any of my bonsai trees. Do you want one? we can talk. My trees honestly are not that great. They're very mid. Most of them are in development. I've got some excellent material, but they're not like actually a really good tree yet. Hopefully, fingers crossed, but it takes some years to get a tree developed well. So if you want a nice tree, honestly, you're probably best off, number one, near where you are. Try to find a nursery just because it's already going to be acclimated to your climate, your water. These things make a big difference. We, as I've mentioned before, have an extremely arid, dry, hot climate here. It's very hostile. It's also very alkaline. Our water is very alkaline. So these are all things that, will affect the soil, the chemistry, the life in the pot, and the plant will need to adapt to that. Some of them will do a better job than others. I can barely grow an azalea in the ground here, like let alone in a pot. Azaleas like it's very cool, very humid, very acidic. just like exactly the polar opposite of what we have here. So really your best bet is going to be to try to find a tree that is near you that's already adapted to your conditions, and just, you'll already know it's a type of tree that works well. I don't know where you are. You know, if you're down in Florida, I'm not sending you my juniper. Okay. My juniper will die down there. Juniper needs a cold winter. You're not going to have that. But down there in Florida, you could have like a nice ficus or a Fukian tea, or some of these nice tropical plants that get used for bonsai sometimes. I don't use those. It's not tropical up here. So just a lot of variation that can come into play. So do keep an eye out, though. If you want to shoot me a message, let me know where you're at. I'll see if I could help you out, find something nearby. Bonsai trees are nice to have around the koi pond. I would like to have a koi pond, but not there, not yet. Jesus freak, if drive is entered evidence, why can't use it all? Anything that has been entered into evidence should be able to be used. So I don't know. It looks like what happened is everybody walked into court this morning knowing they were going to put on a presentation, hadn't showed it to the other side. So everybody had to go take a look at everybody else's presentation and make sure it was going to be okay and not objectionable. And maybe they had to go and tweak things. You know, I don't know. I just know it took an hour and 15 minutes that it wasn't supposed to, because literally every single one of us knew we're not getting started at 9. But Bev thought she knew better. Alyssa Ramirez, Andrea, Brennan reminds you of Binger, not an actor. I'm pretty sure of it. So I did not watch the Rittenhouse trial. I mean, I saw bits and pieces of it, but I didn't sit and watch that particular trial. So I didn't get the full flavor of Binger. His hair, you know, I got his little swoop thing, his little Binger hair. But other than that, I didn't really get a feel for the flavor, the attitude, the character. Just trying to think if there is anybody else that I could think of high profile that Hank Brennan reminds me of that isn't an actor. And the only person I can come up with, honestly, is just like a malicious George Bush Sr. A similar voice, kinda. I don't know. A lot of stuttering too. I mean, I don't know if he's got a speech issue. I don't certainly blame him or hold it against him or anything like that if he does. But it's just noticeable when it comes out. If it is, you know, it's not consistent. It only comes out when you're trying to say things like reasonable doubt. That's a little bit amusing. Catch what he chokes on. I'll take your word for it that he's a Binger type. Attitude wise, yeah, he's probably a little more slimy and snake-like and malicious than the majority of prosecutors, but there's plenty of them like that out there. So if he's like Binger, wouldn't surprise me. Carolyn Smith, you do such a good Bev impression that you could definitely have a career in comedy if the law thing doesn't work out. Haha. Thanks for the amazing and informative stream. Well, thank you for that. I am not in a rush to go be a comic. Honestly, guys, I'm not looking for a job at all. We just have fun watching trials together. I've been blessed by serendipity to find myself on YouTube, and apparently so many of you like watching this with me that it's like it's worked and it's become a thing. So we're going with it. We're seeing where it goes. We're just gonna roll with what the fates hand us. So it's really the only plan right now. Not looking for a job, but I'll take that in mind. I appreciate that. I don't know if I would write very good jokes for comedy, but surely there would be a tolerance to your mom jokes and Bev impressions. DPAT. A jury plant triggers a hung jury. State makes an announcement to not retry the case. This is their off-ramp in order to not answer the real questions of corruption and police misconduct. The problem with this, though, DPAT, we've been talking for several days about the 1983 action, the civil rights case, civil claim for violation of rights. And that comes with discovery, with civil discovery. And number one, very first thing that Karen has to show if she's going to sue anybody civilly over all of this is a favorable outcome favorable to the defendant. If they just walk away and don't retry her, she's got a favorable outcome. So their number one way to stop the questions being asked, take it off the table, don't open up civil discovery, is to get her convicted. This doesn't give them the off-ramp. It doesn't give them the off-ramp. It maybe takes it out of the public eye and maybe gives them hope. Maybe if we just quiet down, it'll all die away. But it doesn't take away the actual legal ground that Karen needs. If she wants to file a civil suit and get discovery and keep asking questions, this doesn't take it away. L'enfant. Is it weird to have a juror who never took one note during 7 weeks of trial, like juror number 1 here? P.S. I'm joined again. All good. Good. I'm glad you made it back. It's not terribly unusual. There's plenty of jurors that don't take notes. Not everybody is a, I've shown my notes so many times, and part of the reason why is because that helps solidify what I hear and what I think. It's like literally part of the process. It's not even so much. It's helpful to have as a resource to go back and look for it, especially if I'm going to like come and try to do a long recap or something like that. But that's honestly really a side benefit. It's the act of writing it for me is helpful to the whole cognitive process. Not everybody is like that. A lot of people are going to find trying to write is distracting. It's dividing your attention from being able to pay attention to what people are saying and listen to it and take it in. So it's not really that unusual for there to be jurors that don't take any notes. It's just that isn't part of their process. That's not how they learn. It doesn't give me any particular alarm, really. AHAP. Through this entire case, it feels to me like the roles are reversed. Commonwealth is putting on a defense, and Karen Reed is in the prove innocence protection role, prosecution role. It's just another bizarre layer. We noticed this in the first trial too, that it was even more, I think, explicit in the first trial, that they really ran it like a defense of the folks inside 34 Fairview. It was less proving that Karen Reed did something wrong and much more about proving that those people didn't. They did nothing wrong. Similar theme here. I mean, I don't know how you prosecute a case and say, get up on your closing and say with your whole chest, we don't know what happened. We can't show you. The evidence can't tell us exactly the details, but we just know it happened. Really don't know how you get there and think that you've met anything like a burden of proof. The way that Hank has conducted this case throughout, the raising the questions. Well, Dr. Welcher, he doesn't know how this happened. If he doesn't know how it's happened, then how are we supposed to know how it happened? And why did we listen to Dr. Welcher in the first place? If he doesn't know anything, then why did we even have him on? Why did we even listen to him? Oh, that's right, because you needed to put your finger on the scale with all of that unscientific stuff. He doesn't know that there was an accident because of biomechanics and accident reconstruction. He knows it because of the witness statements, you see, and the DNA on the taillights. It's just a crazy situation we're in, and the fact that it's been so facilitated and enabled by the judge is that's really the alarming part. It's an adversarial system. So I kind of expect prosecutors to be, major dumbasses from time to time. They have to. They're being advocates. They're in a terrible position. What are you going to do? Prosecutors aren't necessarily used to having to argue a weak position. Okay, defense attorneys, a little more practice with that kind of thing. But the judge, for the judge, it's inexcusable. Because you're not an advocate. You're supposed to be there to just call the balls and strikes, enforce the rules of the game. The rules of the game are supposed to be, scientific. Methodology is required to come in and offer a scientific opinion. But when Dr. Welcher wants to get in and say, there was a car accident, just doesn't have anything to do with my science because of unscientific reasons. No, sorry. It's just unbelievable that this type of thing is allowed by this court. That's not being a gatekeeper. That's not applying the law. It's not enforcing it. It's really contrary to it. I don't know how much of that is Hank, because Hank is a defense lawyer and that's just what he defaults to and what he's used to, raising doubt, asking questions. I don't know how much of that is him. And how much of that is just because this is such a weak case, they don't have answers. They don't have answers. They can't answer the questions. I really don't know. Kathy, your realtor living in New Jersey. Is there truth to Brian Albert having his arm in a sling the day after? I don't know if there is truth to this. So I have seen, there is a photo that goes around that's got Brian Albert with his arm in a sling. And I want to say it's like a week later, maybe 10 days later or something like that. It's a photograph at a bar. And as far as I know, there was some suggestion that he was out for surgery. He went out for shoulder surgery or something like that. So it's really not clear that it's related to anything. I don't think the bottom line is we have no idea what Brian Albert's condition was the day after because none of us saw him. Proctor did. Lank did. Those guys did. Didn't tell us anything remarkable, but not sure that they would tell us anything remarkable. So that's all that I know about Brian Albert having his arm in a sling. There was some photo going around, but I don't think it is contemporaneous, and it seems like it might be an unrelated surgery. Jilly Bean, will you be covering the Koberger trial in August? Love your channel. I will indeed. Just talking about that at the top. Not quite sure yet what my format's going to be. I still got to kind of think about it and figure it out because I do plan to be there for some of it, but I'm not sure if I want to be there for the whole thing. I don't know. Still working through it. But yes, I absolutely will be covering the trial in one format or another. Sarah, how to become a member and gift memberships from iPhone, iPad if can't on app. Use Safari, not the YouTube app. Bottom left-hand corner, hit the 2 AAs, then request desktop site will show join button. Sarah, thank you so much for that step-by-step, very clear and easy directions to follow. Use Safari, guys. Don't use the YouTube app. I know on the YouTube app, this is a common problem with the iPhone. For some reason or another, it doesn't have the little join button that you have on the desktop. So if you do that through the Safari app, you can join. Thank you so much, Sarah. Appreciate you making that easy for everybody. Kathy, your realtor living in New Jersey. Have you seen your likeness in the funny allegedly posts? I don't think I have. Do I have a doppelganger that I don't know about? I don't think I have seen that. What's funny allegedly? Don't think so, Kathy, but not totally sure. There's so much flying around right now. Just as a heads up too, like guys, I can't, notifications are like not a thing right now. I get tagged in lots of stuff. I get too many things going through right now to be able to track that. That will calm down once this trial is over. It will be very calm, and then send me whatever you want, and I'll probably have a pretty good chance of seeing it. But when we're in the thick of stuff, I don't always see everything that everybody sends to me. I do try. I do like to see what folks are talking about and stuff, but I definitely don't catch everything. So can't say I have seen this one or not. Super planner girl Amanda, you should use a fountain pen. They help with speed and hand pain. Also, thank you. You have been so great. Thank you, super planner girl Amanda. If you weren't here with me in Delphi, you don't know about the great pen, the Great Pen Challenge. You see, I have been a decades long fan of the Uniball Vision Elite pen. I have used it for years, decades. I love it. The bold pen, it's got nice smooth ink and stuff like that. Well, I ran out of pens in Delphi. I had to go get more pens, and they didn't have my Uniball Vision Elite. I couldn't get it. I had to get other pens. I had folks who were very kindly and generously helping me out with pens. And Amanda, we discovered the Sharpie S Gel pen. Okay. And this pen, this is my new favorite pen. This is why, here's just, you've seen all my pads. These are some of the pens that I've gone through over the course of this trial. A little handful of dead pens. We settled on this pen. I really love this pen now. I still prefer the blue. This one is a black. I don't love the black, but I'll take what I can get. So anyway, we did a very comprehensive test. All different kinds of pens and stuff. The Sharpie S Gel, I'm just telling you, is where it's at. It's a great pen. It is not a fountain pen. It is a rollerball pen, but it works great. I haven't had any hand pain or anything like that. Really enjoy it. DPAT. Andrea, with all of your success during this trial, are you going to jump into another live trial right away? I am not planning on it. Definitely not planning on it. And guys, if you're new to the channel, that's not my routine. It's just, this is very time consuming. It takes a lot of time. We put hundreds of hours into watching this trial, gavel to gavel. And I've reached a point in my life where I have much more appreciation of the incremental value of time, and how the more time that goes by, the more valuable what you have left is. Really important to go out and have some life. I'm not somebody who likes to live online or even really sit a lot. Like I've sat so much in the last couple months. I'm not complaining. It's, I undertook to do that. I knew that was going to be the deal, but I'm not looking to really continue that just because. I'm not looking to have a YouTube channel just to have a YouTube channel. I'm not looking to talk about trials just to talk about something, So when there's something new that catches my attention, something big that I want to follow and put this kind of time and energy into, I will. Koberger is definitely going to be on that list. Some of the other ones I've been watching, I'm very interested in the Long Island serial killer. That case to me is, it's like the anti-Koberger case. If you take those two probable cause affidavits and hold them up side by side, it just... To me, it's a massive illustration of the difference between a strong circumstantial case that is built on solid, conventional police investigation techniques, corroborating on all kinds of different levels. In the case of the Long Island serial killer, any particular killing, they've got his calendar, they've got his date, they've got location data, they've got DNA for a bunch of these things. They got communications. They have so many layers of corroboration. And then compare that to Koberger, where very, very, very thin circumstantial case. Very thin circumstantial case. So very interested in Long Island serial killer. Interested in Matthew Farwell. Definitely interested in Matthew Farwell. Saw a big development with that one yesterday. Not that it really matters for the trial. Turns out apparently he was not the father. Went through all that, went to those lengths, wasn't even the father. But it doesn't really matter from the theory of the case perspective, because if he thought he did, that's really all that matters. It was his motive to go and kill her. So I'm interested in those, but those are definitely not right on the horizon by any stretch of the imagination. Koberger would be the next closest up. We'll see where we're at Monday. We got a hearing on the motion to continue Monday. I might live stream that if we're not in the middle of, maybe getting a verdict or something like that. But not saying we are, but just, things happen. So we're going to play it by ear. So no, the long answer to your question, Deepat, probably going to take some time off. Maybe go do a little hiking, go do a little camping. We're kind of in that season here. Oh gosh, that was the other. There's the case up here that some of you guys may have been following. It came out from Wenatchee, the Travis Decker situation. So really terrible case with some children, some young girls found murdered. They're on a manhunt for this guy, Travis Decker. He's the father. And they're saying he could be anywhere in the country. But simultaneously, they've shut down North Cascades National Park for some reason. So they're looking for him there. So you're not allowed to go to North Cascades right now. It's like a misdemeanor to go to North Cascades National Park, which is a little bit of a bummer. But if he's up there, I don't mind. It's just, I'm like, why do we think he's up there? Simultaneously saying he could be anywhere in the world. Anyway, he's a former Army Ranger, I guess. And so that's another case I'm just kind of aware of, but it isn't actually a case yet. And it may ultimately never be a case, because if they don't get him alive, there won't, of course, be a criminal charge. But anyway, just mentioning that because wherever else I go, it probably won't be to North Cascades. But that's my short-term plan. Get a little bit of time in, some time outside, some activity, some good life stuff, and then come back. I do have the Substack as well, which I don't want to forget, because we've been like super focused on Karen Reed for the last 2 months, and it's kind of sucked out all the air in the room and all the time and every day and so forth. The Substack is definitely a place where it's much easier to do things that aren't so time consuming, that aren't so, attention demanding. I do a lot of reading stuff and thinking about stuff, and Substack is a great way to be able to just put some of that thought in writing, maybe do like a one-off video or something like that. So I do expect to probably be more active on the Substack before I'm back live streaming another trial. So you can keep an eye on that if you are so interested. I see Christina Rex has our verdict slips. Let me go ahead and pull those up. Okay, here it is. The very first one, this is easy enough. Murder in the second degree, guilty, not guilty. Well, not guilty, guilty. Easy enough. This one, look at this thing. Look at this thing. Not guilty of the offense charged or any lesser included. Guilty of the offense, one of these other prongs. Guilty of the lesser included. Guilty of a different lesser included. Guilty of yet another lesser included. Okay, the lesser includeds. Let's talk about this too. I am just very confused about the lesser includeds, who asked for them, and why are we instructing on them at all? So I went and looked, because my recollection from yesterday, the Commonwealth said very specifically they were not requesting the lesser included. So then I'm thinking, well, then did the defense request them? That would seem a little weird to me to request all of these lesser includeds. I could imagine a situation where we would just ask for the operating under the influence. And then we could tell the jury, look, she did that. We're not going to fight that. She did that. But she didn't hit him with a car. Real easy. Find her guilty of OUI, send her home on everything else. Should take you 5 minutes. But that's not what they did. So who even asked for these lesser includeds? Bev in her discretion, in her instructions makes it sound like this is just a thing that happens by operation of law. By charging you with a greater, you necessarily charge all of the lessers. That's true in an abstract sense, but it doesn't mean that you instruct on lessers every single time. So I wanted to check that in Massachusetts law, be like, is there some weird thing in Massachusetts where like the jury is always going to get all of the lesser included offenses, even if nobody asks for them? So I went and looked. There's a statute that says the judge must, on request, charge the jury concerning a lesser included offense if the evidence provides a rational basis for acquitting the defendant of the greater crime charged and convicting on the lesser included offense. On request. And then what I'm looking at here is, I'll show you guys this now. Switch over real quick. Where did I go? Lost my tab. We'll switch over to this real quick and then we'll go back to Christina's. This is a form instruction from the district court. Form instruction, lesser included offenses. See, it's got all these notes on the case law. That's what I'm looking at. Even if supported by the evidence, let me get this big, nice and big, nice and big. Even if supported by the evidence, such an instruction is not required if neither party requests it. You don't have to give it if any party requests it. But look at this, guys. If the judge is inclined to give such an instruction sua sponte, neither the Commonwealth nor the defense have any right to object to the instruction in order to pursue an all or nothing strategy. But neither does the judge have any duty to undercut it by giving an instruction. Judge can do it on her own. That's all I'm coming up with here, guys. Judge decided on her own because the Commonwealth said very clearly we're not requesting it. Doesn't make any sense to me that the defense would be requesting these. I didn't hear them request them. It's not really logical that they would request them. So think about that. Think about that. Sua sponte, judge can do it. They have no right to stop her. Huh. It should tell you something. It should tell you something because what it tells you is that the judge is more interested in seeing Karen Reed convicted of something than the Commonwealth is. That should tell you something. This verdict slip really is tiny, isn't it? I don't know if you guys can even really see that, but I can't really make it bigger. Let me do this instead. That works better. That works better. Now you can see it. I mean, look at this thing. This is what David Yanetti said. It's confusing. There's 7 options for guilty, 1 option for not guilty. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. It's actually 10. 10 options for guilty. Only 1 for not guilty. It's confusing how they fill it out because they're supposed to, she's guilty of this one, but under which prong, which are both, which one or both. Does look a little bit confusing, doesn't it? Start at the top and work your way down, she told them. Start at the top and work your way down. So start with not guilty. How do you start with not guilty? I mean, you start with not guilty as the presumption, don't you? You start with not guilty as the presumption, and then we wait to see if the Commonwealth has proved any of the elements of the charges beyond a reasonable doubt. So we really have to work through all of these and say, no, they have not overcome this burden before we can check that. Just found that a little bit strange because it almost sounds like, I mean, she's not giving instructions, but I'm trying to put myself in the shoes of a juror who's seeing this for the first time, doesn't really know what we're doing, has received all of these complex and often confusing instructions, and they've been really boring. And so some of the details have not stuck and all of that. And how am I going to handle this? And if I see that and the judge has told me, we'll start at the top first, I might be thinking, well, has she proved she's not guilty? That's how I might be thinking about it. If I don't know. I'm a jury. She told me to start at the top. How do I know if she's not guilty without working through all of these first? I don't know. So just a point that David Yanetti did make that I thought was a pretty good point. And then we have this third slip, also very straightforward, leaving a scene of an accident resulting in death. Oh, that last one that we saw, by the way, still has the problem that it had in the first trial, which is that let's say they go through and they find that she's not guilty of manslaughter. She's not guilty of involuntary manslaughter. We can't decide if she's guilty of motor vehicle homicide. There's no way for me to indicate that on this verdict form. But if I find her not guilty of these, she should be acquitted on those. But there's no way for me to indicate that on this verdict form. I can only find her not guilty of everything. So I don't like that. That remains problematic from a double jeopardy standpoint. You could have acquittals here. You could have unanimous agreement that she's not guilty of these lessers, and there's no way for them to enter that, no way for that to take legally binding effect. So I don't love that myself. Really don't love it. It's the same problem we had last time. That's why Mr. Yanetti asked that she fix it. She's refusing to fix it. Why? I don't know. She just won't be told how to do it. She's going to do it her way. Mine's been upheld so far. Yeah. And theirs would be invited, Bev. Theirs would be invited. She just has terrible appellate judgment. It's really remarkable. The stuff that she thinks is important and the stuff that actually is, these do not line up really very closely. Matilda, thank you, Andrea. Your insight and dedication through this has been amazing. I appreciate you, FKR. Thank you so much, Matilda. It's been awesome having such a good, insightful crew here. So many times when I'm like trying to remember the details of something, I can't throw it out there to the chat. You guys got it. You guys got it like that. It's been a wonderful experience for me too, and that's why we like doing this. This is a good way to watch trials. Watch it together, take it in, have our group feedback and processing. And the best thing of all, we're not alone, guys. When they gaslight us, try to make us think we're crazy, try to make us think we're stupid, we're shameful, all of those things, all of those weapons that get wielded. How dare you? You defend murderers. Mm-hmm. That's right, I do, because even murderers are entitled to a fair trial. Because if we don't give them that, we're no better. We're no better. So I appreciate all of you being here with me as well. Thanks, Matilda. AK, I would love for you to go there and do it that way instead of live streams, but I'll watch no matter what. Well, I'm definitely going to start that way, for sure. They're not going to live stream the jury selection anyway. So, might as well be there for that. Appreciate the thought. I'm definitely going to think about it. See, the thing is that it's going to be on TV, so everyone can watch it. There's going to be a lot of people. There's going to be a lot of people streaming that trial. There's going to be a lot of different ways and a lot of different input to be able to follow it. I know it's not the same. But I just have to gauge, I think, if the upside, the benefits from being in the courtroom are worth the trade-offs. So I haven't fully decided, but I gave you a little bit of a kind of insight into my thought process about that. And the big factor at this point, yeah, it's nice to see the jury, but I don't, I'm very skeptical of what you can take away from that anyway. It's mostly about the evidence that they're not going to show on TV. You're going to have to be in the courtroom. You may not even see it in the courtroom, honestly, though. But I can already imagine someone's going to be like, "Oh, Andrea, can't wait to go look at the gory stuff." No, I've seen plenty of gory stuff in my day job. I don't need to rush and see the gory stuff. It's because the details matter. That's why that evidence is really important. The details matter. And just not clear, given the circumstances of that case, that we watching at home are going to have a clear picture of the details. So that's my main reason for wanting to be in the courtroom on that one. Got to think about it. Appreciate your input on it. Danielle C. Question: how would one go about getting coverage of a trial at all if you can't go yourself? Not high profile, just personal. You would have to check and see if there's local news or something like that. But the overwhelming majority of cases go right through the court system and nobody notices, nobody pays attention. Nobody's there watching. Most trials go without any kind of media attention or something like that. And then you'll have like degrees of profile that it might get locally. If you got a murder in your community, it might not be national news, but it's could be big local news. Depends where you are. You're in Boston, maybe a murder is just another day. You're out here in rural Eastern Washington. Murders don't happen all that often, so they catch your attention when they do. Otherwise, you're probably going to be recreating it after the fact. You're going to be going and reading the court file. You're going to be going and requesting the exhibits. You're going to be buying transcripts. It's probably, spending hundreds, if not thousands of dollars to get the transcript of what happened in the trial. That's the record. If you don't have somebody there taking the notes, reporting back, you don't have the cameras in the courtroom, you don't have the feed, then you really don't get coverage. Hap, I just want to see you cover the Adelson trial. You remind me of the Assistant State Attorney Georgia Kappelman in the Charlie trial. That's interesting. I haven't watched any of the Adelson trials. I'm very, very vaguely familiar with them. And mainly what I know about them is because way back, like a gazillion years ago, when I used to be more interested in politics and stuff than I am now, it's got to be like 15 years ago now. I used to read Instapundit a lot. I liked it. It's just a good aggregation of all kinds of different news and things like that. And so Glenn Reynolds would talk a lot about the Adelson. Dan Markel's killing. He talked about Dan Markel's killing because he was on it way before anybody had ever been arrested or charged or anything like that. So I kind of remember it just from that context, from before it even was a case. And then the case was filed and went through the courts, and I really didn't follow it. She seems like a lunatic, She's just got some, I don't know, sort of entitlement, I guess, about things that doesn't necessarily sit very comfortably with me. I don't know what or how or to what extent anybody was involved, but obviously we have one conviction, and Isn't it the wife? The wife has gotten off so far. No charge on the wife. I don't know. Okay, I'll keep it. I'll keep it on the radar. Maybe I'll pay attention. Maybe I'll keep an eye on it. And look and see when that is. In June. Oh my goodness, that's coming right up. Goodness, in June. Unlikely, but I guess I would say depends on how long it's going to be. Oh wait, no. This says it got moved to August 19th. So if it's in August, it's going to conflict with the Koberger trial, at least as long as Koberger continues to go forward. So we'll play it by ear. I'll keep it on the radar. No promises. But it is one that is not completely foreign to me, but I definitely don't know a lot about it at all. Clinton Hall, how you doing, Clinton? I got to see, yeah, you did. I got to witness Andrea's note-taking in Delphi. If Aunt Bev took notes like Andrea, this trial might have ended back in April. I've seen efficiency, Your Honor, and it had a legal pad. Well, thank you, Clinton. It also had a really comfortable thing to sit on in that hard seating that we had there in the Delphi courtroom. Clinton was there for the first bit, and he had his little seating pad that he wasn't going to need anymore. I didn't even think to bring anything like that. So what I had was I have my puffer coat, my Patagonia puffer coat, because it was getting cold and we're sleeping out on the street at night to get in the courtroom. So I had my puffer coat, and it comes in a stuff sack, and so I was sitting on my puffer coat in the stuff sack. It was not particularly comfortable. The seating pad did make things a lot easier. You really facilitated the note taking, Clinton. So I thank you for that. Appreciate the kind words. Good to see you still around. Nikki Kadia, go to court on important days and stream, rest, do both. That's true. You can do both. You might have noticed I got a little bit of a perfectionist kind of mindset about stuff like this. You know, if I'm going to start the trial, I'm going to finish it. If I'm going to watch some of it, I'm probably going to watch all of it. I don't like doing things piecemeal. I was always one of those people that, you start reading a book and it sucks and you hate it. And I just would make myself finish it. I have to. The very first book I remember where I broke that, I made myself put it down because I'm like, this is just too terrible. It is such a waste of time. I can't stand reading this anymore. It was The Tommyknockers by Stephen King. The Tommyknockers. It's just one of the dumbest things I ever read. I couldn't stand it. It was the very first time I ever put a book down and didn't finish it. It's probably not a virtue. Probably not a good thing to be like that. But I don't know. I do. I want to be thorough. I don't want to just come at something half-assed just to have something to say on YouTube. Like, that's not really the point. The point is that the value is there. And if the value is there, then there's an incentive to share it. I don't want to be just like stirring, looking for something to try to create value. It's not what this is about, really. But I agree. There's definitely some room to do both. And not every trial is a 2-month trial. I don't know why I got to pick these long ones. I got to pick Karen Reed and Brian Koberger, the ones that are going to take half a year out of my life. We know why. It's because they're the interesting ones. It just has so happened that they're particularly long this year. But you're right. I can definitely try to work in doing some both. Michael Milano, updates like Lawyer has done for this trial have been great. If I stream another full trial for weeks, my wife might leave me. I understand the feeling. I understand the feeling. Hence my skepticism to my hesitation to make any commitments to future streaming. Yeah, I mean that's kind of what I'm thinking. The updates seem pretty all right, and everybody has different takes on things anyway. You get, if we watch the trial together, you get my instant reaction. But you don't necessarily get the after reflection. I mean, I try to share it if I remember, if I I'm thinking about it after the fact. I'm coming in to start the next day. I was thinking about what we saw yesterday. You know, sometimes things come together. I mean, it's not like I'm not sharing that. It's just different format, different things that you get out of it. So maybe just some recaps. Maybe just some recaps. Yeah. Still thinking it through, Michael. Mostly peaceful redhead. Do you think Jen is hosting a watch party? Thank you so much for your stellar coverage. I doubt it. I doubt it. Suspect there are probably a few White Claws in already. Everybody hates the limbo of the wait. Everybody hates that. But nobody more than the people who have the strongest interest in the outcome. Karen is absolutely suffering right now. This is the worst part. Her team is suffering. It's the worst part. Hank maybe doesn't care anymore. It's a little bit hard to tell. But to the extent he does, this is also very, very uncomfortable for him. So what about Jen? What about Jen? Sure does look to me like Hank hung this trial outcome pretty squarely around her neck and Proctor's neck, so that if he doesn't get his conviction, he can point to them. You're the reason why. Jen, if you hadn't lied to the FBI, if you hadn't been such a terrible, shady witness, if you hadn't Googled Hoslong to Diane Cold at 227, maybe we would have gotten the conviction. So if she knows that, maybe a little stressful for her too. Gary Herman, Homer Simpson famously states, facts are meaningless. You could use facts to prove anything that's even remotely true. Oh, a wise man, our Homer Simpson. It's true. It's true. You really can. Even just a little bit true. You can use facts. You can use facts to prove it. It doesn't even have to be all the way true. It'll have some facts. That is a funny quote. Thank you for sharing that one. I don't remember that. That might be a newer episode. Get nerdy. Can AJ ask Bev in open court and in front of the jury to draw alternates out in the open? Anything to lose? I mean, not really. Not really. Anything to lose. It's not like you're not in contempt by doing that. Doing it out in front of the jury, you know she's going to be pissed. She'll be like, you should take it sidebar. I already denied this motion anyway. If you wanted to ask to reconsider, do it out of the presence. I mean, she'll be pissed. Is there anything she can do? Questionable. Questionable. Motions in CPA. Is there a clip on Twitter with a hot mic moment right before first sidebar? Oh, there is a clip on Twitter with a hot mic moment right before first sidebar. Brennan, do you agree with this? Lally, no, it's total garbage. Then Brennan asked to approach. Sorry if you mentioned. I haven't seen this. I haven't seen this clip. Let me see if I can find it real quick. Here we go. Eve True Crime has this one. Let me just pull it up so we can all listen to it together. Let me get that up. True Crime with Eve has the hot mic moment. There it is. Let's listen.
You are unmuted.
Do you agree with that? No, that's complete garbage.
We did.
Jurors on their way.
No, it's complete garbage. That's funny. What are they talking about? I wonder. What are they talking about? Hilarious if they're talking about his closing. No, it's complete garbage. It's probably something of the defenses, who knows, but we would love to know, wouldn't we? No, it's total garbage. Maybe that's why they had to go debate the presentations. Not sure. KH, are official records maintained for phone calls or online meetings conducted by a judge while in their chambers alone? So stuff that goes on in chambers, it's not unheard of for formal court business to be conducted in chambers, to have chambers conferences, to have chambers review, in-camera review of materials, things like that. Sometimes, depending on the nature of the proceeding, you'll have the court reporter back there in chambers taking it down. So an example of when we saw this, we had very, very, very early on in the Koberger case, there was a smear that was circulating attributed to a certain trash cable channel that's had a big interest in the case, and a certain retired FBI agent who seems to have an allergy to truthfulness and integrity. There was a rumor that can be attributed to those people that Ann Taylor had a conflict of interest due to prior representation of Kara Kernodle, the mother of the victim, the Idaho 4 victim, Xana Kernodle. And it turns out this is completely untrue. Kara Kernodle had been represented by the Kootenai County Public Defender, of which Ann Taylor was the head of that agency, but she did not herself ever meet Kara Kernodle, ever represent her, ever appear in court for her, ever speak with her. And the reason we know that is because they had a chambers conference to talk about it. Not going to have that chat in open court. You're going to do it in chambers. So they had the clerk back there making a record, taking notes. So that kind of thing does happen. But if it's just the court back there doing their own thing, their ordinary business, their own phone calls, stuff like that, nope. Typically not going to be a record of that maintained. Just kind of general public record stuff, if there is a record of it. Online meetings, if it's a court hearing, like a Zoom hearing or something like that, well, yeah, there should be a record of it, but just a general, online meeting, no. No, the judges are not surveilled. They're not generally under constant surveillance unless you're in Kentucky, where apparently they have a camera in the judges' chambers. Forgot about that one. I'm interested in that one too. The Sheriff Steins. I'm interested in that trial. More corruption, it seems, but exactly where it is and exactly what it's about. A lot of open questions still. So, general answer to your question, probably not. Probably not a record of those types of things. Nana S44, I've learned, laughed, and snarked along with you this whole trial. It can't be easy as you make it. It can't be as easy as you make it look to do such stellar coverage. Thank you, Andrea FKR. That's very kind of you, Nana. The hardest thing, honestly, is probably just, I think, like many of you, not getting too pissed off and having to walk away. Not getting so annoyed and frustrated and outraged at just the ridiculousness that we see coming out of this courtroom might be the hardest part. But the talking about what's going on, I mean, that's easy for me. I want people to see it. I've been seeing the system for a lot of years, guys, a lot of years. And it's just been one of the most vindicating parts of my experience with it, to have so many of you seeing the same thing and not afraid to call it out. See it what it is, say that it's wrong. Really is very, very validating. So thanks for being here with us, Nana. I do appreciate that. Jason McClellan, who is more pro-state, Judge Bev or Gull? Defense closes first. Spooky. I mean, Gull is more pro-state. Bev will occasionally throw a little breadcrumb over to the defense to give him something. She gave him I'll reiterate, in my opinion, she gave them a real gift, shutting down the whole issue with Karen waiving the attorney-client privilege with David Yanetti by giving the interview where she says, I told David Yanetti told me. You don't get more explicit waivers of attorney-client privilege than that. She did them a real favor, not opening that door. Gull would never do that. Never do that. Not the tiniest little thing would ever go in the defense favor. Things that should never happen, not paying them, making them pay out of pocket for their experts and then get reimbursed, then not paying their experts, then not paying them. Nightmare stuff, nightmare fuel, making it as hard as possible. That one to me is pretty easy. That's definitely Judge Gull, but she's just on a different level of malice than Bev is. Bev, I get mostly just laziness, and it's easy for her. This is what she's used to. These are her buddies. These are her allies. Don't make it complicated. But it's mostly laziness driving a lot of it. She wants things to be shortcutted and simple, and the simple shortcut is, these are the good people, the white hats, so they should win. Gull has a level of malice and sadism far beyond what Bev has ever shown. Bev's loud. The court cameras in the courtroom. She's not making anybody sleep out on the steps to be able to get inside. Bev's not saying, you, the court, get to look, you, the reporters, you credentialed reporters, you get to go look at the exhibits, but the rest of you peons, public attendees at the trial, you don't get to see the public exhibits that are being admitted. It's really not even close. Yeah, the defense closing first. I forgot about that. So I'm used to it's prosecutor, and they get to reserve time for rebuttal. So it goes prosecutor, defense, prosecutor, but not here. Here it's defense goes first. That is weird. You're defending yourself, but against what? You don't even know what you're defending yourself against because the prosecutor hasn't gone. Strange. BLT, I've watched the whole trial via your stream, Andrea, and now I'm watching AJ masterfully argue in defense of Karen Reed. Thank you for insight and coverage, and you have the best LawTube chat out there, FKR. I agree with that. We've got an awesome chat. Really do love this chat. It's a great resource of folks. So many of you still hanging out, guys. We're still just, let me find it here. Still just staring at this fan over there, waiting and hoping that something might happen today. We'll see where we get, but it's a wonderful chat. Good group of people, friendly people, knowledgeable people, insightful people, clever people, witty people, people who are concerned about getting to the truth. And that's the most important thing. People who want to ask questions, people who want the answer, whether it's what you want to hear or what you don't want to hear. It's one of the most important jobs you have as a lawyer is delivering the bad news that people don't want to hear. Every single client walks into your office and wants to hear, it's okay, I can fix it. I can make this go away. And a lot of times you can't say that. So I very much appreciate that about this chat. Thanks so much for being here this whole time, BLT. That's a big investment that you made as well. It's great to see so many people care about this case, care about corruption. It's insulting, isn't it? Watching our institutions, they're supposed to belong to us, and here they are acting like they're our kings, our betters. L'état, c'est moi. Attitude we get from this courtroom. It just does give me some comfort to know that I'm not the only one that finds that pretty gross. It's gross. It's gross. And in Massachusetts, of all places, you know, an original colony, and you're gonna act like the king that we fought a war to separate ourselves from. So I really appreciate you, BLT, and everybody else who's been here in the chat, contributing, paying attention, and caring to what's happening here. And it was a masterful, very, very good closing. Very good closing. Made sense. A lot of details, easy to follow. Kept hitting that same theme. The only one that matters. There was no collision. You can stop there. Why are we even here? Because they knew before they went to trial last year that this is what ARCA had to say. And they didn't even have a response to ARCA. But to put a guy there to play dress up and paint on his arm. Why are we even here? David E. 25 years in public safety here. You know who was dumb enough to come up with this absurd story for how he was killed? Cops. Guys, there's no criminal masterminds. There's really not. There's so few and far between. Okay, we had DB Cooper, and it's been downhill ever since. There just aren't criminal masterminds, and nobody is as smart as they think they are. Cops make case after case after case out of people thinking they're going to be smart enough to come up with a story. They're going to be smart enough to be able to explain things away. They're going to have the excuse that nobody else has ever heard. Oh, those drugs in my pants pocket, those aren't my pants. Like the cops have never heard that one before, okay? Everybody has heard. You just put on some random pants that you found at your cousin's house. Your cousin who? You don't remember your cousin's name. Everyone has heard this story a million times. Everybody thinks that they're going to be smart enough to come up with a cover story, and they never are. And in this particular case, they didn't know what they didn't know. They didn't have enough information. They didn't know what was going to be in Karen's car. They didn't know what was going to be in Karen's phone. They didn't know what was going to be in John's phone. And they had to put their cover story together before they had all of those pieces of information. And just lo and behold, you can work real hard to try to make some of it fit. But it's just real hard to come up with a perfect cover story when at the end of the day, he wasn't hit by a car. Look at him. Look at him. Doesn't pass the eye test. When not a single medical professional will say, yeah, he looks like he was hit by a car, you're going to have a hard time coming up with a story to be able to explain that one. Voir Noir. Alan Jackson is a criminal defense attorney. His firm's office at Worksman, Jackson & Quinn, LLP is located at 888 West 6th Street, 4th floor, Los Angeles, California, 90017. I'm sending a bottle of scotch. You? Some flowers. They deserve flowers today. Ms. Little deserves her flowers as well. Anybody have gifts, fan art, anything like that? You know where to send it. Ms. Jake, has Andrea seen any of the AI baby videos she's in? Adorable. I have seen the AI babies. They are pretty cute. The AI babies are pretty cute. Guys, I will tell you, not a cute baby here. I was not a cute baby. I was a hideous baby. I was really an ugly baby. Okay. I was born bald. I was born really fat. I had like 8 chins. I believe the story is that I was allergic to my mother's breast milk, so I had terrible acne. I was really an ugly baby, guys. So these AI babies doing me some major favors when it comes to that throwback. My brother was a beautiful baby. My brother had the porcelain skin and the black ringlets, the curls, and he was beautiful. I was the nice baby. That's how you know when you're the nice baby. That's how you know you were a freaking hideous baby. Wisconsinite, as AJ concludes his masterclass closing, I'd like to thank you for your masterclass and trial coverage. Truly excellent coverage. Thank you. Well, thank you so much. I appreciate all the kind words because there's something is happening in here. Not sure what. We'll just keep an eye on it. I don't know what I'm doing. There's no plan here. There's no strategy here. We're just watching and talking about what we see. So the fact.
Jurors, I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. See you Monday morning, ready to start up fresh.
All right, guys. So I have ended the poll. 2/3 in favor of no verdict today. And you are right, because that's the kind of brainy chat that we have. The odds were against it. Of course, everybody loves a fast not guilty, but it really is very rare and not really. The odds are not in its favor in a case like this.
All right. Well, I hope everyone has a good weekend with no work.
Thank you. All right.
There you go. You just heard Bev's priority right there. No work. Doesn't that just say it all? No work. All the things to hope for. No work. Well, jury's going home. Finish back up Monday. So we'll see how that goes. I don't, now I gotta look. Oof, now I gotta find out what time is that Koberger hearing on Monday? Don't think I remember off the top of my head. Don't think I remember off the top of my head. I'll have to double check. But just by virtue of us being over here on the West Coast, it is going to be in the middle of their day over there. So I think I'll watch, unless we get something early over here in Massachusetts. I think I'll watch Koberger on Monday and just see if we get any news coming up from here in the meantime. So keep your eyes open for that. I'll shift my brain over to the other case. Probably sometime over the weekend, just when we get a chance. So keep your eyes open and I'll get that posted. Jen Borden, powerful. Thank you for your great coverage and insight, Andrea. Well, thank you, Jen. It was a very powerful closing, I thought. Very oh, I'm hearing now did I get the date wrong? Is the hearing on Wednesday? Ugh. I am way out of the loop. The Koberger hearing. I'm just going to double check everything. we're hearing maybe on Wednesday instead. I'll verify when it is, guys. I'll plan to be there. So, me being scattered right now. That's just because it's been 8 hours since I was, starting the stream at 5:15 in the freaking morning. Thank you, Jen. Thanks for being here with us. And I do appreciate the kind words. D. London 1144. It's worth remembering that Hank is the guy whose defense of the murderous mobster Whitey Bulger was described as virtuoso. Kind of puts his moral compass in perspective, huh? Well, I got to tell you, D. London 1144, the first thing that jumps out at me in your comment is the passive was described. Who is doing the describing? Who's describing him as a virtuoso? Because I got to tell you, nothing that I saw in this particular trial tells me that virtuoso is within the capacity of this attorney. I'm sure he can do a good job. He can do a better job. He can do a worse job. But virtuoso, not seeing it. Not seeing it. He can't even really cross-examine an expert. He doesn't know when he should just not ask any questions. So I'd be interested in who exactly gave that description. I have been wondering if there is somewhere to maybe be able to hunt down the transcripts from the Whitey Bulger trial. It was a federal court, federal case. This is, a while before we didn't, routinely have cameras in the courtroom at that point. What was it, 2015 or something like that? Like, it's not unheard of, but it's not post-COVID, certainly. But it's in federal court anyway, so no cameras. I'd be interested in seeing if there are transcripts. I know Howie Carr's got a book on it. Interested in reading that. It's on my list for sure. But I'd be interested in who described it as a virtuoso. AC 75. Oops. We'll go to Michael O'Houlihan. I'd like to think the defense watches your excellent coverage and saw my comment. If he wasn't trying to make representations, then why did he dress like John O'Keefe? It was mentioned twice in closing. It's such a good point. It was a good point. I hadn't thought of that when you brought it up, but it's an excellent point. If you're not trying to represent something, then why are you dressing up? Why are you playing dress up? Why the cosplay? If you're not trying to represent John, you're just part of the fan club. Like what's that? What's that even about? It was an excellent point. I seriously doubt the defense team, has the time to sit and watch all the live streams, all the coverage and stuff like that. But I'll tell you what, it wouldn't surprise me if their law clerks did that. And just, mine the internet for feedback, for reactions, for questions. It's an amazing resource that lawyers in high profile trials have now to be able to get this real-time reaction from what is in many respects very similar to like a focus group jury. Just random people out here with no particularly greater insight into the case. Certainly not on the level of the lawyers. Okay, some of us who watched the first trial might, know a little bit more than your jury that's sitting there right now. But by and large, people are just taking in the trial as it happens, just like the jury is. So it's a fantastic resource for them. I think it would be a real missed opportunity if they hadn't. But I think this is a good example of just a situation where it's either great minds thinking alike, which is very possible. Great minds do think alike, but also possible that the law clerks were mining the live streams for the insights they thought were good. Happened to catch yours, Michael. It was a good one. I agree completely. Grifting Gamer. Objectively, Hank has a point about the text stream data. I'm disappointed the defense has no answer or explanation. I'd still vote not guilty, but they didn't really address the text stream data or the data, is the data itself at all, in part because, again, it's weird to have them in a position of defending, they don't know what. They're going first. So they're defending, but it's not clear what we're defending yet. The text stream data isn't their focus because it doesn't matter. It doesn't matter what Karen did if there was no collision. So I understand the thinking behind it. But, you know, if we knew that that was what Hank was going to rely on so heavily in his closing, might we address it a little bit? The data is the data. It doesn't change, but the significance of the data is something else entirely. We depend on people to tell us what it means. And so we still have to know who do we trust to give us the right interpretation. Do we trust Shannon Burgess and Judd Welcher? Do we trust them? Or do we trust Dr. Laposada, who says it doesn't matter how fast she was going because she wasn't hit by a car? That's how the battle lines were drawn. So that's what they stuck with. That's why they didn't address the text stream data. There's always going to be things. There's always going to be things that don't get addressed, things that get dropped. You just have to have faith in your case and in your preparation, your theory that you constructed and you presented throughout this whole undertaking. That's why you, the defense, get to get up in closing and you get to focus on exactly the same thing as you did in your opening. There was no collision. Because you already knew that's what your case is about before you started. You made the case about that as you went through. And so when you finish, you get to point out that's still the main issue here. There was no collision, no proof of it. You don't do that, then you'll find yourself on one day telling the story of Timothy Nuttall, and on the next day you're closing saying John was 46 years old. You can't even keep the same perspective how you tell your story. I'd be interested if you think there is more of a point about the text stream data other than just it is what it is. I mean, my concern, my issue with the text stream data, once again, you have these two triggering events from the acceleration, and you're saying one of them was this life-ending collision, and the other was a perfectly ordinary three-point turn. It could have been something very simple that the defense could have done. They had multiple witnesses. Even the Commonwealth's own witnesses acknowledge. Text stream data doesn't show a collision. The trigger event is not a collision. That's not what it shows. So they could have capitalized on that, but maybe it's just not necessary because if there was no collision, none of this matters. Polly Quinn. Oh my God, Hank made me fall asleep. Thanks, AB, for your awesome coverage and knowledge. In my opinion, this is going to go down as one of the biggest corruption cases. I have a feeling that many people will be arrested. We'd love to see it. We really would, because at this point, it does seem like there's just no accountability whatsoever for that whole imperial police force you guys have going on over there in Massachusetts. Really does seem like they can do whatever they want. And the worst case scenario is you might lose a few vacation days unless you're so bad that you got to be the scapegoat for everybody's corruption. Then you might have some personal consequences. You might have to, go get a different job. It'd be great to see. Don't know if we're going to. I didn't fall asleep in Hank. I just was confused with Hank. I fell asleep during Bev, but Hank just had me confused. Why are we jumping all over the place? And we're going to come back to that. But did we ever come back to that? You didn't guide me well at all through any of this. You got a timeline up on the screen that shows me John taking steps after the collision that you're saying happened. Surely you're not saying, okay, it's not the collision, it's just the data. Could have happened afterwards. Surely you're not saying Karen continued to speed backwards for another 4 seconds. She'd be back at Cedar Crest by then. Looks like I'm running a little bit out of my tea here. We still got a lot of stuff in the queue, guys. I'm going to pause real quickly. Hang tight. Haven't had a break yet today. which is fine, not a big deal. But I do need to get some more tea so that I don't turn myself into a mummy talking here, getting through your comments and stuff. So give me half a sec. I'm going to refill it, and then I will be right back. All right. Thank you so much for hanging out and waiting for me, giving me my moment there. Oh, life does come flooding back with a little nice tea in the afternoon. Bobby Walter, is an only count 2 guilty verdict a win for Karen? Well, that's a philosophical question, isn't it? In many respects, it is. Of course, it's not a murder conviction. A lot of people would look at a case like this with the perspective that avoiding the worst possible scenario is a win. Other people might look at it as a loss because the only reason you charge murder in the first place is to hope that she'll plead down to manslaughter, or get a compromise or something like that. So she doesn't necessarily do any better than she potentially could have done through, plea bargaining or stuff like that. Now, that said, have no idea what was out there as an option or anything, if anything even was. But my personal opinion, if you're asking me if count 2 guilty would be a win for Karen, no. Maybe one of the lessers, maybe like the count 2 OUI lesser, sure. If Karen walks away with just a DUI, that's a win. But Karen convicted of voluntary manslaughter is not a win because it means they failed on the proof, the argument, the pointing out that there's no proof of a collision here. They didn't get the jury to see it that way, and that's really central to their case. So I personally would not see a voluntary manslaughter conviction as a win, but opinions could differ on that. La Casa Academy, is it typical for attorneys to have leeway to testify during closing, i.e., I didn't remember 1236 Wi-Fi being in evidence? No, it is very much not typical. It is very much not typical to be able to misstate facts and evidence and just have this sort of generic advisement to the jury. Well, if you don't remember if what they say is right, just go with your memory. No, it's not normal. It's an issue that comes up on appeal for me with prosecutors misstating evidence in closing. It happens not infrequently, and it's misconduct. It's not always objected to. If it's not objected to, I have a lot harder time making the argument that it warrants reversal in a new trial, but sometimes it is objected to. And then you got a mess. What do? Often the judge will just instruct the jury, disregard it. Sometimes they'll instruct the jury like Bev did here. Your collective memory of the facts is what you need to rely on. If your memory doesn't comport with what the attorneys say, they don't come out and obliquely say or overtly say that the attorney just told you something wrong, but they make it clear, disregard anything that doesn't fit with your memory. So no, it's not routine at all. The verdict is to be based on the evidence. The argument is to be based on the evidence. If it's not in evidence, you don't get to argue it. You can argue inferences. You can argue what they should make of the evidence, what they should think about it, how they should interpret it. You can argue inferences from common sense. Okay, we all know nobody is falling down on a lawn in Massachusetts in January and cracking their skull on the lawn. We all know that. You can use common sense for that. You can make that type of argument. But things like, 1236 Wi-Fi connection, I don't remember that being in evidence either. You're really not supposed to bring that up. Didn't get objected to. Sandra, let me get this straight. Karen Reed maliciously killed John O'Keefe because of Bella's mom, and then at 6:30, she is starting to realize what she did and she's panicking. It's incoherent. I mean, if you're getting that straight, I think you're doing better than anybody else. It's incoherent. She's leaving voice messages because she knows she left him there. That's why she's calling him and telling him nobody knows where you are, because she knows she left him there. It's incoherent. She was so panicked. She starts to get more panicked. So what does she do? She goes to sleep. It's incoherent. But hey, if you think that, women are bitchy, going to be jealous about Bella's mom, maybe that's enough. Maybe that's enough to prove murder. Matthew Madu, I just did a mock-up using Google Maps to put circles that mirror Hank's 10-foot dots. Wish AJ had done that. If straight path, Lexus hit house. Interesting. Interesting. Yeah, with the distances, I don't know how she's still in the street, not up the curb, not in the grass, obviously not running into the Jeep, but even the driveway and the other cars that are parked in the driveway, that driveway was crammed full of people. I don't know, but it really wasn't their focus, was it? They didn't focus on that at all. It was really focused on John to prove there was no collision. John in the taillight. No nudes so far. Nobody has overtly called it planted evidence other than Hank. Yeah, you're absolutely right. You're absolutely right. He brought that up with Rentschler, because Rentschler said, "I have no idea how that got there. Somebody could have put it there." Oh, so now who do you think planted it there? Well, Proctor, if you want to know. Proctor and his buddies. Buchanan, Tully, Berkowitz, those guys. They planted it, Hank. Really? No, I don't expect Dr. Rentschler to come out with something like that. He really, I mean, there's no need for him to know those details of the case with that kind of granularity, who was involved, who supervised who, all that type of thing. But it's true. Hank is the only one who called it planted evidence. Everybody else said there's a lot of other ways it could get there. By the way, the scene was unsecured all day, thanks to you guys. But he is the only one who came out and said it was planted, and then got all huffy about, we never said that's how John was standing when he got hit. Oh. Didn't realize you were dressing up as John just because it was Halloween. Nicola Maxwell, thank you, Andrea, Jeff, and chat. You're the best. Nicola, you're the best. You're the best. Look at that wrench right there. One of our awesome mods. She has been here like every day, putting in the hours, thick and thin, keeping things moving. Nicola, I appreciate you so much. I hope you know that. Ferai Naturai, I'm behind as usual, but personally, I'd love to have you in court to tell us vibe, jury notes, but I could be very happy with 3 days a week. Delphi was rough, like a torture marathon. Free RA, it really was like a torture marathon. And that was the point. That was the point. Going back to that comparison between Bev and Gull. That was the point. This was a sadistic court we were dealing with. She was going to make us, it's the same attrition kind of thing like Hank did with the defense. Oh, you're going to show up and exercise your right to attend a trial as a member of the public? Well, you're going to pay for it. You're going to pay for it. It was a little bit rough. I expect that Koberger would be quite different. They do have, recent experience with a high profile case, the Lori Daybell stuff that's going on. When it's streamed, then there's so many sources of information that you don't have to be in the courtroom to know what's going on. So I don't necessarily expect the same kind of crowds to get into the courtroom as in Delphi, where you get in or you rely on somebody else that was in to know what was going on. The whole issue that made it so hard to follow Delphi in the pretrial stage. So, don't expect it to be a torture marathon, to attend the whole thing. If I do that, we'll see. Duncan, Idaho, if you ever find yourself sending an well text, you need to stop everything, isolate yourself from everyone you know, and live in a cocoon of gym and self-reflection for a few years at least. Can't hurt. Can't hurt. Little gym and self-reflection might answer that question. Well, Well, look at you, dude. Look at you. You're kind of pathetic. Sad, sad stuff. Stacy LeBruno, the only issue I saw in AJ's closing is that he didn't address the charges. He could have walked the jury through them to simplify. He could have. I think his point is simply if there's no collision, you don't get there with any of it. It might have been nice to have that more explicitly spelled out how, because of course Hank comes out. All you have to find is she hit the gas pedal and went in reverse, skipped over that important element of causation. Her conduct has to have caused the death of John. And so that's where you got a little bit of a hole. If there's no collision with John, you got a little bit of a hole that her backing up caused anything at all. Even if she did in fact back up and not just, hit reverse in the snow where your wheels would spin. He could have, maybe it would have been a good idea, but I think at least from the 10,000 foot view, their theory is easy enough to understand. She's not guilty of any crime because she didn't hit him with the car. So as long as you agree with that, the only thing you might have to talk about back there would be operating under the influence. That's it. You can talk about if she was DUI. It's the only thing that doesn't require that John was hit by the car. He had it timed extremely well. Okay, but he did run out the clock. He used pretty much every little bit of time that he had, and would have taken time, would have lost something else, would have had to prioritize. Now, personally, I could have lived without the grab ass video. It's just, to me, it really doesn't add anything. It doesn't tell me much. It just shows me dudes are being dudes. So I personally, I could see making that trade. Leave out the grab ass, give me a little bit of detailed focus on the charges. Show me how, just very simply, show me how there is no collision, undermines the elements of these charges, and then we're good to go. Occipit Boner, for Verdict Watch, would you give us your closing? Oh my Lord, I have not written a closing. I would have to go through all of these notes to make the closing. I'm happy. I'm very happy with Alan's closing. I'm just even trying to think if there's like really any facts that he hit on that I didn't. My part of the challenge here is that the things that jump out to me about the case are not necessarily the things that jumped out about the case to the defense. The whole missing chain of custody of John's phone, to me, that's massive. And especially given this whole tie-in with the battery temp. To me, that's a massive piece of all of it. But that didn't come out. It's true, it doesn't have anything to do with whether John was hit by a car or not. But it really does seem to go to the integrity of the investigation and the people that we're hearing from as witnesses. So they didn't focus on that. Where's the blood? So many people in the chat, where's the blood? I've wondered that myself. Where is the blood? If the ground is now frozen, there is no blood seeping into the ground. The blood should be pooled on top, probably frozen because of the conditions. Where is it? Should be right there under where his head was when they were doing that leaf blower. Where is it? So I think because I have like different questions that come up from the facts, I don't know what the answers to those are. It could be very well they talked to the medical examiner about the lack of blood and there's an answer for it. And we just don't know because we don't have the discovery. That's all is very, very possible. I got to say it's, when we talk about these things, these questions, these possible facts and stuff like that, it's very unlikely that we've thought of something the defense team hasn't. Okay. It's almost certain that they've run down all these. They've run down all these roads. They have an idea why that does or doesn't work, why it is or isn't important. So I'll take it on faith they have an answer. It's just I don't. So I don't know what the answer is to that. It's hard for me to construct a closing off of somebody else's case, because they constructed their case based on their theory and the facts they elicited to go along with that theory. I can't argue with what they did. There was no collision. It's perfect. He's right. It does negate all of the charges. And the rest of it doesn't matter. You don't have to decide who planted the taillight. You don't have to decide if the taillight blew in on those 47-mile-an-hour winds. You don't have to decide any of it. If he wasn't hit by a car, you don't have to worry about any of that. And the Commonwealth wants to get it backwards. They want to tell you, because it's there, you should conclude he was hit by a car. But the problem is there's other ways that it could get there. John was hit by the car. His body would show it. And his body would not show what it does show, those weird bite-looking marks that he's got on him. Lacerated tongue, bruise on the hand, scrapes on the nose, bloody nose, cut to the eye. I just don't think I would really take issue with AJ's closing. Your mama, confused, thought Commonwealth had rebuttal, but defense went, and then Commonwealth had no rebuttal. What happened? This is apparently how Massachusetts does it. They just have the defense go first and the Commonwealth go second, instead of having prosecution, defense, prosecution, rebuttal. Just the way they do it there. Sometimes places are kind of weird. Alan Jatkins, 88. Regarding juror selection transparency for deliberation, I know you went over the motion denial, but do you think the fix is in again? I don't think so. I think it was just Bev was, not going to be told how to do it. She just wasn't going to be told how to do it. Picking the juror in seat number 1 for the 4-person, that was consistent with what she did in the first trial. Now, granted, we had seats, jurors moved earlier on in the process to different seats. But if there's a fix in this, I would have to think that it goes back to selection and just who ended up in that pool and in that room and on that jury in the first place. Just my thoughts about it. I don't think the fix is in on like jury tampering or anything like that. It just would be nice if we could have complete faith in the system, not have to question it at all. Marcelo, if Karen is acquitted, how bad do you think the admonitions by Bev to Karen's attorneys would be? I think she still wants to get at them for the ARCA fiasco. Also, BK, recap from inside the courtroom would be better, in my opinion. So getting several comments about coming back from inside the courtroom. I'm kind of leaning that direction, but, like I said, haven't made up any final decisions. If she's acquitted, I don't think there will be any. I don't. There's no reason to. They don't have any reason to stand around and take them. They're done. She's done. She's a free woman. We're walking out. Enjoy your life, Bev. Smell you later. I think she's gotten what she could out of the ARCA fiasco. She got that finding she desperately wanted to make about the multiple repeated discovery violations that are, really unspecific. Not clear what exactly they are. And that's all she needed in the violation of the candor to the tribunal. Found that's really what she wanted. So I think that's probably where it stops. Sharon Yoxall, thanks for all your great work. Really impressive. Thanks, Sharon. It's nice of you to say. Really appreciate that. Kai San, soccer moms can't do bad things. Must be the most American thing I've ever heard. Swede here. Just a normal soccer mom. Can't do anything bad. We don't have a hooligan culture over here. I mean, we don't really care about soccer at all, right? Not that many people in America care about I just said America. Oh, not that many people in the United States care about soccer. There are some, but don't really have the hooligan culture here. Had to catch myself for calling it America because we're not the only America. There's the whole South America down there. There was Chilean poet whose name, or artist, his name is now escaping me, but the first time I went down there and went to the Fine Art Museum, he was part of an exhibition, and he made he had a lot to say about America, and this sort of writing out and forgetting that there's like this whole South America down there. We call ourselves America, and it's true. It's a point. So trying to catch myself. How could they do it? She's just a normal soccer mom. Now, don't you dare wish a happy birthday to your 10-year-old son, but she's just a soccer mom. She makes cookies and teaches the basketball teams and all that. Amy Lecoq. If John O'Keefe's phone shows his movements, why do we not see him fly through the air? Would the phone not register that? Well, it doesn't. It shows steps until they want those not to be steps. The phone shows steps, and he correlates steps with movement because the steps, in the same voice saying the data is the data, he has to make the data something else for the data to work for his theory. So the data is steps, but for his theory, it's movement, and therefore it's good enough, I guess. The phone's not going to show him fly through the air because the location data isn't going to have that amount of precision. Although, I don't know, maybe if he still had Waze on, if he still had the Waze app on, maybe we would see him fly through the air. I don't know. David Case. Wait, what the fuck? The oral instructions take precedent over those the jury gets in the room? Yeah, isn't that wild? Isn't that wild? You are duty bound to remember everything that you heard. And this thing that you're going to have back there to read as your resource, you can't trust it. So anybody in that jury room back there thinks they heard something slightly different. Now you got a problem with your deliberations. Isn't that wild? I know. It's set up for failure. It's crazy. Byron Butterfield. Some of you got chicken for lunch. Some got fish. You will soon know who are the alternates. Who got chicken and who got fish? We need to be better. Thanks, Andrea. As an attorney, I really appreciated your coverage of this trial, especially that you didn't pause the coverage to comment. Well, thank you. Appreciate that coming from attorneys as well. We're just going to take it all in. The trial is the show here. The trial is the show. That's what we're all here for. I am not the show. I'm just here to provide insight where I can. And I can certainly do that at the breaks. So I'm glad that that works for you. Hope you come back for some of the other trials that we watch here. Ian Thomas, praying we will see the light, the tail light at the end of the tunnel. #FKR. I've heard that at the end of your life, sometimes there's like a bright light, and it's a small hole, but it gets bigger and bigger and bigger and bigger. And as you step through that hole, you see suddenly the 47 missing pieces, they converge into the one single beautiful tail light, and you can be at peace. Tom Wax. Hi, Andrea. Great coverage. Thank you. If when she pulled the glass out of his nose and blood came squirting out, doesn't that mean his heart was still pumping? Maybe. I mean, Dr. LaPosada's explanation was it could just be that there was blood transfer. It could be that there was blood pooled. And she's like an arterial spurt. She described it. Yes, that would require a heartbeat, but I don't think you're going to get that out of your nose. The bottom line from my perspective is that the most likely explanation of all of this is that didn't happen. It didn't happen. He didn't bleed because of that. He had blood all over him. She had blood all over his face. She's in a, highly stressed condition. I just don't think that was a reliable report. That's my read on it. But if blood spurted out, it would indicate he was alive. But that would be the only indication at all that we have that John was alive at the time. Beth B, why 4-person selected before the alternates? Believe it or not, that's what the Massachusetts statute says. It says that the judge selects the 4-person, and then it sets out the process for selecting the alternates. And it says you put all of their numbers except the 4-person in the drum, and then you pull it out. That's what the statute says. CG, thanks for your great coverage, Andrea. Well, thank you so much for that, CG. Thank you for your support and for being here. Really appreciate it. Servant and Watcher, what was meant by no not guilty verdicts? He was talking about the verdict form, and the verdict form for count number 2 is very confusing because it's got all kinds of lesser included offenses on it. And the way that the verdict form is structured, they have to either find her not guilty of everything, or they can find her guilty of any one of the main or the lesser included offenses on the sheet. So there's 10 spots where they can mark indicating guilty of something in some way, and only 1 spot to indicate not guilty. That's what he was talking about. Dr. Laposada's clapbacks, MEG. Hank's weird fuck thing with Signal is definitely going to rub the younger jurors the wrong way. It's totally normal. It just gives, okay, boomer. That is one of those things I've wondered about with the younger jury for sure. For sure. Hank is really fixated on the Signal. It's like he takes it. It's one of these things where I think he's taken it personally. He has a personal grudge against it because he wanted the communications. He tried to get them, and then he didn't. He was, he was obstructed by Signal. So for him, it's like this really big deal, but nobody else cares. Sometimes you'll have a situation where, lawyer's really upset about something, but it's something only a lawyer would care about. Like nobody else is going to notice. It's not going to matter. But it really, really matters to that lawyer. I think it's like that. He just took it very personally that happened. So he's obsessed with it, and nobody else cares. I can't see a younger jury caring about communicating with Signal. Maybe they will, but I'm skeptical. Scooter 54, how is that verdict slip even constitutional? Why isn't there a not guilty box on each and every charge? I don't have an answer for that. That's what Yanetti has tried to do. It's what they proposed last year. It makes sense. It's clear. It makes it a lot easier. It's a binary choice for each one. I have no explanation for you on this. As far as the verdict slip being constitutional, I don't know that it is, because I don't know that it's been challenged. She says, well, it hasn't been overturned. And Yanetti says, not yet. Not yet. She didn't say the Supreme Court has affirmed this verdict form. They said it was totally fine to do this. So I don't know that it is constitutional. David, Bev's verdict form had no option for not guilty. It just had the one option on verdict 2. 10 ways to find her guilty, 1 way to find her not guilty. Becca Lynn, hi, Andrea. Was any evidence or testimony given about what the Lexus did after the 87-foot reverse event, or what route she took to John's? Thanks. Nothing. In fact, they made a whole point of saying the 87 feet, the trigger event, that's just the data being recorded. That doesn't necessarily correspond with anything that's going on out in the real world. They have no idea what any of this really means. They did not propose a route back to John's. Nothing like that. They have no idea. They have no idea. Carolyn Smith, according to the text stream data, Karen is still in reverse gunning the gas pedal to this very day. Well, it did end at some point. The trigger event ended at some point, and then then we got it in the possession of law enforcement to be able to add more trigger events to it, and then didn't hear anything about whether they got the right trigger event this time or not. Didn't hear anything about that. It's one of the reasons I'm awfully suspicious of this SD card that old Shannon Burgess managed to find. here on this board. I'm just suspicious of this. I'm very suspicious that all of these people overlooked something as obvious as a big SD card right here on the board. It sure does seem like the kind of thing that somebody might be able to, generate, produce a little data, a little table, a little spreadsheet or something. I don't know how the text stream data is reported, but I'd expect the people that look at text stream data to know that. Come up with something, put some dates on it, stick it on that SD card, and then find it on the board. I can't rule that out with these people. I'm skeptical, very skeptical of this SD card. Claire, as a barrister in the UK, I am totally gobsmacked on how this trial was conducted. It's so different to what would be allowed in the UK. Even though I work for CPS, I feel bad for defendants in the US. Well, thank you for being one of the good ones. Okay. There are good prosecutors out there. Thank you for being one of them. No, this should be beyond the pale. I don't care where you are, what country you're in. I mean, okay, I guess we got to put things in perspective. There are certain countries where, you wouldn't even get a trial. So maybe we have to be, we're better than that. But no, it's just it's been a circus. It's been a sideshow. It's been one-sided. It's been distorted. It's been unfair. It's been leaning on the scale from day one, from before day one. Absolutely shouldn't be that way. Lindsay, I missed a little. Did Bev give further instruction on the sweatshirt? I do not think that she did. I didn't catch anything where she gave any further instruction on the sweatshirt. Chop Trials. He said 13 before he read it. He said 13 and then flipped it over and read it. The clerk, did he? I didn't notice. Odin's Martyr, Cleveland Clinic, BAC over 0.40%. This is a potentially fatal blood alcohol level. You're at risk of coma and death from respiratory arrest, absence of breathing. What was Karen Reed's extrapolated BAC? Let's go. I do have that in my notes from somewhere. That was Hannah. What was her name? Hannah Knowles. Well, it's a massive range because they don't have very precise information and their assumptions are so broad. But the range that they got was 0.14 to 0.28 at 12:45 a.m. So that was, assuming. Oh God, I forgot about that Lally question. I had to put it in my notes. That Lally question, remember that one? Now, if you know how much in the elimination phase, as far as bladders are concerned, how much loss of alcohol is concerned in the elimination phase with reference to bladder loss? I forgot about that. Oh, Lally never change. So 0.14 to 0.28 was the range, the possible range. It's well below the 0.40. But it's pretty high, it's pretty high. 0.28 is really high, at least from my perspective. 0.28 is getting into, severely alcoholic to be able to have that type of BAC and not already be unconscious, vomiting, etc. Dr. Tracy with a super chat. Thank you so much, Dr. Tracy. Melissa Garcia, what did you think of Hank's AJ impression? Gross. This wasn't very good. Hank is just too much of himself. Can't get out of his own character enough. Coffee addiction with a super sticker. Thank you so much for that. D-Kit, Hank never recovered from his humiliation. He really didn't. The house of cards crumbled, he lost his way, and delivered a closing that at its core argued the defense didn't prove Karen was not guilty beyond a reasonable doubt. Just my opinion. And I think you're right. He lost his heart. Didn't have the heart once the fight got tough. Once he got rocked, he was done. He quit. Can't even put together a coherent Coherent closing argument. I mean, I got to give him, a little bit of sympathy because he had such a terrible case. He didn't have facts to build a very good argument on. But whose fault is that? Whose fault is that? Tammy Lynn, click and swipe is referring to Dr. Wolf and the Signal chat messages. Yeah, see, this is way too oblique to get, okay? Click and swipe is supposed to be about Signal. He's obsessed with Signal and nobody else is. So this reference, I sure didn't get it. Good catch, Tammy Lynn. Went right past me. Duncan, Idaho, why would an attorney not use Signal in the interest of protecting sensitive communications with their client at very least? What's the issue? At some point, it may very well be unethical to not use Signal. You have a duty to preserve the confidentiality of your communication. So if you're on notice that you're using a method that isn't secure, you're violating your duty. So at some point, you don't get to use AT&T to pick up the phone, call your client. Why? Because at some point, Project Hemisphere out there is tracking that. You know that. We've known that for decades. Well, more than a decade. There's no issue. There's not only no issue, at some point, it's going to be considered unethical not to do that. Pseudo RMRF, any guess why Bev lied about needing to read verbatim? Is she the most insufferable judge you've seen in one of these trials you covered on YouTube? Yeah, I didn't watch YSL. I heard some pretty bad things about that initial judge. I did watch some of that. It was right about a year ago now when, he was trying to throw Brian Steele in jail because the judge was having ex parte meetings in chambers with the prosecutors and somebody told Steele and Steele wouldn't tell him who told him. So he was going to throw Steele in jail for contempt. For not telling him who told him the judge was having illegal meetings in his chambers with the prosecutor. I remember that guy. That guy probably was pretty insufferable, but I just didn't watch enough of the trial to have a personal experience of it. Bev is really aggravating. Yeah, I think she might be. She might be. Judge Nickel was not awesome either, but we didn't have to watch that. We didn't watch that process as it was happening. We just got the rather insane judgment after the fact. The only reason I can think of about why she lied about needing to read it verbatim is because she wants to give that instruction, and that's her justification. She's going to say, I have to, even though it's not true. But she wants to do it the way she wants to do it. Somebody's going to push back on you about that. What's the easy way out? Well, I have to. Otherwise, you might have to give an answer. You might have to give reasons. Those reasons can be scrutinized. But she very much wanted to do it that way. She wanted to give them all of the prongs of homicide, even the ones everybody agrees not at issue. So she says, that's her excuse. They say I have to say it verbatim. They don't. Very clearly, they do not say that. To me, that just screams volumes about her comfort level with lying to the jury. She doesn't care. She herself does it. She herself did it right in front of our faces. Jen Lux, could you cover the upcoming Donna Adelson trial, please? Like I said, I'll keep an eye on it. If it's in August, good chance it'll conflict with Kohberger, and there's not going to be bandwidth to watch both, not by a long shot. But if Kohberger gets continued or something happens with her or something like that, I will keep it on the radar. I will promise to do that. Dee Marie, thank you for all your time and amazing analysis. Thank you, Dee Marie. Thank you for your support. Thanks for being here. Ghost Horse, Andrea, you are a treasure. Judge Bev is not. AJ's closing was awesome. Thank you for sharing your knowledge with us. Well, thank you. Thanks for being here with us. I'm happy to share. Happy to share what I know. I don't claim to know everything. In fact, when it comes to Massachusetts law, I know almost nothing. I have to go and look it up myself. But I know the bigger picture. I know the context. I know trials, guys. Definitely done that a few times. So more than happy to share what I know about that. Sandra, would it be easier to sue the Alberts, McCabe's, Higgins initially versus the state? I hope she ruins them. It's a different tort. It's a different tort because these guys, okay, so remember the 1983 case for violation of the civil rights applies to any person acting under color of law, whether that's state law, constitutional law, whatever. It's somebody acting with some kind of legal authority. So that'll apply to law enforcement framing her, but it's not going to apply to civilian people doing civilian things. So they have to have a different tort. And I don't necessarily know what that is. I don't know that there is one. What's the worst thing that all of them have done? Let's say they have they've lied and covered up to the grand jury. Okay, that's potential crime. But that's not a tort against Karen. That's a crime against the public and against the justice system and against the institution. So I think there's many ways. I mean, there probably are some torts. And just, the classic ones off the top of my head. They didn't beat her up. They didn't steal her property. It's more oblique than that. So just in terms of identifying a cause of action, yeah, there might be one out there. If you can find one, then maybe it's easier. But I'm just not sure it's going to be that easy to find one, because the main things we can point at and say that's wrongdoing, lying to the FBI, to the grand jury, and so forth. Karen, she's indirectly a victim of that, but she's not directly a victim of that. I don't know if that's going to be enough to raise a cause of action. So I think that's really the $1 million question. What's the claim? What can she prove? And what harm does that, what wrong does that establish that she is the victim of? Just Gold is a YouTube member now. Welcome to the channel. AC75 on 12922 34 Fairview was a crowded house. Everywhere the occupants went that night, they always took the weather with them. Thanks for your coverage. Well, it was raining men, apparently. Apparently it was raining men the whole time in there. Oh, that was that little detail that I would have loved to have come back to too, and never did. Jen's whole story of that evening. So we watched It's Raining Men. You could go back. You could look at the Celebrate report, and you could recreating her story of that night by looking at the Celebrate report and not understanding it. She didn't understand it because when Ian Whiffen testified about it, the only reason that It's Raining Men was on that report because she had opened that tab, looked at it. She had visited that site like 4 days before. She didn't visit it that night. A lot of little details there that, you can't make the case about everything. You got to give up the stuff that isn't furthering your theory of the case. But it's always been such a gold mine. So many different theories you could construct with evidence like this. Natalie VB Light Breeze. I had to stop listening to the trial. He is more a bully than anything, and Bev biased to the max. If hung again, hope they will ask to know what count. Thank you, Andrea. This trial corrupt from the start. I don't blame you. I can see how many people are watching when AJ is talking, and then Hank gets up to the stand, and you can watch people have to click off. People can't stand it. I understand. I do. It's very irritating and aggravating. So I don't blame you at all for that. Thanks for being here with us, Natalie. This trial has definitely been an uphill battle for the defense from day one. And that was by design, wasn't it? They told us Michael Proctor told us explicitly. Just going to bring some serious charges against the girl. Phil the Gilbert villain Biggs. Which is healthier, the shame at the bottom of that $5 bag of potato chips in your hand, or a $5 clever super chat just to see Andrea smile once again? Shame? I'm sorry, but there's no shame in the bottom of the bag of chips. Okay, if you are not doing the full on, shake the bag, lift it up, dump it straight into your mouth, then you're not even eating chips. It's like you're not even trying. Teresa B, if the jury marks the form by adding a not guilty line besides each guilty option and marking everything not guilty, would that be a mistrial? No, I don't think it would be a mistrial. That would be an interesting legal problem, wouldn't it? It would be an interesting legal problem because they would not be following the instruction as it was provided to them. But they do that not infrequently. They'll mess things up on the verdict form, or they'll forget to mark something, or they'll mark something that's not quite right. And then it just gets real complicated figuring out what is the effect of that. In this particular case, it seems like their intent would be pretty clear, not too hard to interpret. So I don't think it would cause a major issue. But that would be interesting if they did. Do you think that would finally send a message about this verdict form? The Incredible Shrunken Bee Guy. Andrea, can Karen Reed sue if the FBI proves collusion, evidence, tampering, and such? Well, it would just depend on what they find. Typically, evidence, creating false evidence, lying in reports, things like that are typically not going to be, cops are not going to be protected by their qualified immunity because of that type of thing. But the prosecutor and the judge are. Prosecutor and the judge, that immunity is absolute for what they do in the courthouse, in the court process. Remember reading through that outline? Lying, falsifying evidence, fabricating witness statements. Prosecutors are absolutely immune civilly for doing that type of thing under Section 1983. So she can potentially go after the law enforcement officers, but the higher ups, nope, it's not happening. Some guy with cancer. To be fair to Hank, I didn't listen to Welcher's Art Project. There wasn't much to take away, and since it didn't matter anyway, as it turned out, you missed nothing. L'enfant. Oh my God, you must see this. It's awesome. Even your fish are babies. Oh, the baby. If that was you were asking about, I forget now what it was called. Funny, and I forget. If that was the baby video, yeah, I did see that. It was pretty cute. I didn't notice that the fish were babies. That's hilarious. I'll have to see that. I didn't notice that at all. Ask freely. Do you have a Bonsai channel? I don't have a Bonsai channel. No, I don't. I occasionally put my bonsais up on Instagram. It's just kind of the place for that type of thing. I did the one video talking about the juror Ronnie interview while I was working on a bonsai. I had grand aspirations of doing more with other trees, but we got out of repotting season, and just a variety of reasons why that didn't happen. By the way, guys, just for the record, I did not end up repotting that juniper anyway, because you really struggle with marginal issues with the health of the plant with bonsai. And so we're dealing with borers. We're dealing with some scale, some juniper scale. The tree is in a little bit of a weakened condition, and going in and taking out the roots was going to make that potentially worse. So the tree is draining okay right now. Left the tree in the pot. Got to give it a systemic. Hate doing that, but I don't want the tree to die. The scale, you have to go out there and you have to, because it doesn't really respond to insecticides, and you can't use like your normal insecticidal soaps. If you guys use any of that, like for citrus scale and stuff like that, it can work really well, but you can't use it on junipers. They don't react well to soaps. So you have to be out there with a toothbrush, scrubbing the whole thing. I've been working on that in little bits and pieces, and the evenings after we're done here, let's go out, spend some time scrubbing my juniper. So at some point I might make another bonsai video. It's pruning season now. Doesn't end up with a lot to do, but we'll see. But check out Instagram if you're interested in the bonsais. That's where you're most likely to see them. Nicole Kelly, Christina Rex posted slip on X. Does the number 5 section mean DUI? It's confusing. Yeah. So we looked at it, the verdict slip. It was straight DUI is like the last lesser included. I don't think they even gave that last year. But Bev says they're getting lesser includeds. And apparently the parties have no right to stop her. So DUI is on the verdict slip. Mike Lewis. Hi, Andrea. So glad I found your channel for trial 2. Lawyer and Emily Baker are good. They're awesome. I love them both. But your insight and dedication have been great. You've inspired me to see the law in a new light. Thank you, and free Karen Reed. Well, thank you so much, Mike. I'm glad you found the channel too. Guys, there's lots of good commentators out there. There's a lot of people with great insights and different perspectives that they bring. I love that Emily is a former prosecutor and that she brings that perspective. I love that Peter Tragos is, practicing trial lawyer. He's got his dad who's been at it for, a long time with all of their different insights about how this stuff works. They've seen dirty cops. Okay. Many, many times. It's a good thing. I love that we have Melanie Little, who knows this case front, back, center, every angle, every fact. She's been on it from the very beginning. There's so much good commentary, and it's one of the things I love about LawTube is that my personal perspective is that it's great that it doesn't have to be a competition. It really doesn't. Everybody has their own talent, I guess, that they bring, and people that will resonate with people or it won't. And everybody kind of finds where they land, and you don't even have to stick somewhere. We're done. Go check out Lawyer go check out Emily. They have great insights. I love to do that when I get the chance to do it. Just don't get as much time to do it when we're actually in trial. But I rely on them for the stuff I'm not watching for sure. El Fett allegedly is the baby AI videos you were recently featured. Yeah, thanks for. I didn't recognize who the creator was, but I did see some folks tagged me in some clips from that. That is a much cuter baby than I was in person. I can guarantee you that. Josh M. Today has one of those last day of school feelings to it. School's out. No more pencils. Thanks for the coverage to numb those soul-crushing workdays. It is a little bit of a last day of school, isn't it? Because we're at the end, and now it's just the wait. We may or may not get questions. We may or may not get a verdict. Whatever we get, it's going to be short. It's going to be sweet. It's not going to be the extended detail that we got over the last several weeks. So there is always a little bit of a feeling of something big coming to an end. But guys, the end of one thing is the beginning of another. It's just a transition. Transitions can be uncomfortable. Change can be uncomfortable. But it's not a bad thing to finish the one thing, close the book, put it aside. That's why I had to get out of civil litigation, honestly, because the cases go on forever. You really never get a chance to close the book and put it aside. Criminal case, you try it, you get your outcome, you're done. You go home, close the file. Don't have to think about it again. Well, I'm glad that you were here with us, Josh. Nicole Kelly, Dr. Adelson was my family dentist. That's how I got into true crime. So crazy. That is a small world. Wow. That is a small world. Well, we'd love to know your take on Dr. Adelson. What kind of dentist was he? What was that like? We all want to know. Miriam, girl, I am 5+ hours behind. That's okay. You can watch me at the high speed. I do speak kind of slow. I understand that. Speed it up. It'll be fine. You'll catch up in no time. Natalie VB Lightbreeze, are still an active lawyer or are you retired? Guys, I just got a ruling this week on, pretty sure this is my very last case that is still open. Pretty sure my very last case that is still open. The state had petitioned for review. It got denied. And that should be it. So I am at this point, I consider myself semi-retired. I do not have an active legal practice right now. It took 2 years. Took 2 years from going out of contract with the state public defender who does the appeals in the state to actually be done being a lawyer. So I'm going to take some time and not be a lawyer for a little bit and just see what comes next. It's been wonderful to have this serendipity, this YouTube that kind of fell in my lap. I really didn't look for it. Wasn't real inclined to do it. But then Isaac Baruch went and was the best witness anybody has ever seen and had that stellar cross. And I just couldn't help it. Had to make those videos. And now here I am. So, but I don't have any permanent plans as far as never going to work as a lawyer again, like nothing like that. Just taking a little break from the grind. It does get to be a grind, guys, and it can really wear you down. So I'm just fortunate to be in a place where I have the opportunity to step away for a little bit and consider some options for the next step. It's one of the reasons why I advise everybody who's thinking about law school, guys, minimize your debt. That will maximize your options. You don't have to worry about, enduring the job that you hate because you have to have the paycheck. Oh, it's much easier to not have that stress. Bird, I sure have enjoyed your coverage and astute commentary. Sometimes replay. Thank you. Well, thank you, Bird. It's a nice thing to say. We're not done. We're not done. We still got a bow to wrap on the end of this trial once we find out. Hey, we thought last time we were going to be done. A year ago, we thought we were at the end of the road, and here we are, still not at the end of the road. Now, I hope we don't get that again here, but we may potentially have a little bit more in this case, but there will also be other cases out there, so do feel free to come back. Phil the Gilbert Villain Biggs, as a native of the common wretch of Massachusetts, it wasn't always like this, but lo and behold, it sure is commonplace now. Places are funny with their culture, huh? And just because I don't know. I'll tell you the only real culture. Obviously, I've heard of the mass holes, but don't have really experience with that myself. I think I mentioned I spent like a week in Massachusetts, maybe when I was in college. A few days in Boston, and all I really, remember from that is just that it's not a place I would ever want to try to drive anywhere. Like, you can't find anything. The roads don't go where they're supposed to go. It's very confusing looking place to drive. And then over on the western Massachusetts, over there in Williams, over there near Williams College, it's just a completely different vibe. That's my only personal experience with Massachusetts. So I've heard of mass holes culturally, but it's like not anything I can, it just seems like a joke. The only thing culturally I really know about Massachusetts is that it's got a nickname among lawyers. They call it Passachusetts. Apparently the bar is like super easy to pass in Massachusetts. But it's interesting to get other people's takes on where you are in your culture and stuff like that, because you're the one who would know. I sure wouldn't know, and it's sad that stuff like this would be commonplace. It certainly shouldn't be. Mike from Providence, it's unexplainable that the judge wouldn't want the clearest possible jury instructions unless she has an ulterior motive. Yeah, the ulterior motive is definitely an explanation, but I really am starting to wonder if she just has the emotional maturity of a toddler. And it really is just, you're not going to tell me what to do. I order people around here. I make the decisions. I. She's just so high on her authority. She just won't be told. I don't wonder. Tom D911, it broke my heart seeing what Delphi did to you. Please stream from home. Oh, you're too kind. You're too kind. It wasn't really that bad. It was, not from like the physical standpoint or anything. It was a little bit of an endurance. I lost some weight. It's okay. It's fine. I'll put it right back on. That was not a problem. It was mostly, the impact from Delphi was it's the emotional, it's the emotional. It's hard to see stuff like that. It's hard to see injustice like that right in front of your face, knowing it's happening, can't do anything about it. It's like watching the train barrel over the edge of the cliff. That was the hard thing about it. And I think even if the trial had been streamed, then we just all would have experienced that from our homes. But I will take your feedback into account, Tom. Thank you for that. It's a very, very sweet thing to say. I really was okay, but I did need some time. Oh, now, Andrea, this space, live stream, and chat has been a source of life, humanity, and not feeling alone. You may never know the impact. Thank you. What a kind thing to say. I love hearing stuff like this because everybody wants to do something meaningful. Everybody wants to have an impact. Maybe it's a silly thing to say, but if you're a well-intentioned person, you want to leave some good in the world. And it's easy to look at YouTube and think it's YouTube. It's so trivial. It's such a silly thing, And so it just means a lot to me that it means a lot to you guys to be a part of it too. So I do appreciate comments like that. Sati, Karen and lawyers back to the courthouse from Dedham, letting the jury go home. Adri, 1984, you do great work, Andrea, are also hilarious. Well, thank you. Thank you. Probably unintentionally sometimes. Gia Precio, thank you for your professionalism and insightful commentary. Thanks for being here for it, and thanks for your support. Amelia Walsh, defense is back in the courthouse. They were called back so that the jury could be released. All of that, all communications with the jury have to be done in the presence of the attorneys. So, and Karen Reed has a right to be present too. So that's why they are called back to let the jury go home. Kimberly Fisher, some are saying jury has a question. Nope, as it turns out. Andrea, apparently lawyers are going back to court. What's happening? The jury is going home early. She had suggested 5:30. Jury said, nope, 4:30 will do it for us. Thanks. You brought us here early, and then we sat around for an extra hour and 15. Respectfully, we'll decline your invitation to also stay late tonight. Ick voice. So many times hearing you mention watering your trees, I started to imagine you were living on a cherry tree plantation on the Columbia River. Somehow I missed the part about the bonsai until today. Yeah, I've got the orchard too. I do. I mean, small, not big orchard. My little small backyard orchard. I got the big trees too, but the garden takes care of those. The bonsais, they dry out very quickly in the pot, and so they need a lot of attention. Said before, they are the most demanding pets I have ever owned. We get into the hot season, we got to be checking them 3, 4, 5 times a day, because if they need water, and they need it when they need it. And you better be prepared to give it to them. Sati, courthouse doors just closed. Nicole Marie, parties headed back to the courthouse. I know, we all wanted a verdict, but it was not to be. Adriana B, custom furniture and home decor, 12 minutes into Jackson's closing and in tears already. He's so strong in his words, attitude, and overall presence. I'm not excited to hear Brennan. I'll tell you what stood out a lot between the both of them to me was just looking at the very beginning of their openings and the demeanor and the presentation that they had. The energy that they brought to that very first part of their openings, You could see confidence and righteousness on AJ. You can see he believes what he's saying. He'll say it loud. He'll say it clearly. He'll look you in the eye while he's saying it. Hank did not have that. Hank had to wander around. His eyes are kind of looking around. He doesn't know where to look. And all he comes up with is John is 46. Like he can barely even talk about the facts that don't matter. And it took him quite a long time to get into his stride. And I just think that speaks a lot, because even if the jurors don't consciously sit here and think, oh, I'm going to compare the tone of the two lawyers, you're going to notice that. And you're going to tell. It's one of the things juries can tell, is who believes what they're telling us and who doesn't. That's why you got to have a theory of the case that you can believe in, because if you don't, the jury is going to smell it on you. They're going to know. They can read inauthenticity really easily. So I thought that was a very distinct difference between them. I thought that AJ, regardless of whether you think he's right or wrong, I think he comes off as very much believing what he says. He's very sincere. He's not trying to sell you something that even he doesn't believe. Michelle, if the weather is good tomorrow, my husband is going to do something pretty cool for the Army's 250th anniversary parade tomorrow. That's cool. A reminder of how people from all walks of life agree with you. Well, I'll be praying for good weather. I didn't realize it was the 250th anniversary of the Army tomorrow. I had no idea. I wonder if there's a parade in my town here. Yeah, that's one of the things that I love about this channel. It's really why I try to stay away from politics and stuff like that, religion, the stuff that divides us for not really any good reason. Because we all share a distaste for injustice, regardless of who you vote for or who you pray to. And so we can all look at a situation like this, and we can find common ground with each other. And that's one of the things that I particularly like about this group. Stacy LeBruno, once again, my bingo card did not include a critical phrase, buffalo on a prairie. For fuck's sake. Thank you, Andrea, for your excellent coverage of this crazy trial. I didn't do a bingo card for closing. That might have been fun. A closing bingo card. I might have done the hump like a buffalo on the prairie. I mean, he did play that clip for a reason, right? It wasn't just Proctor that was dehumanizing people. Look at her, calling him a buffalo. No, Hank. Just saying that's what it looked like. Prime Finder, are you planning to follow up live stream when the sidebar transcripts are available? Curious how bad the micromanagement and bias really was. Thanks. Well, that is definitely an idea. I hadn't planned it because I don't know when or if or how these are going to become available. I don't plan on going and running to be the first person to buy them myself. But if they get acquired and they're out there, I will more than likely take a look. Yeah. And that could be a good subject of a live stream to go over those. So I'll keep my eyes open. Nasir Puto, if mistrial happens again, what I think will happen, do you see Jackson and Alessi come back pro bono again? Yeah. I mean, it's tough. It's a tough thing to do financially, to make that work. But they've already committed to it. They're already in this far. Are they going to do it again? Are they going to just drop her because it's the third time? I don't think they're going to do that. Yeah, I think they probably would. Carolyn Smith, she chose the foreperson before choosing the alternates, so she definitely wanted that person, or is that usual? That is apparently the normal way that they do it in Massachusetts. It's the same way they did it last year. It was very confusing. Because we're like, how are you not, you're picking alternates, but how do you know the foreperson isn't one? They did it the same way. And it turns out that's kind of what the statute sort of says. So Dr. Laposada's clapbacks, MEG. Andrea, you're looking gorgeous today. Oh, you're too kind. Way too kind. It's been an early morning, so I'm just proud I managed to get the makeup on in the right places at all. Melissa M, could they have argued a blank form equals not guilty? Probably not. If there's a space to fill it out to say not guilty. Generally, the blank form means no unanimous agreement. It means hung if we don't fill it out. The verdict too is the weird one. There's just potentially a lot of ways they could fill out that form that would be weird. So we don't know. We'll just have to see what they do with it. But in that particular one, it would not be a blank form equals not guilty. It would mean hung because there is that place to indicate not guilty of everything. So it's either not guilty of everything, guilty of something, or hung on all of it. That's really their only options. They don't get to partially hang under this verdict form. Daniela is a new member. Welcome to the channel, Daniela. Chopped trials. From a business standpoint, there's going to be lots of tubers streaming the trial. You being in court gives us law tubers another perspective, so it makes more business sense for you to be there. I mean, I guess, if I'm thinking about the market and what's the demand, where's the supply, limited supply of, courtroom and all that type of thing. It's really not my perspective because I don't want a business. It's not my goal. I want to have fun watching trials and for it to be something that is mutually beneficial and enjoyable for all of us. But I think that the takeaway here is just that if that is information that I can get, that it would be hard to get otherwise, then I should go get it. That will be valuable. Business aside, it's valuable. It would be good business because it would be valuable. If it's not valuable, it wouldn't be good business. So if it's valuable to me, that is what errs on the side. That's what's got me leaning towards go ahead and just suck it up and go and do some nightly recaps or something like that. Katie Cat, could jury just be leaving early to digest and rest? Is this more favorable to one side than the other? No, I don't think so. I don't think we can really say anything at this point. They were back there for what, like an hour? There's no way they can look through all the evidence, in an hour. So if they're going to have to come back Monday, they're just, let's go have our weekend now. I don't think there's anything to read into it. George Haywood, it's peculiar that John had been drinking beer from bottles as shown in video, yet he has bar glass in his nose. Thank you for all your time, Andrea. It all goes to that, that cup that was there, the tumbler that was there, and then the Karen Reed, her interview where she said he got out of he took the vodka soda that he had bought her at the waterfall, and she didn't drink it, and he took it because apparently it's like you can't have it and not drink it. It's like a waste of money. It's like your Depression era grandparents who always tell you, you have to clean your plate because starving kids in Africa. It seems like that kind of attitude. There's alcohol that's undrunk, so you have to take it with you. That seems to be, the source of the glass in his nose. I don't know. To me, the thing that still makes the most sense is that the glass got dropped. If the glass is dropped and the glass is shattered, that explains why you only have some of the glass and not all of it out here in the yard, in the street. And it also explains how you'd potentially end up with a little piece in your nose. If it shatters, you get a little ricochet. Woodham, do we know who the jury foreman is? He was the middle-aged black man who took no notes throughout the entire trial. As far as I know, that is really all that we know about him. Jess Machado also has some notes about him. She just said juror 1 who did not take any notes has been chosen as the foreman. It's the same seat as from trial 1, the foreman selected in that case. And that is my recollection as well. Little Rusty Potato, I'm catching up. Hank is tanking. He reminds me of a middle schooler acting in a play with his oversized suit and theatrics, just obnoxious. He's acting like a middle schooler trying to do improv. I mean, he's all over. He's just all over. He can't follow a line to its logical conclusion because it doesn't have one. He doesn't have a story for any of this. So it's just jumping all over between this scattershot, this fact and that fact, and signal, and they called us liars, but Dr. Russell's a liar. I mean, it's just it's wild. It's very wild to watch. Mabilis. Andrea is awesome. It appears Bev compromised on the curative instruction by allowing AJ to argue HB's misconduct, or he just did it. He just did it and it didn't get objected to. Could be that. I wish he could also argue the judge's complicity in covering up the deception. Yeah. Yeah, it's true that everybody should be outraged that that happened. And the only people that care is the defense. They're the only ones that care. Nobody else in that courtroom cared at all. Would be nice, but yeah, that won't happen. Ariane, the vegetarian. I was an ugly kid. Husband said I was the ugly. I feel you, girl. I feel you. Ugly kids. Ugly kids unite. I was really a hideous baby. Hideous. Look at those pictures of myself. I'm like, ah. Nasir. Yes, that YSL judge was terrible. I just remember that one part. How do you throw, seriously, how do you throw the defense lawyer in jail? How do you throw the defense lawyer in jail for outing you for being unethical? It didn't take long to remove him after that, did it? Seemed like the new judge was better, but Judge Whitaker, I think her name was. But I didn't watch enough to be able to know. Ian Thomas, Bev talking down her nose and no stipulation for objections was so infuriating. She does, even to the jury. She does always talk down her nose. I did notice that too. It's just an odd habit to have. I don't know. I mean, I'm tall. I kind of look down on people anyway. I don't think I'm ever like jutting my chin out, talking down my nose. Maybe I am. I don't know. But it does just seem a little bit obnoxious. Nasir, YSL judge called his chambers sacrosanct. Yeah, he's got to break all his laws back there. Where else is he going to do it? Out in the open where you can see him? Called his chambers sacrosanct. That's not how any of this works. That is not how any of this works. Nobody is breaking the law by outing your illegal, improper, unethical backdoor meetings with the prosecutor. Oh, and the witness, I forget, there were so many details with that. It was the witness who lied and told him he was going to lie, and they went back into chambers and like talked about how he was going to lie. I don't even remember the details. The whole thing was so freaking horrifying. The whole thing was horrifying. God, I forgot about that. I forgot there was a witness involved in all that too. Ugh. Mabilis, by not changing the verdict form, Bev finally gets to save time at the end of trial when the not guilty verdicts are read. Yeah, that would be a lot of not guilties. That's true. That's true. That's a good observation. And if there's one thing we know Bev doesn't want to do, as she announced at the end of the day today, it's work. It's work. Way to tell on herself. The one thing to celebrate, not working. It's okay. It's okay. We saw you barely doing it as it was. So go take your weekend off, Judge. You clearly need it. Phil the Gilbert Villain Biggs. Shameless is cutting the bag to get to the corners. Cutting the bag to get to the corners. Afix, if you respect the people you talk with, or like that little lock on a website, Use Signal to talk with them, not Telegram, not WhatsApp, not Snapchat. I mean, Signal is the new thing. It's the new wave. I think the bottom line is don't use SMS. Don't use SMS. I use WhatsApp. If I'm going to use something, I use WhatsApp, but that's mainly because WhatsApp is like the international, kind of the international app. When I was down in Chile, you can't use SMS. It doesn't work. It doesn't work on their system down there for whatever reason. You can't just SMS text the US. You just use WhatsApp, and it works great. You can video call and all that kind of stuff. But literally no reason to use anything non-encrypted. Mavka, you'd understand Bev's rulings if you understood Cantonese. Maybe. Maybe it would all make sense to me if I was one of these insiders from Canton. I would probably understand the logic then. Love ya. Thank you for filling my work days. Well, thanks for sharing them with us here. Glad you could join us. L'Enfant. Oh my God. If Jen M didn't watch Raining Men that night, that means that girl lied about, we were laughing about the song in the car, so I didn't see Karen Reed's car, which means she also had the timeline. Did they talk about laughing about the song in the car? They were laughing about the peanut butter. They were laughing about the peanut butter and the bread. That was like the hilarious joke for some reason. Having bread in your car is like the hilarious joke that they were all so busy laughing at that nobody looked out the window and saw John 10 feet away on the grass. But yeah, I mean, Ian Whiffin's own data showed the last time that site had been visited, It's Raining Men on YouTube, was like 4 days before. So whatever else they were doing in the car, in the kitchen, whatever, on the night of 28th, early morning hours, the 29th, they were not watching It's Raining Men on Jen McCabe's cell phone. Phil the Gilbert Villain Biggs, $5 for the Frito-Lay snack wares, or 32 teeth and an exceptional jawbone. Save the crumbs to dump in your chicken tofu soup. Yum. They get mushy though. Now I'm totally down with the potato chip garnish. Okay, guys, the peanut butter sandwich with some jelly, some nice sweet jam. I love me a good apricot jam, but guys, sprinkle the potato chip crumbs on there. You won't regret it. You won't regret it. Just put them right there in there on that sandwich. Oh, it's phenomenal. Who needs croutons in your salad when you can use old potato chip crumbs? Guys, is there anything that potato chip crumbs can't do? Is there anything they can't do? How she grows. No question, but thank you for your incredible coverage on the cases you cover. You enlighten my noggin and routinely shift my perspective. Well, thank you so much for that wonderful comment. It's so encouraging from you guys. You know, anytime I start thinking, oh, you know, maybe I'll stop. Yeah, no. We'll keep coming back. We'll keep watching trials. It just means a lot that so many of you are getting so much from it. It's so important to understand our system. It shouldn't be opaque. It shouldn't be something that you need, 3 years of specialized education and then a career to be able to understand. This is our government, our courts. So anything that I can do to help folks understand how it's all working a little bit better, I am more than happy to do. Voir Noir, it is now 2:46 p.m. on the West Coast. It's 3:12 now. And I've been up with Andrea since 5:30, but she still looks amazing. Well, I need a nap. Have a great weekend, FKR fam. Well, you're too kind. Guys, it's the lights. Okay. I'm just here to tell you, I got great lights. Photography. I was way into photography when I was younger. Okay. I got lights. I could make a corpse. I could make a corpse look like a supermodel with these lights. Okay. Just take my word for it. Jesus freak, try beneficial insects on your scale problem. I would love to try beneficial insects on the scale problem. And in general, I do like to do stuff like that. The problem is it can take too long. because we're dealing with very, very thin margins in the pot. The way the beneficial insects typically work, you have your environment. You get, say this year it's a very wet spring. We see this all the time. It's a very wet spring, so we have lots of aphids, and so then the aphids, they are like sucking on the trees. They are, producing sap. It's a big mess. It's very damaging. So what happens? We get more ladybugs. More ladybugs show up and start eating the aphids. More katydids show up and start eating the aphids. Now we don't have as many aphids, but we have more ladybugs. It just takes time for that transition to happen. And in the pot, we don't necessarily have the luxury of time to sit and wait. Because a little bit of damage can have pretty extreme effects. But in general, yes, I love beneficial insects. There's a wasp, I believe. It might be a braconid wasp. I can't remember now. Not the kind that will like come sting you or anything like that. Even yellow jackets are technically beneficial insects, which like I hate to think about because I hate yellow jackets. But paper wasps, but they are technically beneficial insects. But there's a lot of wasps that are like, you might not even be visible to the bare eye. There are a lot of the beneficial insects. They eat grubs and things like that. So yeah, there are some things out there. Definitely interested in pursuing that, but unfortunately, the problem that we have right now, it's going to have to be dealt with a little bit more directly and quickly, and then we'll just work on trying to incorporate them, trying to bring them into the environment, have the things that support them. This is why, part of the reason why, talked about, I don't like spraying the trees. I don't spray my fruit trees. I don't grow the kind of fruit that you need to spray. The exception to that is apples, and I don't spray my apples. I bag them, except I am way behind on that this year too. And that's a big reason why those sprays very, very bad for the beneficial insects. I don't like using the systemics. The best working ones are the neonics. The neonics, very bad for beneficial insects. They get in the pollen of the plant, and then anything that comes along and eats the pollen, you're creating a problem. So I hate doing that type of stuff. I would definitely prefer to have a good, healthy biological environment. So Jesus freak, I will keep working on it, I assure you. Whatever clever. Did court give instruction regarding consent to return verdicts on the charges they have agreed upon? Nope, nothing that we heard about a partial verdict. It was all. Once you've done it all, let me know. As a fellow estelophile, I do love the Pilot Frixion Gel Fine and TUL Gel Needlepoint. Well, let me just write them down. Pilot. I think the Pilot Frixion Gel might be the one that Jeff uses. I know he used a Pilot pen for a long time. It was very controversial in the office because if we found a Pilot pen in mine or a Uniball in Jeff's, we knew that there was, as Emily would say, there was some fuckery afoot. But I haven't heard of the Tool Gel Needlepoint. Putting it on my list. Check that one out. I will tell you, I don't normally like a fine point pen. I like a bold. I like a lot of ink. I like it easy to come out and write. I hate when it makes the scratching noise. I can't stand scratching noise on the paper. Ugh. Makes the hair on the back of my neck stand up. I'll keep an eye out for your pens and give them a shot. Thanks for the suggestions. Phil the Gilbert Villain Biggs. Finally, the genius. My youngest starts UPenn Wharton in August. Congratulations to your youngest. Being poor and relentless in studies worked for him. Work is like 99% of it. Go Mason, 5 years master's program. Go Mason. I'm telling you, work and just being willing to work. It would be wonderful to be born with just all kinds of natural talent. Guys, it's the thing you see in sports all the time. We see it in boxing all the time. All the time. You'll see kids that come in and they've got just amazing natural talent. They're quick. They got good reflexes. They can see what's happening. They've got great coordination. They got great balance. They have all these natural skills, but they don't want to work. They don't want to work because it's hard and it hurts. God, it's like the most painful thing to work, to do that cardio that's like at your, your 10,000 RPM level. And that's what you got to do to train for boxing. You got to work as hard as you can possibly work until you just want to die. And then you got to do it again, and you got to do it again. And that's the only way you get better. And a lot of people, guys, they don't want to do that. A lot of kids come in with all kinds of natural talent and they don't want to do that. And then you'll have kids that come in and their only natural talent is they are willing to do that. They will put in that work. And those kids are the ones that will last. Those kids are the ones that will last because you can develop skills. You can develop skills. You can train a lot of that. Maybe you'll never be elite if you don't have elite reflexes, elite speed. But you can do pretty good just on work. So good for your son. Good for Mason. Go Mason. Congratulations. Best of luck to you. No nude so far. Will you be live streaming Kohberger? We are still working out the details on that. I will be covering Kohberger one way or another, but whether I am going to sit in the courtroom and then recap or whether I'm going to watch it from live stream, I haven't made a final decision yet. Still thinking about the pluses and minuses. Deanna, hello. I just started following this case. Are you the attorney on the case? I am not. I have nothing to do with this case. I am just an attorney from another state. I'm a criminal defense lawyer. I did trials for almost 20 years. Well, I did trials. Technically, I guess I did trials for like 10 to 15. Did appeals towards the end of my trial, but criminal defense for 10 to 20 years. So I am just providing my insights from that experience. Nikki Kadia, is it weird I talk back to the screen at you? Jen Gooney X here. So we have the same references. I too could not get through Tommy Knockers either. Thank you. It wasn't just me. I'm so glad it wasn't just me. What a stupid book. God, does anybody like that book? It was awful. Only book. Well, now no longer. It's no longer the only book I never finished, but it was definitely the first one, and that's why it still stands out in my mind because I was in high school. Like it was hard to not finish the book, to make myself be like, Andrea, you don't have to do this. It's okay. You don't have to waste the time and attention. I'm glad you talk at the screen, girl. Gen X, we are on the same page. GSUPM, will you please put a list of all your favorite pens, brands, and list on Substack or in the description of your videos? I will. I'll be happy to do that. Definitely right here, this Sharpie S Gel. Love this pen. Such a great pen. So glad I found it over there during Delphi. I'll give you a whole rundown. In fact, I can even I can tell you the ones I don't like too. I can tell you some of those. That standard Bic ballpoint pen. God, I hate that thing. That thing should just die a painful death. Alley Cat, would a juror ever turn in another juror if they suspect they are a ringer or if they suspect they've done outside research? Oh, absolutely. And they do it all the time. In fact, most of the time when you find out about this stuff happening, that's why. It's because the juror has told on him, has outed him. And that's why it's so hard to fix a jury. That's why all these different cases that we've watched, lots of times there's been concerns about fixing a jury. I remember in Depp v. Heard because of Elon Musk's collateral involvement in all of that. A lot of concern that what if Elon Musk could just bribe one of the jurors, give him a wallet with some Bitcoin and nobody would ever know, and there would be no record and stuff like that, and he could buy the jury. The problem is you'd have to buy the whole jury for that to work. And if you don't buy the whole jury, then anybody else on the jury finds out, they don't have the incentive to keep it quiet. So they tell all the time. We saw it during the first trial. That jurors got booted because of their conduct as it was reported by other jurors. So yeah, this you can count on. It's a prisoner's dilemma problem. Everybody on the jury has taken an oath. If they break their oath and they make you complicit in breaking their oath because you know about it and you participate in it, Well, now you're at risk if it gets found out. So they have the incentive to not participate and to go ahead and tell, because you don't know if somebody else is going to. So yes, that does happen routinely. Truth and transparency. Andrea 24, TNT 23. Results are in on the pick'em. I got 24. Yay. Thanks, Lana. Oh, you're gonna have to send it to me so I can see which ones I got. The over under. Yeah. That was a fun game that Lana did. I forgot about it. Boy, man, it's been a long time, hasn't it? Since we did that over under pick'em. I can't wait to see. Thanks, Lana. CG Karis. Thanks, Andrea Superb. Thank you for being here with us. James Casatelli, here's a couple schmeckles for Jeff for keeping the one-liners coming in the chat. He's a clever one, that husband, isn't he? He's a very clever one. He's got some good one-liners. You know, if there's any person who can beat me to the punch on a good your mom or that's what she said, it's going to be Jeff right there. Guys, it's all down to the weight now. It's just all down to the weight. Nothing's going to happen over the weekend, so you can just relax. You can just relax. You can put it out of your mind. Nothing that happens this weekend is going to change the outcome one way or the other. Don't have to worry about anything at all until Monday. So Monday we'll be watching. I am not planning to go live on Monday, like first thing. I'm not going to, just sit online and go live because we have no idea if anything will happen. So my tentative plan at this point, I'm going to double check when the Koberger hearing is, because I've been thinking this whole time it's Monday, but I guess maybe it's Wednesday. So I'll verify that. That will be important. If it's Monday, I'll be watching it Monday. But if it's not, I'll be watching it Wednesday. Otherwise, my plan is I'm just going to wait until there's news. I'm going to be ready. I'm going to be paying attention. And if it looks like things are happening, we'll go ahead and go on and talk about it. Maybe it will be a verdict. Maybe we'll get a question. Maybe there will be nothing at all. Sometimes it's nothing at all. Guys, my last trial, the jury was out. They were out for 5 days. Not a single question the whole time. It was excruciating. Had no idea what was going on, why it was taking so long. So sometimes it happens. You just don't know. So we're not going to sit here and stream, just to stream if nothing is happening, but I will be paying attention. And so as soon as I get word that anything is going on, I will be here and we will watch it and we will talk about it. We'll see what it is and we'll react accordingly. Maybe we will mourn, maybe we will celebrate. But for now, guys, there's a whole weekend to celebrate. A whole weekend. It's summer. What do you guys got on the docket? I think I might get back out on that paddleboard. My goal this year is to train the dog how to ride the paddleboard with me. I think she would enjoy that. I think she'd have fun with that. But it's gonna take a little bit of work. Gonna have to get that figured out. As soon as she jumps off, she's gonna send me flying. That's okay. It just takes practice. So maybe we'll do some of that. What else, guys? The trees don't really need anything right now. Maybe the one elm needs a little bit of pruning. The plants have very different patterns of growth. Some of them really only put on growth in the spring and then just sort of hang out all year. And that's really what you get. The larches are really like that. The hornbeam really just has one good, strong flush of growth, and that's pretty much it. But then you got the maples, the Japanese maples, you got the elm, the Chinese elms. They are just constantly putting out growth. If you're looking for a good, easy, well, I don't want to say easy. If you're looking for a good beginner bonsai, a temperate one, not a tropical, a good temperate bonsai, which means leave it outside in the winter. It lives outside. Chinese elm is a really good one because it just lets you get your hands in it a lot. It's constantly growing. I don't want to say it's easy because it does have some characteristics that can make it a little bit challenging. It's a early succession tree, which means it tends to grow very fast, which means that it does not really prioritize hanging on to all of its wood. It's very happy to shed wood. And so that means you can have spent a lot of time like crafting this beautiful, perfectly shaped branch. And then you prune it a little too hard. And the tree decides, we're done with that branch now. We'll just drop that one. We'll go ahead and focus our energy into these other parts of the tree. So the Chinese elm can be a little bit challenging for that kind of thing. But if you want something that will just grow and grow and grow and you can cut on, it's a great choice. Same with the Japanese maple. They will just grow and grow and grow. Japanese maples are great, super hardy. Yeah. They grow, you cut, they grow, you cut, they grow, you cut. And that's the pattern. That's what you're doing with it. So maybe some work on the bone size. Oh, I can catch up. Catch up on those apples that need bagged. Oh. Probably up back there getting wormy as we speak. We're just about ready to harvest apricots. Not quite yet, but it will be soon. We'll probably start next week. Have the bulk of them over the next 2 weeks or so. Gonna have a lot of apricots this year, a lot of jam to make because I didn't finish my thinning. So my fruit quality is not great. So they're not necessarily like the little beauties that you eat fresh, show off, put on desserts, things like that. No, they're a little uglier. So we'll make some jam. But who doesn't love apricot jam? Some little potato chip sprinkles on there, guys. I'm telling you. It's amazing. Really good stuff. Delicious. Oh, getting a little drooly just thinking about it. And so with that, guys, probably time for me to go find some potato chip crumbs. It's been a day. It's been a few minutes here. But I am again so grateful to have all of you guys here for this journey. Really appreciate all your feedback. It is very encouraging. If I worry that this YouTube stuff, it's just kind of trivial and unimportant. You guys have set my mind right that actually this does matter. It does matter, and it is making a difference for people trying to understand the system and make sense out of it. And that's really my main goal here. So grateful to have all of you, grateful to have the mods and everything that you do to contribute, help out, keep things running smoothly, get us the information, the links, all kinds of good stuff. Really appreciate the mods and everything they do, and appreciate all of you, your comments, your contributions. Always do. Appreciate your attitude. And the attitude on this chat, I didn't make that. You guys made that. You guys brought that and created it. And it's such an awesome thing to see and to get to hang out with. It's a real privilege. So time to go enjoy our weekends, guys. And we'll be back maybe Monday. We'll see what happens. But we'll be ready to come back as soon as there is any kind of news that anything's happening in the courtroom we need to pay attention to. So, guys, do take care of yourselves. Enjoy your weekends. It is a little bit of the end of school, but, remember how we celebrated that when we were kids? We're very close to the end of this, and hopefully going to be real close to that kind of celebration as well. So, fingers crossed it comes soon. Thank you, everybody. Appreciate all of you. And we'll look forward to seeing you next time.